I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases. District Court for County, Washington, State of Michigan is now in session. All those court drawn near. The Honorable Judge J. Cedric preside. You may be seated.
Yes, go ahead.
Good morning, Your Honor. And on behalf of the people, Your Honor, the people would waive any potential conflict between the Office of the Public Defender. While the people don't believe such a conflict exists, the people make this wish for avoidance of all doubt.
Good morning, Your Honor. Rob Buckring on behalf of our client, Ms. Jaleesa McDowell. We join in prosecutor's motion.
The court, for its part, also does not believe that conflict exists, either in the court rules or the case is decided thereon. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the people versus Jaleesa McDowell.
Allie Zend on behalf of the people, Your Honor.
Rob Buckring on behalf of Ms. McDowell.
Ms. McDowell, can you state your name, please?
Jaleesa McDowell.
All right, this is the people's motion.
Thank you, Your Honor. Your Honor, at this time, the people would request the court set a bond of $50,000 cash surety. I'm aware it's already set. In this case, the people originally requested a $100,000 cash surety bond, and the magistrate granted a personal recognizance bond at the arraignment. This case stems from a 911 call from the victim's friend after she received a text from the victim saying that her mother had stabbed her and that she was scared to call 911 because the defendant had been threatening to kill her if she heard sirens. When officers arrived, they spoke with the victim, who informed them that she and her mother had gotten into an argument. And from that argument, the defendant grabbed a butter knife and stabbed a wall in the house and then stabbed the victim's hand. After stabbing the victim's hand, the defendant then forced her into the bathroom and yelled at her to take off her clothes and get in the tub. The victim refused, and this caused the defendant to then grab her around her throat, shove her into a wall, which caused her head to hit the wall. The victim informed officers that she was extremely afraid of her mother and fears that her mother will kill her. And the people have extreme concerns given this case and the fact that the victim had to go to the hospital for that stab wound that required stitches. We have extreme concerns for the victim's safety as well as the community's. This defendant also has another case that was recently charged, I believe was arraigned on Friday for an MDOP against her boyfriend. That case stems from incident in March of this year where the defendant chased her ex-boyfriend in a car and was throwing rocks at his car while it was driving down the road, resulting in damage to the vehicle. So at this time, the people would ask that the court set the bond at $50,000 cash surety in the GBHFA case and believe that the personal recognizance bond was an abuse of discretion, Your Honor.
Thank you.
Your Honor, I've had the opportunity to meet with my client prior to today's hearing. I wasn't present at the arraignment, so I don't know what facts were argued by the prosecutor's office. The only thing new that I'm hearing since the bond was set at personal recognizance by the magistrate on June 12th is the authorization of the malicious destruction of property charge, a 1-year misdemeanor, which my information is involved rock throwing. It did not involve the complaining witness, her 15-year-old daughter. It was a separate incident in March. So I don't know what information is new that is being presented to this background. My client has 2 children that are in the household, a 12 and a 13-year-old who are currently, and I stretch to say unsupervised, but I think they're in the care of neighbors and friends, and they need structure as school is out right now. My client is gainfully employed at the mobile gas station at Haggerty Road and I-94, where she's a supervisor. Also, when she was arrested, her home was not secured, and her home right now, as I understand it, is unlocked, and people are helping themselves to the contents of her home. She lives at 1243 Stamford Court in Ypsilanti, 48198, and it's my information that the prosecution has not been provided or has any jail calls where my client has made any contact or had any contact whatsoever with the complaining witness. And as the court's well aware, had they been armed with this information that my client was attempting to reach out to her 15-year-old daughter, they would have presented to the court. So boiling this all down, we have no new information other than the rock throwing incident, which occurred in March. I'd ask the court to consider a $5,000, 10% bond. The prosecutor, I believe, told me that the bond for the malicious destruction of property charge that was authorized and that my client was arraigned on was set at 1,010%. And also as a condition of this, any release, this case, the instant case, any release would include release on a GPS tether. So we would have, the court would be aware of where she is at all times. And it's my information that the complaining witness, her 15-year-old daughter in this case, is not in the household. So there would be no problem with any unwarranted or any contact whatsoever. But my client needs to get out to save her job, help in the defense of this case, secure her home, and secure those two minor children that aren't in school. So I'd ask the court to consider a $5,000, 10% bond.
Well, I thought that the other children, as I was understood, were with, that their, I guess, care had been secured.
That's my information. I have not been able to verify it. Counsel that was assigned the case this morning called off, so I went to the jail and did due diligence as required by MIDC standards to meet with my client. I can't speak because on verifying that where those children are right now, but that's my information that I don't know their supervision right now. I haven't been able to ascertain that because I had to go see my client, but I got the call from my colleague who called off.
Well, just so that we're clear, I watched the arraignment after receiving the motion, and my understanding was that the 15-year-old was with her grandmother.
Your Honor, per my notes, my other minor children are staying with the stepfather, and then the victim, the minor child, is staying with her grandmother. And then further notes indicate that the children were put with a brother or girlfriend who lives either next door or close to defendant's residence. So I'm not exactly sure at this time where they're staying. I know they talked with CPS, who is working on getting the grandma to be the caretaker at this time.
Okay, that was one of my questions, whether or not CPS was involved. But
And that's another concern of my client, not to cut you off, Your Honor, but with the tenuous supervision, as stated by prosecutor as well, there is a plan in place, but I don't know, kids being kids, I don't know how manageable they are. You've had 12 and 13-year-olds, Your Honor. You can't even get them to go to turn off the TV sometimes or come in when the street lights are off. You know what I'm
I don't
talking
know how
about.
your kids act.
Oh,
That was not my children.
oh, okay.
All right, so, but Ms. Zenda, these new individuals, I'll call them, that these children are staying with, does that include, at least based upon what you have, that the victim or the 15-year-old is there?
I believe so.
I heard grandmother in Detroit. That's what I thought I heard.
Well, that initially was where she was going to be, but the other two were supposed to be with, I thought, at least as what I could understand from the arraignment, we're supposed to be with the father of the middle child. But now I'm hearing something different where all three children may be someplace in the same neighborhood.
I believe so. We received an email from DHHS that said the kids were with an Alicia Clark, who is the defendant's brother's girlfriend, and the residence of the address that they're at is, can we approach, Your Honor?
Yes. Should reflect at a pre-press conference, and the major clear was the at least the last known address regarding the children that are involved in the case. been put on record. That way. Was there anything else from my other side?
Nothing from the people, Your Honor.
No, Your Honor, other than she needs to get out, take care of those kids. The two that she can have contact with, keep her job, and
Well, and maybe that raises another concern for the board. I became aware of the MDOP after, or at least the details of the MDOP after the court had made its initial decision regarding the magistrate setting a bond. But why should I permit, given what I hear, her to have any contact with children or anyone under the age of 18?
the CPS will step in. And then that's a whole nother can of worms.
What is a whole other can of worms?
CPS investigating, possibly.
Correct. But typically in cases that might be similar to this, where there's injury to a child, we don't, the bond conditions are set where there is no contact
With any children?
with any child.
If you let her out, we don't object. Put her on a tether and set her bond at 5,000, 10%. No objection.
Okay, but then I have the other issue that if she were let out, the location, at least as known, of the children are in very close proximity to where she would need to reside, which is my other concern.
She's already got a condition for release on a tether, so you know where she's at.
I don't know that it's much of an issue.
I can get another address, sir.
Okay. Don't interrupt the judge.
I'm sorry.
The concern that I have is it's not a home confinement tether. It is just an exclusion zone, which, given the addresses given, the children would be residing within that exclusion zone.
Understood. She said she'd give you another address.
Well, I don't know anything about that. I mean, maybe she should have talked with counsel about that.
Well, we don't know where the kids are. To see if there's going to be any
Right.
violation.
I know, and I understand that, but I also know that as of Friday, or at the time of the arraignment, one child was one place, the other two were at some other location with someone. Now I get here today and am told that all three of them may be someplace else. Now, granted, on Friday, I did not have any information or any indication that CPS was involved. I was going to imagine that they were going to be, but I didn't have any of that information. So I don't even know where these children are at this point.
And that's why I said CPS involvement. She's fighting this case and now she got to deal with CPS too.
Well, I don't know, right? I mean, I can't say anything about what CPS will do or not do. I just know that. All right. The magistrate in setting the bond, there were a couple of things that the motion indicates, and from what I'm to understand, that there were indeed threats that were made to at least the victim in this case, the 15-year-old. Both from what the court understands before and after the incident of the stabbing or the injury to the 15-year-old's hand. The bond form, the law enforcement bond form, which may have mistakenly misled the magistrate, indicated that there were no threats. However, there were indeed or at least were indeed threats. The other concern that I have is that there is a weapon that is used against a minor, not just in a threatening or assaultive fashion, but in a fashion which then indeed led to the injury and the necessity for medical treatment of that 50-year-old. There's further the indication that the defendant or that the victim in this case is fearful of the defendant. In looking at just those facts, the court would find that the bond as set by the magistrate does constitute an abuse of discretion with reference to a PR bond, and then simply without knowing the exact location of GPS involvement, just a GPS with an exclusion zone and nothing more. So the court does find that that's an abuse of discretion. Knowing additional facts, and let me just say this, it's an abuse of discretion because of the alleged conduct of the defendant in this case, and that the court would consider that the defendant would then be a threat to not only the victim in this case, but a threat to the community, and a monetary bond, given those circumstances, should have been set. As we now sit here today, there is the additional information regarding this defendant and alleged activities of violence toward someone else with the malicious destruction of property claim, or malicious destruction of property circumstance. From what I am to understand about that case involves either a boyfriend or ex-boyfriend. There is a concern that the court has given that I have 2 domestic violence incidents by this defendant, allegations or cases that are domestically involved, which raises additional red flags for the court, and also a heightened belief that the defendant in certain circumstances does indeed pose a risk to the community. Taking all of that into account, I'm going to do 2 things. I maintain the bond that the court originally set, although quite frankly, I believe that I should raise it, and that her bond will be set in the amount of $50,000. That's a cash bond. Further, the court is going to order the cancellation of the exclusion zone tether, but should the defendant be released, certainly I would reconsider it, but I would order a home confinement tether as a condition upon her release, prior to her release, should she postpone.
When's the next hearing on this one?
Pardon?
The PCC is already set for June 26th.
Is June 26th.
If we get you a new address, would you reconsider before then? Or
Reconsider which portion?
a 10% privilege?
I will certainly look at anything that anybody presents to me. I'm disinclined to change anything until I have some information regarding where the alleged victim in this case is, as well as these 2 other children and where they are. But at this juncture, I'm not inclined to change it.
Yes, sir.
All right.
Yes,
Thank
sir.
you.
Thank you. I'll see y'all tomorrow.
Yes, sir. 14A in recess.
How you been, Judge?
I'm always good.
I know you are.
14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J. Cedric Simpson resides.
Maybe. And having done the waiver this morning. I'll lose it there, apparently. Just
I was hoping no one noticed.
Alan's the one that pointed it out to me. Court does call the case People versus Nicholas and Bonasai.
Requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ali Zenda.
Permission to practice is granted.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Bosniak. Sir, please state your name for the record.
Nicholas Michael Bosonic III.
Masonic, yeah, it's like every time we see him, we mess it up. And I'm before I called it, I'm staring at him going, I know it's not how we got it right. But anyway.
It's like Masonic. Bosonic.
Bosonic.
Anyways, okay.
Like vinegar. No,
There you go.
no, I'm kidding.
Need to write in the file.
All right, what are we doing?
Your Honor, we are requesting an adjournment of the pre-trial for continued discussions with the people. Obviously, this case is quite old, and Mr. Bosonic lives in New Zealand. So there are some things that we want to work out.
Like how we're gonna get him back here? Or
Well-
how we're gonna go over there to handle the case?
I'd love to go. That would be great.
Go over there. Okay, how much time are you guys gonna?
I think that's the standard 2 weeks should be sufficient.
Think it will. All right. Adjourn the pretrial in this matter to, what is that, to
June 30th at 1 p.m.
June 30th, 2025, 1 p.m. All right. Bond will continue. All right. Thank you, sir.
Thank you.
What time is it there?
5 a.m. 5:19.
Ow. Ow. Sorry.
You're fine. Not a problem at all.
All right. You take care of yourself.
Thank you. You do the same, sir.
Court does call the case of the People versus Eric Buckner.
Ali Zenda on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Buckner. Your Honor, I'm not sure if Mr. Buckner is present.
Oh, I have an Eric Buckner.
Yes.
Oh, there he is. You'll have to unmute, sir. All right, state your name.
Yes, can you hear me? Eric Buckner?
Yes, we can hear you.
Sorry.
All right, I just need you to state your name. You're breaking up a little bit there.
Eric Buckner?
Better delay, but
Your Honor, I spoke with Ms. Zenda prior to the docket. Do you want to approach?
Can we approach briefly, Your Honor?
you may. Ready to go.
You just turned this camera on.
All right, Mr. Buckner.
Yes, I'm here.
Okay, we're back on the record on this case.
No.
I'm going to adjourn your case to June 30th, 2025 at
1 p.m.
1 p.m. That will be an in-person hearing.
Okay.
All right, so you have to be here.
Yes, sir.
Okay? All right, thank you. Con, continue. Court does call the case People versus Dejamoa Byers.
Claire Lowe on behalf of
Good
Need to
afternoon.
wake you. All right, what?
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Byers. Ms. Byers, please state your name for the record.
Deja Moye Byers.
Your Honor, we are requesting that this case be set for final settlement, please.
Jury, final settlement conference will be set for
August 8th, 2025 at 9 a.m.
August 8th, 2025, 9 a.m. Jury selection, if necessary, will be August 11th, 2025, 8:30. Both of those proceedings are in person. Bond continued. Thank you.
Thank you. You're all
Thank
set,
you.
Ms. Byers.
Thank you.
Thank you. Court calls the case, People versus Marquand, is it Grace?
On behalf of the people.
Oh, there he is.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Gracie, who is approaching. State your name for the record, please. Ms. Gracie.
Gracie, all right.
Your Honor, we are also asking to set this case for final settlement, please.
Jury, final settlement conference will be August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person. All right, bond will continue.
Thank you.
Thank you. Court does call the case, People versus Douglas Lee.
On behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Lee.
There's an individual who signed on Samsung. Could you unmute and state your name, please?
Can you hear me now?
Yes, what's your name?
Douglas Lee.
Okay, that's Mr. Lee. All right, I need a camera on, sir.
Yes, sir. I'm still trying to figure this one out. Right. Okay. I hope this is it.
There should be a little camera with a line through it. You want to click that,
I'm clicking it.
maybe.
I'm definitely clicking it. Oh no. Please. Please work with me. I'm sorry,
Send me a request, sir.
Oh, goodness. I don't know how to work it. They all heard my video, yes.
Oh, there you are. We've got you now.
Thank you very much for your patience. I'm sorry.
Oh, I wasn't patient. We were gonna come find you. No, I'm kidding.
Oh.
All right. What are we doing? State your name, sir.
Douglas Tyrone Lee.
Thank you. All right. What are we doing?
Your Honor, we are requesting an adjournment of the pretrial. Ms. Pate would like to review all the media with Mr. Lee.
I'll adjourn this matter then to June 30th, 2025, 1 p.m. All right. Thank you. Now he knows how to work the camera, so we won't have the same problem.
Thank you, Your Honor.
You have a good day, sir. Thank you.
You too. Oh, one more thing. Happy belated Father's Day.
What you say?
Yeah, happy Father's Day.
Oh, and to you, sir.
Yes, sir.
Court calls the case, People versus, is it Jaquil Lloyd? I got that right.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Lloyd. Mr. Lloyd, please say your name for the record.
Yes, Jaquil Elijah Lloyd.
All right, thank you.
Your Honor, two things. First, we are asking to address his bond conditions. There was a bond condition that was set at arraignment for drug testing. Ms. Zenda and I spoke this afternoon and reviewed the police report together. And there were no allegations in this case that Mr. Lloyd consumed drugs or alcohol or that led to the charges. Ms. Zenda also reviewed his criminal history, and we didn't see any indication of drug or alcohol related prior cases. So I'm asking for the drug testing condition to be lifted. And I don't want to speak with Ms. Zenda, but I believe she has no objection to that.
That's correct. No objection from the people.
All right. Then I don't have a problem, and council, you may want to just prepare an order, because currently what I have is that he's on testing 2 times per month.
Correct, yeah, that's what I
Have you
have.
taken, sir, have you taken a test already?
Yes. I've been down there. Yes. I'm all the
Okay,
way.
and you tested?
Yes, for the first
Did
time.
it come back clean?
Yes, when I went down there, yes.
Okay. Then if you prepare an order, as long as his test came back clean, then I don't have a problem removing that condition.
Okay, thank you for the consideration, Your Honor.
Oh? Is there a problem?
Can we approach briefly?
You know, Ally, I'm just gonna get Ally a chair.
Oh, no.
I don't know what happened.
Sir, we'll be right back with you.
Okay.
All right,
Hello?
we're back on the record on the case of the People versus Lloyd. Sir, I have an indication that you actually came back with marijuana in your system. Do you have a medical marijuana card?
No, not currently, not anymore. No.
Pardon?
I said no, not anymore. No.
Okay.
That
So
was-
you can't be, hold on, you can't be using. So I'm not gonna order that the drug testing stop at this point. We're gonna get a couple of more tests, and the levels need to be going down.
Okay, can I say something or no? But it don't even, never mind. It don't even matter. We're not gonna care.
We'll call you, Mr. Lloyd, to explain
All right.
what's going on.
Yeah, talk to your attorney about it. All right, so when you want, just 2 weeks?
Please, he should test again then.
Yeah, he should be. So I'll adjourn this to June 30th, 2025 at 1 PM. Okay, sir?
All right, I understand you.
All right, thank you. Bond continued. Court does call the case, People versus Alexis Naveen.
It's my turn now, Your Honor. Good afternoon, Assistant Public Defender Lauren Perry. On behalf of Ms. Naveed, can we approach, please?
Sure. Hold court to June. In this case, I will adjourn this matter to June, bless you, 30th, 2025, 1 PM. Bond will continue. Thank you. Court does call the case, People versus William Fridge.
Is Mr. Fridge present?
He is not.
Your Honor, that surprises me because
I know.
Mr. Fridge, this is Teresa Claire on behalf of probation, by the way. Mr. Fridge has been compliant with me otherwise, and has been reporting. The issue today is regarding his payments. He's not made any payments and has been arrears of $250.
I'm going to check, and I agree with you. I would, not only is he compliant, I find it unusual that Mr. Fridge is not appearing. So what I'm going to do is I'll indicate that defendant failed to appear at this proceeding, but I'll adjourn this out to June 30th,
Thank you, Your Honor.
2025, 1 PM. Court calls the case, People versus Jason Orr.
Ally Zend on behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Orr. Your Honor, I'm not sure if Mr. Orr is on Zoom. However, I did speak with him today and Ms. Pilar, and she did he had to be here in person due to the new allegations. He indicated to me that he was working on the line today and could not get off at short notice. He was waived up until this morning, as the court knows. So that is why he's not present today.
Right, because we weren't aware of the contact.
Right.
So Teresa Claire on behalf of probation, Your Honor, given that Mr. Orr is not present and there was a police report that was received over the weekend regarding a violation of the no contact order, probation is requesting that the court issue a bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety. That warrant will issue immediately. Court does call the case, People versus Alfredo Gonzalez Lopez.
On behalf of the people.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Gonzalez Lopez, whose appearance has been waived.
And Teresa Claire on behalf of probation, Your Honor, Mr. Gonzalez Lopez is scheduled before the court for
All right. 14A District Court for County of Washington, State of Michigan is now in session. All those having been, court drawn near, the Honorable Judge J. Cedric Simpson presiding.
You may be seated. Ms. Linda.
Good morning, Your Honor. Ally Zenda on behalf of the people. Your Honor, the people would waive any potential conflict between this honorable court and the Office of Public Defender. While the people don't believe such a conflict exists, the people make this waiver in avoidance of all doubt.
Ron Crane on behalf
I got
of the Defender's Office.
She's got it. She's got it.
Anna Mack on behalf of
Just do whatever.
Anna Mack requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Ron Brown.
Permission to practice is granted. I appreciate you're just taking charge. Go ahead.
Your Honor, we waive any conflict between this honorable court and our office. If any conflict were to arise, we waive that conflict so this honorable court can hear these matters. Thank you.
Court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided they're to the extent a conflict does exist, given the waivers, court will consent to hear the matters. Court does call the case, People of the State of Michigan versus Imbaye, is it India?
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Good morning.
Good morning, Your Honor. Assistant Public Defender Qasim Bobes on behalf of Mr. Mbaye Ndaye.
Is he here?
I have not spoken with him, Your Honor. Ndaye? Your Honor, I have not had any meaningful contact with him, unfortunately. Was going to be asking for an adjournment. There is an offer. He did pay about $3,000 to get out. There was an agreement between the Attorney General's office and I, but have not been able to reach him.
He's not here. How much is currently owing on the child support council?
So, Judge, my understanding is that the defendant posted the bond. It has not yet showed up in the child support system, but his current arrearage, Your Honor, is $20,287.86. I'm wondering.
You said 20? I'm sorry. You said 20,000?
$20,287.86.
Thank you.
Judge, I know you have a mechanism to have those bonds. Do we know whether they're processing that bond over to the child support case?
They should. Yes, our mechanism is that the order would read to pay that bond over. And I think that has, I just want to make sure that the bond form indicates that. And it does, to send over to circuit court. So he's paid about 3,000, a little over 3,000 of that amount.
Correct.
So it's about 17,200 that's still owed.
That
So
would be
bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $17,200. That's cash to be paid to the circuit court if posted. That warrant will issue immediately.
Thank you, Your Honor.
And Your Honor, will that be an immediate bench warrant? And do you need the AG to prepare and submit it, or will the court handle that?
No, we will handle it, and it's an immediate bench warrant.
Very well. Thank you very much, Your Honor.
All right, thank you. Court does call the case of People versus Devontae Davis.
That was for the people.
Morning, Your Honor. Alex Warren, Green on behalf of Mr. Davis. Mr. Davis, can you state your name for the court?
Devontae Davis.
Thank you.
Your Honor, at this time, we are asking the court to set this matter for preliminary examination.
And all discovery is complete.
Believe so, Your Honor.
And which one are we on? July 20th?
Oh, I'm sorry.
It's a
week from July 1st.
I thought so. People have their witnesses available July 1st. Preliminary examination in person will be set July 1st, 2025. 9 a.m. That is before Judge Perry. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Alan Ballou.
Good morning, Judge Lawrence H. Margolis with and on behalf of Alan Ballou. Alan, please state your name.
Alan David Ballou.
Judge, this is a referral, we hope, to the Veterans Court. He has been accepted into the court, and we are prepared to go forward with a plea today. If Your Honor will take it, he has been advised of his rights. He has signed a waiver. He is also prepared.
What is he pleading to?
Disorderly.
Your Honor, I don't know if for Douglason people, Your Honor, I don't know if Your Honor had a chance to sign the referral and if that paperwork.
I have the referral that I will sign off on, but I don't have a plea form. I don't have anything.
Then we aren't ready for it. We needed you to sign it. So that's what we needed.
Yeah, that was the one thing I was waiting on, was hoping we could do it this morning, but I don't obviously mind passing.
Do what this morning?
Sign the plea form. That was the only thing that was not prepared.
I don't kind of need that.
I was hopeful that Ms. Douglas could.
Okay, what am I doing? Because otherwise I'm just gonna do what I'm gonna do.
I have an email at 9 a.m. with maybe the information that they're looking for. I don't know.
At 9 o'clock this morning?
Yes, I have not reviewed it over. So Your Honor, we're trying to get him referred to Veterans Court. I have not received confirmation that he's been accepted, and that's why I didn't do the plea form because he needed the paper.
No, I got you, because I just signed off on the referral. So I can't really do anything.
And I apologize, Your Honor. I was under the assumption that the emails that I had provided from Mr. Graveline stating that he had been accepted into the court and that this was going to be pled today was going to be sufficient, but
Probable cause in this matter will be adjourned June 26, 2025, 9 a.m. Bond will continue. You guys get your stuff together and then I'll deal with it.
Thank you, Judge.
Court does call the case, people versus Larry Hickman.
Judge Kennedy, after people, Your Honor.
This was the.
Yeah.
Good morning, Your Honor. Student attorney requesting Andra Savvy requesting permission to practice pursuant to MCR 8.120 under the supervision of Assistant Public Defender Chinaza Ikiri Akinruli, representing Mr. Hickman, who is present in person today.
Permission to practice is granted.
Thank you, Your Honor.
I guess the first thing we need to take care of is there were additional counts added, counts 3 and 4. I think we got the counts straight. Have you reviewed those with your client?
I believe Ms. Ikiri Akinruli has reviewed those counts with Mr. Hickman. No. The knee counts, were they reviewed with you yesterday?
No.
No?
Where's Ms. Akinruli then?
I'm not sure, Your Honor. I believe she may be in another courtroom at this time.
Well, has anybody gone through the other counts with him that were authorized? Or you don't know? I'll take that as that I don't know. Huh?
Yeah, I apologize, Your Honor. I cannot provide an answer to
You
that at
take
this
it
time.
back. I'll pass the matter. We'll have to bring him out later. I have to go through those other counts. Court does call the case of the people versus Brandon Clemens.
Good morning, Your Honor. Attorney Jonathan Paul for Mr. Clemens.
Clemens, can you state your name, please?
Yes, sir. Brandon Clemens.
And I'm gonna. That's okay. My God.
It's a
Okay, thank you. All right.
I wasn't sure you were going to do it.
That's the one report that I got
Yes.
last minute. All right. I have before me a plea form that indicates that the defendant is going to be pleading guilt. Well, is he going to be pleading guilty or no contest? Because otherwise I've wasted my time reviewing a plea.
Your Honor, he's pleading guilty.
Pleading guilty to the charge of operating while intoxicated with an occupant less than 16, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement. Is that correct?
Yes, sir, that's correct. Yes, Your Honor.
Mr. Clemens, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes, Your Honor.
State your name again for the record.
Brandon Clemens.
Put your hand down. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated with an occupant less than 16. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, Your Honor. Yes, Your Honor.
All right. And understanding all of that, well, and I'll also indicate to you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge. Need a name? Before Judge Perry in the 15th District Court. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, sir.
And you understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Your Honor. Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Pardon?
I currently have a sober breathalyzer. You're not
right. Are you under the jurisdiction of any other court, sir?
No, Your Honor.
All right. Have you ever been to prison for longer than a year?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor. No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor. Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor. Yes, Your Honor.
All right. And you understand that if you commit any type of misconduct between the time of this plea and the time of sentencing, that you would not be entitled to withdraw your plea unless allowed by the court for a good cause. You understand that?
Yes, Your Honor.
You also understand, sir, that if you do commit misconduct during that time, the sentencing judge would not be bound by any recommendation or evaluation.
Yes, Your Honor. Yes, Your Honor.
Is counsel aware of any other pleas, inducements, or threats that have led to this plea?
No, Your Honor. No, Your Honor.
Counsel, I didn't hear you.
No, Your Honor.
All right. Sir, on the date of April 3rd, 2024, at the location of Liberty Street near Maple Road in the city of Ann Arbor, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, Your Honor. Yes, Your Honor.
What did you have and how much?
I had I had drank heavily the night before, and then the day of that morning, I had about 2 twisted teas. So I think my blood alcohol was mostly from the night before of me drinking heavily.
Were you stopped by the police or was there an accident?
I was stopped by the police. There was
Why did they stop you?
I did bump a little bucket inside of the store, but they stopped me because of the driving that they had witnessed.
Are you disputing the right of the police to stop you?
No, Your Honor.
Were you ultimately arrested?
Yes, Your Honor.
And were you taken to the station or the hospital?
I was taken to the station, Your Honor.
Was there a data master or breathalyzer test of some type?
Not on my end, Your Honor. They took me to the police station, and then later they took me to
Counsel,
the
was there
hospital.
a breath test or a blood test in this case?
Your Honor, it was a blood test of
I have the labs.
Did you take a blood test, sir?
Yes, Your Honor.
What were the results of that blood test?
0.248, Your Honor.
0.248? Sir, do you have any reason to dispute those blood test results?
No, Your Honor.
Was there an occupant in that vehicle
You broke up, Your
besides
Honor.
you?
Yes,
Pardon?
there was another occupant in the car, Your Honor.
Who was that?
That was my girlfriend's son.
And how old is he?
He is currently 6.
At the time, how old was he?
He would have been 5 years old, Your Honor.
Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea. 2 count 2, count 1 is dismissed. The pre-sentence investigation and screening and assessment is ordered at 15th District Court. Sentencing in this matter will be July 14th, 2025, 8:30 before Judge Perry.
Thank you very much, Your Honor.
Bond with its conditions will continue. Thank you.
You can sign off, Brandon.
Thanks.
Court calls the case of the people versus Michael Patterson.
Can I be executed here?
I have 2 cases. Second, really? Hang on a second.
Good morning, Your Honor.
Pardon?
I said, good morning, Your Honor.
Not really, but thanks. Good morning to you.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Patterson. Today is the date and time set for the probable cause conference, Your Honor?
Yes, both matters.
Set up a examination.
What's that?
Set up an examination covers all.
Oh, that's from the prosecutor?
Yes.
Hospital. So today, I would like to be concluded from this situation, in this case, just to be furtherly admitted into the psychiatric hospital. He already ordained that.
We'll do that as part of the bond. Your Honor, today, there are no offers from the prosecution. My client will respectfully request that this matter be set for preliminary examination. We'd also like to address the bond at the appropriate time.
You want preliminary examination in both cases, sir?
Yes, please.
To your knowledge, I'll discover his complaint.
To my knowledge, yes.
People have their witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. before Judge Barr.
Thank you, Your Honor. As to bond, we're asking for a modification. My client indicates that he has already been determined to be released to,
I'm sorry?
To Havenwick, Arbor Hills, Havenwick Hospital for psychiatric treatment.
Arborwick, Haven Hills Hospital, we're asking that his bond in these cases allow him that similar release to, what's saying the name of it again?
To Auburn Hills, Havenwick Hospital.
Auburn Hills, Haven.
For treatment?
Yes, please.
And you say he has that in his other cases or?
Yes, the last time I was here, that's what I was before you, Judge Simpson, and
Yeah.
you ordered for me to go there.
I think I ordered release to inpatient treatment,
That's right. That's what I want.
but I think did we already order it?
Well, it sounds to me like.
Yeah, on my last court date, that's what was, that was ordered by, you personally.
Okay, I don't have an order. If it's a release to inpatient treatment, I am not gonna have an objection whatsoever. So where's Ms. Yagi? Ms. Yagi has an order that she has prepared that probably all of the public defenders should use. That I'd be more than happy to sign off on, that I've signed off on for the last 5 to 10 times for her.
I know Ms. Yagi will happily share.
Thank you, Ms. Yagi.
Because we are one happy family.
I don't know about all that. All right, so at this point, what I'll do is his bond will continue. And once I receive that order, I'll sign off on it.
Thank you very much.
All right, thank you.
Thank you, brother.
You're welcome.
Okay, to whip him into shape. Court calls the case, People versus Mary Collins.
Andrew Banner for the people. Good morning, Judge Caldwell, on behalf of Mary Collins, who is approaching the podium. And Mrs. Collins, please introduce yourself to the court.
I'm Mary Collins.
Thank you.
And Your Honor, today's the date and time set for probable cause conference. I have spoken to Prosecutor Banis. We are working on a resolution. I do have a adjournment form for the court's file.
Probable cause conference in this matter will be adjourned to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, sir.
Court does call the case, People versus Lakita Roberts.
Andrew Banner.
Have you start working.
Hannah Mackey on behalf of Mrs. Lakita, who's approaching to my right. Please state your name for the
Lakita
record.
Roberts.
Your Honor, we're respectfully requesting an adjournment. We believe that we could discuss a possible global resolution in her circuit court matter as well.
So she has things in circuit court.
She does, Your Honor.
And when's her next date in circuit?
Don't know that one.
You're gonna do a global resolution. Don't you think you should know that? I'll wait.
Your Honor, I see a case, according to X jail, a circuit case scheduled for 6/25, June 25th.
June 25th, Your Honor, is the date.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond continues.
Thank you.
Court calls case of the People versus Bianca Rao.
Andrew Dennis for the people. However, on behalf of Ms. Rowell, who's approaching the podium. Ms. Rowell, please say your name for the record.
Bianca Rao.
So, Your Honor, so we are, today is the date and time for probable cause conference. We have worked out a resolution. I've provided documents to the prosecutor, Mr. Banis, today, and I have a few more that I'm going to email that Ms. Rowell provided for me today. We just need to have first APA, Burton Harris, look at these documents. So we are asking for a brief adjournment, hopefully the last.
Probable cause conference will be adjourned July 3rd, 2025.
Thank you, Judge.
9 a.m. Bond continues. Court calls case People versus Thomas Vasher.
Andrew Banner.
And Alex Warren Green on behalf of Mr. Vasher. Mr. Vasher, can you state your name for the court?
Thomas Vasher. Are we gonna get breakout room or something?
Oh, Your Honor, I went to the jail last night and
Yes, you did. He wasn't there. He's in the hospital.
he has been transported to the hospital.
Yes.
So I'm asking for an adjournment. The people generously did extend an offer. I want to discuss that with Mr. Vasher. And if I may ask on the record, Mr. Vasher, do you anticipate when you'll be discharged and returned to the jail?
No, actually, they just talked to me and I plan on staying here. They need to run
Okay, well,
different tests.
Mr.
and see why
Vasher, call the
legs are-
public defender's office if you can, and Your
Well,
Honor,
how
I'm
come
respectfully asking
Room and
for
you
an
can
adjournment.
explain, or can you address my bond at least? Because I'm here on my bond's been violated because you guys
Mr. Vasher,
while I was out.
Your Honor, I'm requesting an adjournment to the next available
Well,
date so I can talk
to
to
address
him.
my bond. I'm asking you that.
I'll give him an early date. That way you can go talk to him and see exactly what it is his complaint is. June 26th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor. I want a new counsel.
Court calls case People versus Julius Holston. That's on.
Good morning, Your Honor. Edward Rubis on behalf of Julius Holston.
Good morning, Julius Holston.
Your Honor, there was a resolution that was worked out this morning. It would be a no contest plea. I have a plea form if the court's able to allow that. Otherwise, we'd be asking for an adjournment.
No contest. I haven't even read a report.
I understand.
They're supposed to get to me at least 24 hours. I don't mind doing the work, but I'm not going to do it on this day. So I'm going to put it over and then I'll take your plea.
Okay.
But I'm not going to do it. I'm not doing that today.
That sounds like a plan.
Probable cause conference, June 26th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Demarius Tubbs.
Andrew Bennett.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P 85051 on behalf of Demarius Tubbs. Mr. Tubbs, please state your full name for the record.
Demarius Tubbs. All right, first order of business is I need a substitution of attorney filed. Mr. Martell, I'll let you go ahead. I realize you filed an appearance, but I think you know the court rules require a substitution of attorney.
Yes, Judge.
All right, what are we doing today on this?
Judge, it was my expectation that charges would be filed federally by now. I have not received any. So, Judge, discovery is complete. I'm asking for an examination date, please, and thank you.
I didn't hear any of that. You need a better microphone.
Forgive me, Judge. Discovery is complete. We're asking for a preliminary examination date.
People have their witnesses available July 1st.
We will do our best, Your Honor.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Always a pleasure. Have a great day.
Court calls case People versus James Chandler.
And is that on behalf of the people, Your Honor?
And good morning, Your Honor. Please, this honorable court, Brandon Bird on behalf of James Chandler. Mr. Chandler, can you please state your full name for the record? James Chandler.
Where's the rest of his pants?
I was at work. He was at work, Your Honor.
Really?
And that's and one thing about it is my apology. I had told him it was going to be 2 p.m. and once I seen he was on the 9 a.m. docket, I called him later. He hurried up and got up to.
And so what? His pants weren't ready or what?
He probably didn't have any pants. But he was.
I see. Oh. Okay.
But now
it won't happen again, right?
Never again.
Yeah. Okay. Okay. Go ahead.
Okay. Today we're gonna.
Sir, that's not your fault. It's his. Yeah. Don't worry about it.
It is. It is.
I got. Oh, I know. Everybody knows it's your fault.
I take full
All right.
responsibility. Now, we're just asking for a slight adjournment because the prosecutor needs to check to see if the body cam has audio, Your Honor.
That's correct, Your Honor. Media's been provided, but it's my understanding that Mr. Bird's media doesn't have audio, so I need to check in if there is audio on the videos.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. bond will continue. You fill out a green form?
I did, Your Honor.
All right, yay.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Philip Brown.
Regardless of people.
Okay, where's Burgess?
He's here.
Good morning, Your Honor. Please, Honorable Court, David Burgess, on behalf of Philip Brown.
All right, what are we doing?
Your Honor, this was a reissue. I have had discovery for some time, so we were requesting an exam in this matter.
People have witnesses available July 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Barr.
Judge, may I briefly address the issue, bond?
You may.
Thank you, Your Honor. Your Honor, bond is currently set at $250,000 cash surety in this case. Understand the serious nature of the charges, but the allegations are that the complainants in this case ran up into my client's girlfriend's house where he was staying. The police report is somewhat vague on whether the incident occurred outside or inside the residence, but be that as it may, Your Honor, on my client's actions, we do take the position that my client was acting in self-defense of himself, his girlfriend, and her home. And all three witnesses on the case before didn't appear at the last exam, Your Honor, after speaking respectively to their counsel, which they needed appointed because of their potential Fifth Amendment issues. So based on that situation, Your Honor, I think that the bond should be lowered, maybe 50,000, 10%. My client didn't want me to ask for a PR bond. I know the charges are serious, but I do think under the circumstances, the bond's excessive. Thank you, Judge.
Response.
I believe that the bond is appropriate. The report is not vague about where this took place. The allegation is not that these people ran up in the house, it's that they did go to the house, and that this occurred outside, and that a neighbor who was uninvolved witnessed part of this, and it was the reason she was able to witness it is because it happened outside. And so, Your Honor, there's the allegation that he shot at 3 different people in the front yard. As far as the cases, 2 witnesses that were able to be contacted for the exam when this was initially issued did want to move forward. They were not able to come on that date. And so the people were unable to get an adjournment. And that's why there was a dismissal and immediate reissue. It's not that they didn't want to move forward. So, Your Honor, we do believe that this bond is appropriate.
Who was this case originally before?
Judge Washington? Yes. Judge Washington, I believe, Your Honor.
But no testimony was heard?
Correct, Your Honor. We've adjourned it a few times for them to
Then
speak to counsel.
I'll leave it before. All right. Anything else?
Your Honor, only that the 3 people that came to the house came uninvited, and this was over a dispute, so they were coming there, obviously.
Were they armed?
Yes, Your Honor.
Your Honor, there was one individual who admitted he had a firearm. However, he is not accused of trying to shoot him.
Only accused of bringing a gun to a stranger's house without permission.
Yeah.
I believe there was an AR-15, Your Honor. That's a semi-automatic rifle.
Had a firearm.
But there are 3 felony firearm charges here at the 3 in possession of the allegations that he's a prohibited person, so he shouldn't have a firearm or ammunition. And then I have 1, 2, 3 counts of assault with intent to murder and assault with intent to do great bodily harm less than murder and carrying concealed. All right. Anything else from either side?
Your Honor, there was one minor. There was a no contact issue to his girlfriend, Latrice Hargrove, when he was rearraigned on this case. that had been lifted last time. There was a confusion as to that. She's just his girlfriend, not a complaining witness to the case. I just asked that he be allowed to have contact with her. She'd be a defense witness in this case.
Any response to the no contact?
Your Honor, she is a witness in this case. I believe that the no contact was issued because part of the conflict is supposed to have been based on allegation that Mr. Brown had done something to her daughter, but I will leave that discussion.
Okay, I'm not gonna change the no contact. I'm gonna leave that where it is at this point. I'm also gonna deny the defendant's motion for a bond reduction. Bond will continue. Thank you.
So if you need another copy, so. Okay.
That's called the case of People versus Leorn McEwen.
Yes, Your Honor. Please, this honorable court again, Brandon Bird on behalf of Leon McEwen. Mr. McEwen, can you please state your full name for the record? Please.
Thank you. All right, what are we doing?
I would really like to get this resolved, Your Honor. But if Sister Prosecutor doesn't believe that we can get this resolved, then we're gonna set this matter for exam.
You have all the discovery.
I do have all the discovery.
People have their witnesses available to first. You need to, sir, you need to take your hand out of your.
Oh, I'm sorry.
Preliminary examination in person, July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue.
Just for the record, the offer has been that if Mr. McEwen could provide proof that he could drug treatment for date of offense, that would be offered and used, however, that apparently is not.
I say anything? I've been in treatment for 5 years. This case is 5 years old. So is there any way we could adjourn this matter, Your Honor, to provide, just the prosecutor? I passed all my drug tests, every one of them.
I need a green sheet. Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will continue. Thank you. July 3rd.
Okay, sir. Thank you. Thank you, Your Honor. Thank you for your patience today, too.
Thank you,
sir.
What?
Thank you for your patience today.
Oh, no, that's really not in the cards. Thank you. Court does call the case, People versus Todd Rayberg. Now you get it. All three
Morning,
cases.
Your Honor, Laura Yagi, Assistant Public Defender with and on behalf of Mr. Rayberg. And, Your Honor, I do have some paperwork here. I just had it. Mr. Rayberg, could you state your name for the court?
Todd Rayberg.
I swear I had it, Your Honor. Here it is. I am requesting a brief adjournment. One of these cases is very new and I didn't have the police report yesterday when I met with Mr. Rayberg. I'm also submitting to the court a proposed release to treatment order if the court would consider signing it.
Any objection to release the treatment from the people?
Your Honor, there's no objection.
I'll sign that order. And then I'll grant the adjournment in this matter on the 6th, which is going to be the day from where you want the 3rd.
I think probably the 3rd, Your Honor.
Good enough.
Thank you.
So probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bond will.
Thank you.
Court does call the case, People versus Adam Fari. This is the one.
Oh, different. No, it's one.
Right, the people put their appearance on the record. Joe Simon, you did, right? Sorry. Joe Simon, on behalf of defendant, Mr. Barry, state your name.
Adam Mari.
All right. You need an adjournment in this case?
Yes, I'm going to supply some mitigation documents to the people in support of a
I
request.
think July 10th was,
I will be back, Your Honor, but you may be seeing too much of me on that particular day.
oh, I'm seeing too much of you every day.
So either the 10th or the 17th, but I have, sometimes the court gets mad when he sees too much.
July 10th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Mohammed Dar.
Say it again. Yeah, actually.
Assistant Public Defender Costinville based on behalf of Mohammed Dar, who is present to my right. Mr. Dar, could you state your full name for the record?
Mohammed Hassan Dar.
Thank you. Your Honor, today is the end time set for probable cause conference. At this time, there is no offer, so we'll be requesting to set this for a preliminary exam at the soonest available date.
You have all discovery.
To my knowledge, Your Honor.
People have their witnesses available the first.
Your best, Your Honor.
Preliminary examination in person, July 1st, 2025,
Your Honor, may I just bond when
9
appropriate?
a.m. Yes.
Your Honor, my client is requesting a PR bond. He has two jobs on the outside that he would like to keep. This is in a group home. He supports his mother financially by sending her money. He also has some personal matters that he needs to be taken care of on the outside. I don't believe he's a further danger, Your Honor, if the court is inclined to give him a GPS tether or put in the no contact, no go-to orders. He's willing to do whatever the court deems necessary, Your Honor.
Anything.
Strong.
I object to any modification of bond at this time. My understanding, Your Honor, is that the defendant was currently on bond at a case out of the 15th District Court, failed to appear at that case while he was hospitalized, which is where this offense took place. In this present matter, the defendant assaulted a nurse by grabbing her right breast, and she was placing a blanket on him. Check that complication.
Well, we certainly understand how serious the allegations are, Your Honor. As I said, my client is open to any no go-to, no contact orders, anything the court deems appropriate. We don't believe that he's a further ongoing danger to the community nor a flight risk, Your Honor, at this time.
His bond is set at this point at $1,000 cash surety. So I think that's appropriate given the allegations in this case. Motion for bond reduction is denied. Bond will continue.
What was that date, Your Honor, for the
July 1st.
Thank you.
Thank you, Your Honor.
July 1st before Judge Barr.
Thank you, Your Honor.
Did I put that in there? I think I did. Double check it. Yeah. Court does call the case People versus David Witherspoon.
Ready, Your Honor. Andrew Banner.
Your Honor, Joe Simon, on behalf of Mr. Witherspoon, is making his way to the podium. Mr. Witherspoon, state your name, please.
David Witherspoon.
Your Honor, may counsel approach?
Yes.
Thank you, Your Honor.
Court will pass this matter. Recall it later. Court does call the case of the People versus Mark Hubbard.
Ally Zend on behalf of the people, Your Honor.
And I'm acting on behalf of Mr. Hubbard, who is approaching. Please state your name for the record.
Mark Hubbard.
Your Honor, we're respectfully requesting an adjournment. We just received discovery and have yet to go over it with the clerk.
Is anything else holding him or?
I don't believe so, Your Honor. I believe
This
it's
is
just
the only thing holding it?
correct.
All right, probable cause conference, June 26, 2025, 9 AM.
Thank you, Your Honor.
Bond will continue.
Thank you.
Court does call the case of the people versus Joel Jones.
Good morning, Anna. David Burgess on behalf of Joel Jones, who does not appear to be here.
He's not here?
No.
Got it. Joel Jones, you were just appointed on this case?
Yes, Your Honor. So I don't have a contact number for her at this time.
And, well, the reason I'm asking, I think she's been on bench warrant status.
She was, I think I appeared on Zoom on the 20 case, Your Honor. There's 2 cases, I believe.
Right.
Yeah. And I appeared on Zoom that day and I gave her my information, but I did not receive a call from her.
Bench warrant will issue for defendant's failure to appear in each case. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. You can get that one. You can get this one. Court does call the case, people versus Javante Jackson.
And then on behalf of the people,
I have anybody that wants.
I can't see, I'm so sorry.
We're not. The comments. Javante Jackson, you have Jackson?
Assistant Public Defender Sandra White on behalf of Javante Jackson.
State your name, sir.
How are you doing, Javante Jackson?
What are we doing?
Your Honor, we're asking for an adjournment in this matter. Apparently there are some jail calls I was just made aware of that we need to review.
Your Honor, I'd like to address that.
All right. I'm gonna need a green sheet. All right, yes, Esteban.
Thank you, Your Honor. It's come to my attention, this defense has made 16 complete calls to the victim in this case, as well as 142 attempts to call her. These calls are extremely concerning. At the beginning of the call, the victim tells him she wants him to stop contacting her, that she's gonna come to court. He continues to keep calling her, as well as having a third party reach out to her. He says to the third party, "You want to do me a solid?" Third party says, "What's that?" He says, "Pull up on that bitch. She's gonna cry to you. She's gonna do all this crime shit to you. Just pull up on her for me and be like, yo, don't cook." Because yesterday I talked to her and she kept going on about testifying. So I have extreme concerns that he's not only reaching out to the victim, but also third parties to contact the victim on his behalf. And would ask that his phone privileges be revoked.
Any response to that?
Yes, Your Honor, I would ask, first of all, we need to review these calls, but that the phone privileges only be revoked to that certain number. Mr. Jackson needs to call his parole officer, so we are asking for the calls to only be revoked to that certain number.
You need to do what?
Have phone calls with his parole officer. We are trying to arrange certain things.
But the calls that the people are talking about aren't parole calls to his parole officer.
That is correct, Your Honor.
Probable cause conference will be adjourned to July 3rd, 2025, 9 AM. At this time, pending a hearing or request for a hearing, defendant's phone privileges are hereby ordered revoked.
Thank you, Your Honor.
Bond will continue. That was for you. Court calls the case, people versus Joseph Bailey.
Ally Zend on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Bailey. Could you state your name, Mr. Bailey?
Joseph Bailey.
He forgot his pants too.
Oh, Mr. Bailey, you gotta wear long pants in court moving forward. Your Honor,
Pardon me about that.
Pardon?
Said pardon me about that.
Okay.
we're asking the court to set this matter for preliminary examination. And my client does have a request relative to his bond conditions.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 1st, 2025, 9 a.m. before Judge Perry. Mr. Bond.
Thank you, Your Honor. Mr. Bailey is currently on a hot zone tether. He's asking the court to consider removing that requirement. He is a moving truck driver. He's a soccer coach. And my understanding is that this case involves allegations of electronic communications only. So, Your Honor, I believe the no go to and no contact order are sufficient.
But it's an aggravated stalking that may begin with electronic communication.
Understood, Your Honor. I just wanted to make the request.
Response?
Your Honor, I would object to any bond. This is an aggravated stalking which he violated a PO. I have concerns about the victim and would ask that the tether remain on, given he already violated a court order to initiate this case.
Well, okay. Motion for bond reduction or bond modification is denied. Bond will continue with its conditions. All right, thank you.
Thank you.
Thank you, Your Honor.
I have some. Court does call the case People versus Chad Jones.
I'm Lori Yagi, Assistant Public Defender, with on behalf of Mr. Jones, who's approaching. Mr. Jones, could you state your name for the court?
Chad Jones.
And Your Honor, I did submit, or I did fill out, not submit yet, but a green sheet. Mr. Jones is seeking a global resolution. I am asking for another adjournment. We need some paperwork from some other jurisdictions, but I am asking for a 2-week adjournment for
2 weeks. You'll be able to get everything you think in 2 weeks.
I'm not sure, but I think it makes sense to just ask for 2 weeks at this point.
Any objection?
There's no objection.
Probable cause conference. So, well, I have 10 days out, but you want July 3rd date?
To the preference. Okay, that's fine, Your Honor.
All right. July 3rd, 2025, 9 a.m. Bond will continue. Our close case of People versus Grace Brenner.
Ally Zend on behalf of the people.
Assistant Public Defender Sandra White on behalf of Grace Brenner. Your Honor, I have tried to contact Ms. Brenner. She works through a worker, and the phone number, I think with Avalon Housing, I'm not sure. I don't believe she's missed any court dates, so I would ask for an adjournment.
Your Honor, at this time, I wouldn't object to the adjournment. Ms. Brenner normally appears on Zoom, and Ms. Apple is normally covering her case, so there may have been a slight with Ms. Apple.
Really?
I believe so, Your Honor. She has been at every previous court date.
And I thank Ms. Zenda. We did talk about that, and she said we did.
You two?
And we're hoping
you two
that
rigged this whole thing for an adjournment?
Yes, and we're hoping you agree.
And Ally signed on?
Yes, she's nice. Sometimes.
That implies
Sometimes.
that implies others aren't. Who are you talking about?
We're not going to mention any names.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. without objection. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Paris Lester.
Good morning, Your Honor. Kirma Dadish on behalf of Mr. Lester. Lester, can you please state your name for the record?
Yes, Paris Lester. Okay, so Mr. Deuce, let me explain something about what she did. So she didn't know what a shortstop was the last time we were here.
I have a
I did,
diagram.
hold on. I then sent you a baseball diamond. With, yeah, you got it.
I have a diagram for you
Uh-oh.
for a game that you won't understand.
Oh, no. So now she wants to play games.
That's what baseball looks like to me.
Wow, I'm sorry.
I appreciate that. It's Yellow's turn.
I don't even know what that is. That's what baseball looks like to her?
Looks like a house.
Okay, so I sent her a baseball diamond with all of the positions listed and their number next to them. She's showing it.
Mm-hmm.
The response I get back, I was trying to help her, was she called me a troll. I'm just.
I never said those
no, I'm
words.
just pointing that out what you did.
I never said.
No. You want an adjournment?
Yes,
Yeah,
please.
you may.
There are pending charges that are waiting to be authorized, so we are adjourning.
Additional charges against this defendant?
No, never. Yes, again.
So where are they do we know where they are in the system and how?
Your Honor, we have the warrant request, but I'll have to go through them. There's 3 or 4 of them.
There's 3, okay. And is this then the only thing holding him at this point? No?
No.
All right. Well, what I'll do then is I'll adjourn it out. Let's see where we are. I'll just go 2 weeks out, or basically 2 weeks out to July 3rd, 2025.
And for the record, Your Honor, we are, on his other cases, we are potentially working with CMH.
On
right?
those.
Yeah. Okay.
Got it.
Thank you.
All right. And at this point, it's bond will continue. All right. Thank you.
Yeah, please.
Good. Oh. I don't even know what that name is. That's what she gave me. Put some voodoo stuff. Court goes case people versus Dave Ellington. See, I was trying to help her out.
Ellington? And Jennifer Douglas.
You know what a shortstop is, right? Oh, okay, never mind.
Welcome back, Mr. Allen.
Wow. She said, welcome back. She did? Did she miss you? Huh? Why did she say that?
Well, I
There's
just
something
was
there.
acknowledging that.
No, something's up.
Your Honor, we are requesting a 2-week adjournment for mitigation purposes.
Any objection from the people? Probable cause July 3rd, 2025, 9 a.m. Bond continue.
July 3rd, 7-3, 9 a.m.
Court does call the case of the people versus Tyler Redmond. Thank
Good morning, Your Honor. Intern Malaika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
Oh. So bald head. Permission to practice is granted.
Thank you, Your Honor. Appearing with and on behalf of Tyler Redmond, please state your name for the record.
Tyler Redmond. Thank you, sir. All right, what are we doing?
At this time, we are requesting an adjournment to be assessed for the Drug Circuit Court, which is set for June
The
20.
Drug Circuit Court.
The Drug Treatment Court. Yeah.
Circuit Court. I don't know what that means.
Circuit Drug Court.
Okay, go ahead. Then.
It is set for June 26th, so a date after
So
that.
they would be, they have their meeting on the 26th.
Yes.
Okay. Any objection from the people?
No, no.
July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. What's she do? I have enough to sign. Trying to be fancy. Oh, you got it. Court does call the case People versus Latosha Griffin.
Cameron Dadish on behalf of Ms. Griffin. Can you say your name for the record?
Latasha Griffin. Latasha Griffin.
Your Honor, we are going to be setting this for preliminary examination. Please.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the first. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond continue.
Thank you.
Court does call the cases of the People versus Leo Stringa.
Andrew Banish for the people.
Hannah Mackey on behalf of Mr. Stringa, who is approaching to my right. Please state your name for the record.
Leo Stringa.
Your Honor, we're respectfully requesting an adjournment to write up a plea offer form.
To do what?
We need to write a plea form.
Is this the only thing holding him? Why is every question I ask her a mystery?
Feel the same way sometimes, Your Honor. Said I feel the
Your
same
Honor,
way
it's
sometimes.
Wow.
It's not the only thing holding him in this county.
Pardon?
He has other holds in other counties.
Other
But in this
In
county.
this county, this is the only.
Probable cause conference, July 3rd, 2025, 9 a.m. Bond continue. Did she give me a green sheet?
Oh.
Do you have a green sheet? Or you're just gonna hold it?
No, I'm gonna fill it out.
Oh, you haven't even filled it out. Okay, so so the correct answer to that would have been no.
Green sheet. Technically, I have a green sheet.
This is like riding that bus. Demetrius Griggs.
Allie says on behalf of the people, Your Honor.
Stephanie Can on behalf of Ms. Griggs.
Ms. Griggs, could you please state your name for the record? Demetrius Griggs. And Your Honor, we are just setting this for a preliminary exam.
Discovery complete.
To my knowledge, Your Honor, yes.
People have their witnesses available the first.
We'll do our best, Your Honor.
Preliminary examination, July 1st, 2025, 9 a.m. That's before Judge Barr.
7 a.m. before, it's here. Okay, I understand. Yes.
Bond will continue. Thank you.
Thank you.
Court does call the case People versus Larry Hickman recall.
Thanks for the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender, Chinazi Carriac Worley, on behalf of Mr. Larry Hickman. Mr. Hickman, could you state your name for the record, please?
All right.
Your Honor, today's date and time set for a probable cause conference in this matter. The people did send over an amended complaint. I think he would need to be arraigned on the additional
Yes, he needs
charges.
to be arraigned on counts 3 and 4. You waive their formal reading.
We do waive formal reading of that, Your Honor. We stand here asking the court to enter a not guilty plea on Mr. Hickman's behalf.
All right. Been enabled to waive formal reading, standing mute to counts 3 and 4. Court will enter a not guilty plea.
Thank you, Your Honor. And in regards to the probable cause conference, we'd like to set this matter for preliminary examination, Judge.
You want this set for the prelim?
Yes, please.
And you're satisfied with discovery, even with the added counts?
Yes, we are, Judge.
All right. People have their witnesses available to first? Preliminary examination will be set July 1st, 2025, 9 a.m. That's before Judge Perry. Bond will continue. Thank you.
Thank you, Judge.
Court does call the case of the people versus Alicia Henderson.
Assistant Public Defender Chinazi Carey, I can really, Your Honor, on behalf of Ms. Arlisha Henderson. Your Honor, she is not here right now. We have spoken to her. She's
What do you
en
mean,
route.
not right now?
She's just not here right now, Judge.
What does that mean?
She had an appointment this morning. She's pregnant, so she did have an appointment that she could not miss. But she says she's en route.
Oh, I'm supposed to have some sympathy.
No, I don't, that's not what we expect, Your Honor. I'm just giving.
That's not, she doesn't. Really?
If you'd
Well,
like,
no,
it would
you
be
go
nice.
ahead. I will let you make your argument.
It's Judge,
Your client's pregnant, had a medical appointment this morning?
that's correct,
Are you
Your Honor.
sure?
I am, well, that's what she's told us, Judge.
Oh,
Yes. So we did speak to her.
so you
She-
want me to issue a bench warrant?
I absolutely not, Judge. I'd ask that you pass this matter and see if I can get an ETA for her.
Why do I have a feeling this is gonna end up where she's on a bus?
I don't have pictures yet, but I can. And Judge, we do have a resolution in this matter too, but.
Specifically restorative.
I don't know what that is, but it's fine. I'll pass it.
Thank you so much, Judge.
Court does call the case people versus Dantes Williams.
Alexander on behalf of the people.
Good morning, Your Honor. Hannah Mackey on behalf of Mr. William.
Your name, sir?
Dante Williams.
Thank you.
Your Honor, I believe we would like to set this matter for preliminary examination.
All right. Did you wish to argue the bond? Your bond motion was also
Yes,
put over.
Mr. Brown will do that, if that's okay.
Pardon? Because I believe at this point his bond stands as revoked. Is that right?
That is correct. Can I pass this matter, Your Honor, please?
Yes, this was set for
A bond, yes. Bond
the
violation.
bond as well as I think a PCC, so, but I'll pass it.
Thank you.
Court does call the case people versus Marcus Jones.
April.
Good morning, Your Honor. Constable Mubesa on behalf of Mr. Marcus Jones. In the hallway, Your Honor. Just
Okay.
I just tapped him just to speak.
Find out why they got their hand up. I don't have no idea. Oh, they just put it down.
we say your full name for the record, please.
Marcus Jones.
Thank you. Take your hands out of your pockets, please. All right.
Sir, today is the date and time set for a probable cause conference. At this time, we're going to be requesting for about a month adjournment. My client is to be starting treatment on July 1st, and we would like to show, of course, some progress so that we can get an offer for my clients.
Starting what treatment?
He's starting outpatient treatment.
Yeah.
We're at. Explain to the judge.
CMA, because I was off my medication for like a few years
Okay, so you're working through CMA,
for treatment,
pardon?
for treatment to be compliant with my medication.
Okay. Gotcha. Oh, no, we won't have 24. We don't have 24, we only have the 22nd. All right. Probable cause conference will be adjourned to July 22nd, 2025, 9 a.m. That's a Tuesday.
Thank you, Your Honor.
Round will continue. Thank you. I got one. Court does call the case People versus Dominic Kelly Payne.
Good morning, Your Honor.
Katma Dadish, on behalf of Mr. Kelly Payne, stepping in for attorney of record, APD Alexis Plumai.
Okay. Mr. Payne, state your name, please.
Dominic Kelly Payne.
All right.
Your Honor, I believe Mr. Kelly Payne is supposed to be getting a bed at Spera today, which is the reason for Zoom.
Getting.
A bed at Spera.
Okay. Is that where you are, sir?
No, not currently. I'll be there at 1 o'clock.
So you're requesting an adjournment?
Yes, Your Honor, we're going to be requesting an adjournment. She filled out a green sheet.
Well, I'll adjourn it to July 3rd, 2025, 9 a.m. so we can keep a status on it.
Thank you, Your Honor.
Thank you, Your Honor.
Fine, continue. Thank you. Court calls the case People versus Nicole Knox.
Andrew Dennis for the People.
Your Honor, Alexis Plumai appearing with and on behalf of Ms. Knox. Ms. Knox, could you state your full name for the record? Your Honor, today is the date and time for a probable cause conference. We have reached an agreement with the people. Ms. Knox is going to be pleading to an OWI second, which is a misdemeanor. I believe the court has that plea form.
I do have a plea form that indicates she's going to be pleading to an added count 2 of operating while intoxicated, second offense, a 1-year offense. Upon a successful guilty plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
Yes, that is our understanding as well. And I also have a signed advice of rights and sentencing judge waiver form.
May I have her sworn?
Right hand. You solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Nicole Knox.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense.
Yes.
That's your understanding?
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, up to a $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you will not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
You're on probation. Were you on probation at the time of this offense?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
of your own free will.
Yes.
All right, and because you believe that you are indeed guilty.
Yes.
I do have to advise you, ma'am, that if you do commit misconduct from the time, if I accept this plea, from the time of this plea up until the time of your sentencing, that you would not be entitled to withdraw your plea. You understand that, ma'am?
Yes.
You also understand that any sentence recommendation or evaluation, in this case, the court would no longer be bound by.
Yes. I understand.
All right. All right, on date of February 24th, 2024, at the location of Michigan Avenue near Hamilton Street, city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, you consumed intoxicating liquor.
Yes.
What did you have and how much?
I had one margarita.
Pardon?
I had one margarita.
One margarita?
Yes.
All right, were you stopped by the police or was there an accident?
No accident. My car had, my axle had broke.
Your what?
My axle.
The axle on your vehicle broke?
Yes.
Okay.
So I couldn't move. I was stopped by the,
Yeah, usually you can't move without an axle. Did the police arrive?
yes.
Were you ultimately arrested?
Yes.
Were you taken to the hospital or were you taken to the police station?
Both.
Was there a blood draw?
Yes.
What were the results of the blood draw?
Your Honor, it was 0.173.
0.173.
Yes, the blood draw.
How big was this margarita?
It wasn't that big.
It wasn't that big? You got to a 173 with one margarita.
I think I had drank it the day before or so.
Do you have any reason to dispute those blood test results?
No.
Had you previously been convicted of operating while intoxicated on or about August 13, 2014 in the Third Circuit Court, and of operating while intoxicated on or about July 6, 2025 in the Third Circuit Court?
Yes.
Counsel, are you aware of any other threats, promises, or inducements that have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court ruling? Would it be proper to accept this defendant's plea guilty to this charge?
Yes, people are satisfied. Thank you.
Yes, Your Honor, the defense is also satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and screening assessment is ordered. Sentencing in this matter will be
July 23rd, 5 at 10 a.m.
July 23rd, 2025, 10 a.m. before Judge Barr. Are you on a tether or SoberLink?
Soberlink. And Your Honor, just to clarify, I apologize that I don't know this, do you refer to CCOP or Von Schwartz for, screening pre-sentencing?
Well, this isn't mine, so you're gonna have to ask
Judge Barr.
Judge Barr's court who they go through.
Okay,
Bond with its conditions will continue.
thank you.
It's like a festival site. It was one? Oh, that ain't right. That's a big old margarita. Yeah, please. Maybe we could order one for the room. Court calls the case, People versus Quincy Jones, both cases.
Andrew Dennis for the people. We're ready in this matter.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Jones, who appears to my right.
Good morning, Your Honor. Lauren Brown, Deputy Chief Public Defender, also on behalf of Mr. Quincy Jones, and 21F1057.
Yes.
Your name?
Quincy Jones.
Counsel approach. Okay, in these matters, the record should reflect we've had a bench conference in this case. And I informed counsel that yesterday I had issued a warrant for Mr. Jones because he hadn't shown up and hadn't been testing. We had already been through this with Mr. Jones before. I released him. He assured me that he would do it. I reinstated his previous conditions. That was on June 5th, and we've not seen him test since. So what I will do, and we had talked about adjourning this matter out, counsel's checking into some other options, I guess, maybe for Mr. Jones. I'll adjourn this out to June 26, 2025, 9 a.m. You might want to eat your Wheaties that day. It's going to be a long one. June 26, 2025, 9 a.m. Defendant's bond at this time is revoked.
Thank you so much, Your Honor.
All right, defendant's remanded. Court does call the case People versus Sheldon Lewis. Those are recalls. Sheldon?
And our Assistant Public Defender Carson will base on behalf of Mr. Lewis.
Andrew Dennis for the people.
Your Honor, I just did receive a message saying that he's on his way, that he's on the bus. He's been.
No, you didn't.
I got it here.
No.
I got it right here.
No.
I've got it right here.
You had the nerve to come up and tell me on a bus.
May I approach you?
No. Is that really what you're telling me?
That's
Did
really,
you talk?
That's really what I'm telling you.
Where's what's your name?
I wouldn't make
No.
this up. I wouldn't make
Wouldn't
this
make it up?
I would not. Not in front of you.
Another judge you might. Okay, I get you. Where's a bus from where?
Your Honor, I know he's in Ypsilanti. He's on his way here. I
Where's
just received another.
Did Mackie tell you to say that? You don't know where he's coming?
I know he'll be here soon, Your Honor. If we could just briefly pass the matter.
You know he'll be here soon?
Yes, I do.
You have no idea if
I received assurance from his daughter that he's on his way here just a moment ago.
From where?
From Ypsilanti. She said he left about an hour ago. So I assume he'd be here very soon.
Just take a bus that long? I don't know. Ask Mackie. Mackie, does it take a bus that long?
Yeah.
It does?
I took a bus.
No, you didn't. No, I don't know. I don't even know why you're saying that.
I don't normally ask this of you, Your Honor.
No, you would. You absolutely would. I'll pass it.
Thank you, Your Honor.
If he doesn't show up, I'm putting you on a bus.
Fair enough.
Been a day. Court calls the case, People versus Derek Martin.
Stephanie, oh. Stephanie Cannon on behalf of Martin.
Really?
Oh, I didn't even look, Your Honor.
Oh.
Your Honor, my client is expressing his sincere.
Do they not make them as they go under the ground anymore?
From here on out, but the shoes are nice.
What?
Your Honor, we're just
You
requesting.
like the shoes?
I like
Hey, Candace.
I
No,
like
I don't want to hear about it.
We are requesting a 2-week adjournment. My client is of the understanding and knowledge that from here on out, he will dress in appropriate court attire.
Without a doubt.
Probable cause conference, July 3rd, 2025, 9 a.m. Bond continued. Court calls case, People versus Kevin McCullough.
Take the county to the people, Your Honor. We're ready in this matter, Your Honor.
Owen Brown, Deputy Chief Public Defender, appearing on behalf of Mr. McCullough. Your Honor, we received a communication from Mr. McCullough this morning.
He's on a bus coming down.
Not in a bus, Your Honor. He is at the Trinity Health, the hospital. He does not have a release date. I was able to share the information sent with the prosecutor, Mr. Kennedy. We're asking for a 2-week adjournment in this case.
That, Your Honor, it may explain why he didn't appear at community corrections, given that I believe he's checked in.
How long's he been there?
6:15. I believe is what you showed me.
Yeah, 6:15 is the date.
Well, if he's been there since 6:15, he didn't report to community corrections as previously ordered, and that was before that date. So that wasn't the reason for his failure to go over to community corrections.
Well, maybe he was feeling ill before that. Your Honor. You know, us men, we like to procrastinate and going to the hospital.
Okay, so here's what I've done. I'll adjourn it out. But he already has a bench warrant out because of his failure to appear. So I'm going to leave the bench warrant outstanding. I'll adjourn this. I have the thing for Trinity Health now, but I'll adjourn the probable cause to July 3rd, 2025, 9 a.m. So they'll have to do that, and then maybe I'll lift it.
Thank you, Your Honor.
Thank you, Your Honor.
What is she handing you? This is Mr. Brown on this case. She's handing you another green sheet on what? Something she didn't do before? Like all the way it's already gone, she's just handing it in now? Why? That's an old green. It's like that case was like hours ago, Mackie. That's all you got. Court calls the case, People versus Joseph Trim.
Said on behalf of people, Hannah Mackey on behalf of Mr. Trim. Oh, he's in the hallway.
Good morning, Your Honor. Edward Dukes on behalf of Mr. Trim, who is approaching.
Your name?
Joseph Trim.
Thank you. Really? What?
Your Honor, if we could ask this for a moment, I didn't know I knew he was out of custody, but there's an argument regarding bond that I want to go over with him prior to discussing. I'd be asking for an adjournment, but I do know there's a bond argument as well.
He's out. You want, okay, fine, I'll pass it.
Okay, thank you, Your Honor.
Court calls the case of People versus Mikeisha Melchor.
Andrew Banish for the
Lori Yagi, Assistant Public Defender, written on behalf of Mr. Melchor. Am I saying that right? Ms. Melchor?
Yeah.
Ms. Melchor, who's standing to my right. Your Honor, I do have a green sheet. I'm very hopeful that we're very close to a resolution. Ms. Melchor, I'm expecting documentation by the end of the day of her intensive outpatient treatment program. So I am asking for a brief.
July 3rd, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Lanish Mitchell.
We're ready in this matter, Your Honor. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Mitchell.
Is that how we have it set?
Yes.
Okay.
What's that?
All right, what are we doing?
Your Honor, upon speaking with Ms. Mitchell, I think it would be necessary for us to adjourn the probable cause conference. We need to do some further investigation based on the information we've received.
All right,
Asking for an adjournment.
I'll need a green sheet. Any objection? July 3rd, 2025, 9 a.m. Bond continued.
And we do want to address one aspect of bond. What's the date? June 19th? And where do you have to be? Your Honor, my client has a dance team. She is a verified dance mom. They dancing.
Dance mom, dance coach.
A dance coach and a dance mom. So her team is going to be, I guess, competing in Minnesota on June 19th. And she'd like permission to be able to travel with her team so that they can, do their thing.
You'll see us on YouTube.
I'm sorry?
You'll see us on YouTube.
You can see us, you guys on YouTube? Yeah, me too. So. Are they any good?
Best.
Yeah, we're the best thing.
Why are you saying, have you seen me?
What?
Have you seen them?
It's my client. I did all the way. They're gonna win.
Yeah.
So when does she want to go to Minnesota?
Well, the event is on the 19th, so
Pardon?
tomorrow morning. We're gonna drive.
Till when?
After the performance is over, and we'll head back.
That doesn't tell me. I need a day. Is it gonna be that same day?
21st. It's a 10-hour drive, so it's 10 hours.
Why is everybody explaining all this to me? I understand how far Minnesota is.
Okay, well.
I just need to know, when do
21st.
you want to
after, like,
go?
Tomorrow morning. Yes,
Till
the 21st.
And the good news, Your Honor, is she won't be taking the bus.
That was great.
It's on this one.
Could have made it.
All right, defendant may travel to Minnesota the 18th through the 21st inclusive for dancing.
We teach
Is it a
everybody.
competition?
It's a performance for the Juneteenth parade, so.
Oh, well, you should have led with that. I mean, fine.
I was letting him talk.
Oh, you shouldn't do that. All right, yeah, absolutely, you can go now.
Thank you.
All right.
All right, thank you.
Good luck to you.
Thank you.
Troy. Court does call the case People versus Keith Moore.
Andrew Banish for the People.
And Alex Warren Green on behalf of Mr. Moore. Does the court see Mr. Moore on Zoom? I'm not sure if you. Okay, Your Honor, I talked to Mr. Moore's,
Down the bus with the other guy. Is that what you're gonna tell me?
No, I talked to his community mental health caseworker. She says that Mr. Moore is having some mental health issues right now. I understand CMH has the court's Zoom link, so I wasn't sure if they were going to log in. Your Honor, I'd ask for either an adjournment so that I can, so we can get him to a better place and I can evaluate his competency, or ask the court to pass this matter so he can appear on Zoom. Thank you, Your Honor.
I haven't said anything. I'll pass it.
Thank you, Judge. I appreciate that. I will get in touch with his caseworker right now.
Go on.
Thank you, Your Honor.
It's not going. Court calls the case People versus Megan Moses.
Anna Mackey on behalf of Ms. Moses, who is appearing via Zoom.
Andrew Banish for the people.
Oh, sorry. Ms. Moses, please state your name.
Hi, Megan Moses. Sorry, I've got a puppy in the background.
Did you?
That's her.
Okay. Your Honor, we're respectfully requesting to adjourn this matter to give Ms. Moses more time to pay restitution off.
The rest, so how much more time is she gonna need to pay it off?
We're still in discussion about how much the restitution actually is.
So we don't even know how much she's supposed to pay?
We do not.
Well, from what I've
When are we
heard,
gonna get that? When are we gonna get that information?
I think there was supposed to be a restitution hearing first before we move forward because there was some issues with what the amount was.
The amount was conveyed, but there was a dispute from the defense with the defendant about it. So I would.
And so how's she gonna pay if you guys aren't I mean, what are you guys trying to do? Besides irritate me.
Your Honor, we were given a number at her second hearing, I believe, and then the number increased by a couple $100 somehow at the third hearing. So
I feel like there's more to it than that. What I've heard and what I talked to with a public defender yesterday was she was also adding her therapy costs and her lost wages for going to therapy. So the restitution I was going to start a payment plan and then the restitution just kept going up and up. So the payment plan wasn't going to work. And it's just above and beyond what I can even afford without having a steady income or a vehicle or a car, or even a steady home at the moment. So that's why we were going to have the hearing. So it could go back to just the fines and costs. And
what hearing are we having?
Your Honor,
other than this one, which is going nowhere?
Can we adjourn this matter so we can, Ms. Moses?
Yeah.
Can we adjourn this matter so we can discuss with the prosecution what to do moving forward?
Yeah. All right.
July 3rd, 2025, 9 a.m. We can't do anything. You need to set this for a restitution, or not a restitution here, or exam, because I mean, if there's not going to be an agreement on a number for her to pay and then get a deal, we're wasting time.
Thank you, Your Honor. And may I request to address bond, please?
To what?
A bond modification. May I request to address?
Oh, now you want a bond modification. Go ahead.
Your Honor, Ms. Moses was placed on a tether in April, I believe, for a failure to appear to a court hearing when she did not have access to the internet. She has complied with all of her court orders since then. She has shown up to all of her hearings since then. So we asked this court if she could remove the GPS tether. Moses ride the bike to work, and it gets in the way of that as well. It just chafes her leg.
Any response from people?
Yeah, I'll leave that to your discretion. My main concern is that the, any or all no contact orders remain.
I'm gonna deny the modification at this time, and we can address it on the third, potentially, and then figure out what we're doing.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case, People versus Nicole Nelson. You weren't.
Oh, not true.
Good morning, Your Honor. Student Attorney Andrea Sabri on behalf of Mr. Nicola Nelson.
Oh, Andrew Vanderson, excuse me.
Your Honor, Mr. Nelson is not present. I have made multiple attempts to contact him, but I do not have an explanation regarding his absence, unfortunately.
Bench warrant will issue the defendant's failure to appear. Bond in each of these cases will be set in the amount of $10,000 cash surety. Warrant will issue immediately.
Thank you, Your Honor.
Court does call the case People versus Antoine Patterson.
Chicken candy for the people, Your Honor.
Assistant Public Defender Sandra White on behalf of Antoine Patterson. Please state your name.
Antoine Patterson Senior. Thank you.
Yeah, and I've been talking with the prosecution, and I believe Mr. Bellinger has been handling this matter, and we're asking for an adjournment. They're still waiting on CPS reports.
Do we have any idea when those might be coming?
No, but we'll look into it.
The green sheet, July 3rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Taiwan felon.
Phelan, this is your name for the record.
Tawana Taylor.
Thank you.
Your Honor, we are going to be setting this for preliminary exam, please.
All discovery is complete.
Yes, Your Honor.
People would have their witnesses available the first.
Yes, Your Honor.
Preliminary examination will be set in person, July 1st, 2025, 9 a.m. That's before Judge Barr. Bond will continue.
Thank you, Your Honor.
Court calls case of the People versus Tyler Pittman.
Andrew Vanderson.
Your Honor, Alexis Blumey appearing with and on behalf of Mr. Pittman. Mr. Pittman, could you say your full name?
Tyler Pittman.
Your Honor, we are requesting an adjournment at this time. We did recently provide the people with a mitigation report, so they will need some time to review that, and hopefully we can negotiate an offer. And I do have that green sheet here.
July 3rd, 2025, 9 a.m.
Your Honor, would it be possible to actually go out one more week? Mr. Pittman stated he has trouble getting off work and school on 2 weeks' notice, so if we could go 3.
Is that correct, sir? July 10th will give you enough time then?
Yes, sir.
All right, July 10th, 2025. All right, thank you, sir.
Thank you.
Court calls case People versus Jeremy Schultz.
Assistant Public Defender, on behalf of Mr. Schultz, he's in Wayne County Jail. I'm not sure if, I know it was adjourned previously to writ him out, or at least that's what my notes say. That being said, I was going to request an adjournment anyways, because he just had court yesterday in Wayne County, and so he is going to be held in Wayne County until July 7th, which is his next court date, his sentencing in Wayne.
July 7th.
Correct.
I did send the red email, I think it was.
Oh, that makes sense.
Well, if I set it for the 3rd, he doesn't have court on the 3rd.
Correct.
July 3rd, 2025, 9 a.m. That way it'll be enough time for a writ.
Thank you, Your Honor.
Court calls the case People versus Kirby Snyder.
Stephanie Han on behalf of Ms. Snyder.
Hello, what's your name? Thank you.
And Your Honor, we're going to ask for I think I put a 3-week adjournment on there. We're going to have her screened for sobriety court, but we're also looking to negotiate with the prosecutor on this matter.
July 10th, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Case of the People versus Matthew Vermillion.
Bailey's on behalf of the people, Your Honor.
I'm Lily Gagne, Assistant Public Defender with and on behalf of Mr. Vermeulen, who's standing to my right. Could you state your name for the court?
Matthew Vermillion.
And Your Honor, we are respectfully requesting an exam date in this matter. I do believe discovery is complete.
People have their witnesses available the 1st. Preliminary examination in person, July 1st, 2025, 9 a.m. That is before Judge Perry. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Cynthia Weber.
And Alex Warren Green on behalf of Ms. Weber. State your name, Ms. Weber.
Cynthia Weber.
Your Honor, today's date and time for probable cause conference. I believe we have reached a resolution. I have a plea form from the people right here.
I don't have it.
Thank you.
She'd be pleading to operating while intoxicated, second offense.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Cynthia Weber.
All right, ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration, up to $1,000 fine plus court costs. The court could order community service or any rehabilitative program support deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, ma'am?
Yes. Sorry.
And understanding, and I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 1483 District Court. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
Probation.
Were you on probation at the time of this offense?
Yes,
All right, I do have to advise you that your entry or plea in this case could be a violation of that probation. You understand that?
yes,
You understand that if it is considered a violation of that probation, that other court could sentence you to the maximum allowable under the other charge. You understand that?
yes.
And understanding that, you still wish to plead guilty?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No,
Anybody threaten you or coerce you?
no.
You're doing this voluntarily
Yes,
of your own free will
yes,
because you believe that you're indeed guilty of this offense?
yes.
I would also have to advise you, ma'am, that at the time of this plea, if it is accepted in time of sentencing, if you do commit misconduct, then any sentence recommendation or any agreement or evaluation is basically voided and court is not obligated to follow that. You understand that?
Yes,
You also understand that if you do commit misconduct, you would also not be entitled to withdraw your plea.
yes.
Hang on. On the date of December 30th, 2024, at the location of Hadley near Bartell in Linden Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes,
Prior to operating that motor vehicle, did you consume intoxicating liquor?
yes.
What'd you have and how much?
3 to 4 beers as well as 4, maybe 5 shots.
Were you stopped by the police or was there an accident?
Tree accident.
You ran into a tree?
Yeah,
Did the police arrive?
yes,
Were you taken to the hospital?
yes,
Was there a blood draw?
yes.
And what were the results of that blood draw?
0.112, Your Honor.
Do you have any reason to dispute those blood test results?
No,
Counsel, have there been any other promises, threats, or other inducements which have led to this plea that were not stated on the record?
None from the defense, Your Honor.
No.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
August 4th, 2025 at 9 a.m.
August 4th, 2025, 9 a.m. before Judge Freshour. Bond will continue.
thank you.
Thank you, Your Honor. I provided the court with a referral to the sobriety court. This plea is in no way contingent on her screening or acceptance, but I'd ask the court to consider signing that. I talked to probation with the sobriety court and they advised that they could complete a screening between today's date and the sentencing date.
All right.
Thank you, Your Honor.
Court calls case People versus Taylor Adams.
Advantage to the people.
Right. Your name, sir?
Taylor Adams.
All right.
Your Honor, I retained an attorney, but this is now his second. He didn't show up the first time, and now it's the second time that he hasn't showed up. So I'm asking for a public defender, please.
All right. When you say you retained, did you pay him money?
No, his check is here.
Pardon?
His check is here. That's what I was gonna do the first time. Give him the money when he gets here. His office is out of Grand Rapids.
Oh. The public defender case.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Adams. Your Honor, we're requesting an adjournment.
Which,
I apologize. I received Mr. Adams' contact information. We just need an adjournment to receive discovery, review it with our client. I'll complete a green sheet for the court. I apologize.
yeah, I'll adjourn this out to July 3rd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
We'll be in touch. Okay. Court does call the case People versus Willis Cherry.
Jennifer Douglas for the people.
David I. Goldstein appearing on behalf of the defendant. State your name, sir.
Willis Cherry.
Your Honor, I'm prepared to ask for a preliminary examination, but I did inquire of Ms. Douglas whether there are any, I do have the written discovery. I don't know if there's any videos. If there aren't, we're ready to go to an exam.
There are videos.
How soon can you get to defense counsel?
I'm showing this as having been discovered, so let me.
Yeah, that would have been to public defender's office.
So I guess it went to the public defender. I can get that done.
Probable cause conference. Are you available the 3rd?
I'm sorry, Your Honor?
Are you available the 3rd?
Yes.
July 3rd, 2025, 9 a.m. Bond continues.
Your Honor, with regard to the issue of the bond, and I'm sorry I didn't get a chance to talk to Ms. Douglas about that. Mr. Cherry is employed, and a lot of his employment is in Lucas County, Ohio, the Toledo area. He is on probation to a district court. They have already given him permission to travel to Ohio, but that's conditional upon you granting that permission also.
Any response from the people? What district court granted him?
15th, Your Honor.
Or is okay with it. I won't.
Really? Okay. I'll indicate that defendant may travel to Ohio for work purposes.
Thank you, Your Honor.
Thank you, Your Honor.
Yeah, I will.
My last. Oh. Court does call the case People versus Antoine Pitts. Just that one again.
Ms. Douglas, call Pitts, Antoine Pitts.
Jennifer Douglas for the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, Mr. Pitts is having some health issues. He has been recently diagnosed with lupus. He has a probation violation in front of Judge Hammoud. The public defender has been presenting to Judge Hammoud notices from the doctor regarding he's been ordered to bed rest and oxygen therapy. I was hoping to have him, I have several of them on my phone. I was hoping for a more recent one. The most recent one I have is from May, but they've indicated he has lupus and has issues with breathing.
Yeah, but we keep letting him out. He doesn't appear. The last time that you were here, I think I told you I was leaving the bench warrant out. I was waiting on medical. I never got any medical to indicate anything.
Okay, I can get those to
And
the
I
court.
left the bench warrant out. And now he goes through the arraignment process, gets released again, supposed to get to community corrections, doesn't go.
Your Honor, I'm assuming he's not going because of his medical problem.
I don't know that.
I was, okay, I'll get that stuff to you, Judge. I've got some of it.
I already issued this bench warrant.
Yes.
He's already got a bench warrant outstanding at this point.
Okay, I'll get the medicals to you as soon as I can, Your Honor.
All right. So I'm just going to leave the bench warrant out. I'll give a new date on it, but July 3rd. And if he shows up, he shows up. But otherwise, in the interim, there's a bench warrant that's outstanding.
And you'll have the medicals before then, Your Honor.
Recalls the case People versus David Witherspoon.
Joe Simon on behalf of Mr. Witherspoon, Your Honor.
What's your name again, David? David Witherspoon?
All right. The issue in this case is I did call over. There are no other violations, correct?
That is correct. One you missed. There was a late test.
There was a late test yesterday. Why?
It was 7 minutes. Well, I asked my client and he basically told me he was worried he was gonna go to jail today and he was just.
Well, he should be.
Yeah, because I told him to be. And, but anyway, he has he missed the time slot. And then, just no good explanation other than he just missed, and then he panicked and tested 7 minutes later. But he also wants to let you know he tested this morning too. And there was no violation.
Anything you want to say regarding this bond violation? Because I don't even understand.
He had a bad day and night where he's going to admit drinking alcohol. So that was June 3rd, segue into the morning hours of June 4. And since then, he's been completely compliant other than that 7 minutes. He also wanted to go over to a scram tether because he's so panicked about missing times, etc. He's maintaining that since he'll admit to drinking on the 3rd, but since he's been completely sober also. Regarding the case, we've reached a resolution between the parties, but I just checked with Mr. Heaton, who was here today from the 14A court regarding sobriety court screening. And I know what my client needs to do. If we resolve the matter the way that we principally constructed, I want to get my client screened and accepted into the sobriety court in 14A first. And I think that will only help him in his issues. If in the interim, he can be on a scram. And if all of that is acceptable to the court, I'd request July 17, because it's going to require a few things for him to get done before being accepted.
Mr. Allen, I will adjourn the probable cause to July 17th, 2025, 9 a.m. The defendant having admitted to the violation, I'm going to sentence the defendant 7 days into Washtenaw County Jail. So he'll be released and then can do that upon his release. He's to be placed on a scram tether prior to his release.
Thank you. So, Your Honor, my staff will try to make arrangements with the community corrections in my absence to make sure that he gets that before release. But in the court, as the court knows, sometimes we have trouble with that. Is there anything?
Well, we will prepare an order that needs to be placed on the scram prior to release.
I'm saying for community corrections, the jail always is aware of that, but sometimes community corrections doesn't know to do that. You know what I'm saying?
They're supposed to be contacted, I think, by the jail. That's how that's supposed to happen. But
I've had trouble with that before. We'll do all we can. Thank you very much, Your Honor.
if you have an issue, let us know.
Thank you, Your Honor. That was July 17th. Thank you.
Yes. Court calls the case, recalls the case, people versus Alicia Henderson.
Andrew Banish for the people.
Are we ready on that?
I'm gonna say no.
Court calls case, people versus Dantes Williams. Are we ready on that one?
Yes, Your Honor.
Well, they call for him. Court does, well, that one's coming out. Court calls case, people versus Sheldon Lewis. Is that? This is on the bus.
Yeah.
Sheldon Lewis? Oh. Was he driving the bus? Yeah. Or he wasn't driving it, but.
You're ready on this matter, Your Honor, and here he is.
Here he is what?
He was on the bus and he came.
I know. Did he leave all of his pants on the bus?
Yeah.
We won't have that happen again, will we?
Assistant Public Defender Costin Obasi on behalf of Mr. Sheldon Lewis, who was present to my right. And you say your full name for the record, please?
Yes, Sheldon Lewis.
Your Honor, we're going to be requesting an adjournment for some video discovery that our office has not yet received.
July 3rd, 2025, 9 a.m.
July 3rd.
All right. Oh, that, yes, that's right. Court does call the case People versus Dantes Williams.
Ally Zend on behalf of the people, Your Honor.
Ron Brown appearing on behalf of Mr. Williams, Your Honor.
All right, I have before me a plea form in this case that indicates that the defendant is going to be pleading guilty to an added count 4 of aggravated domestic violence to 1 year. Upon a successful plea to that charge, counts 1, 2, and 3 would be dismissed. There was some issue because part of this case had been bound over, but then the case got set back for further testimony regarding an additional charge. I spoke directly with Judge Slay. What she had indicated is that those counts, so after I take this, because those counts exist in circuit court, there would have to be a nollie pros filed with the circuit court to get rid of those cases. I can dismiss them here, at least as a record, but those cases are up. All right.
Your Honor.
Yes.
Also, I believe party stipulator agree that he would receive sentencing under section 7694A.
Yes, that is on the plea form.
And that he would agree to no contact with
Or
Ms.
no, not to contest her PPO.
Exactly, Your Honor. Which has already been done.
Kevin sworn.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Dantes Williams. All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of aggravated domestic violence. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
All right. You have signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No question, sir.
Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes.
of your own free will,
Yes, sir.
and because you believe that you are indeed guilty of this offense?
Yes.
Yes.
Yes, sir.
I also have to advise you that if there's any misconduct committed by you between the time of the acceptance of this plea and the time of your sentencing, that you would not be entitled to withdraw your plea. You understand that, sir?
Understood.
And you also understand that any sentence recommendation and or evaluation, which may include the 7694A assessment, would also not have to be followed by the court. You understand that?
Yes, sir.
Counsel, is counsel aware of any pleas, promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And has the court complied with the court rule on would it be proper to accept this defendant's plea?
Do you need a basis? For the
Pardon? Did I not take a factual?
Factual.
You're right. I was so concerned making sure I complied with the new court rule that I haven't. I do have to take a factual basis. It's not in front of me. Thank you, Mr. Brown. On the date of April 2nd, 2024, at the location of 2017 Medford Road in the city of Ann Arbor, Washtenaw County, state of Michigan, what did you do on that date involving a Zaylen Gaynor that makes you think that you're guilty?
We got into an altercation and I scratched her.
You what?
I scratched her face.
All right. And who is she to you?
Oh, she was my girlfriend at the time.
All right. You didn't have permission to lay your hands on her in that fashion on that date, did you?
No, sir.
And it was not an accident on your part?
No, sir.
Counsel, have I complied with the court rule now? Would it be proper to accept this defendant's?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea. You count for counts 1, 2, and 3 are dismissed, although 1 and 2, there needs to be the nolly filed circuit court. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
July 9th, 2025 at 9 a.m.
July 9th, 2025, 9 a.m. before Judge Barry.
Your Honor, may I address bond?
You may.
Your Honor, my client tells me he's been in jail about 9 months. Is that accurate?
Maybe. I don't know.
Oh, strike that. Strike that. He has not been out 9 months. Now that he's pled to a misdemeanor and the felony charges have been dismissed, I'm asking the court to consider release custody possibly on a tether so he can get back to work. He would stay at 19963 St. Aubin in Detroit, 48233, and have no contact with the complaining witness.
I don't need a response because I'm not going to release him prior. You can take that up with Judge Perry after after he's seen by probation for a screening assessment.
Yes, Your Honor. So bond continues, but once you're seen by probation, call our office. We can take a motion up in front of Judge Perry. Here's a reminder of your court date and time.
Thank you.
Thank you. Go with the court office.
Court calls the case, People versus Joseph Trim.
Allie Zend on behalf of the people, Your Honor.
Thank you for that pause, Your Honor. Edward Lucas on behalf of Joseph Trim, who is approaching. Joseph Trim. Your Honor, I just was appointed to this case. I'm asking for an adjournment to obtain discovery and like to address his tether bond condition.
Go ahead and address the tether. I'll grant the adjournment.
Your Honor,
July 3rd, 2025. 9 a.m. Yes, that's the bond.
Your Honor, as to bond, he has the tether and a no-go to an address on International Drive. It's his parents' residence. The parents are not associated with, I guess, the charges in this case. It's because of the complaining witness lived on the either below or above his parents. And so he has a no-go to there. His parents are relatively dependent on him for medical care for his father who has cancer. It's our understanding that the complaining witness has moved out of town and is no longer living at that residence and since been rented to another individual. I've told this to the prosecutor's office. They may be objecting to have it.
Pardon?
I believe the prosecutor's office is objecting. I don't think they've confirmed that yet, but I'm attesting to the court that that's the case and that she has moved.
That's correct. We have not had confirmation that she's if we do get confirmation that she has moved, I would be willing to do a stipend order, but at this time we don't have confirmation that she's out of that residence.
So at this time, what I'll do is I'm going to deny your request for any bond modification or change.
Okay.
Subject to seeking some type of confirmation regarding that.
Okay.
That'll be handled by step. Okay.
Thank you. Thank you.
Bond will continue. Thank you.
Thank you.
Court recalls case of the People versus Keith Moore.
Excuse me, Andrew Bannis for the people.
And Alex Warren Green on behalf of Mr. Moore. Your Honor, I'm not sure if he's on there. If he's not, I have not.
Alex Moore. Or Keith Moore, excuse me. Keith Moore. No response.
And Your Honor, his caseworker has not got back to me. I appreciate the court's accommodation.
Will it this time issue a bench warrant bond 10,000 cash here? That warrant will issue immediately. All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 district court.
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, that you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
Were you on probation at the time of this offense?
Oh, no, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you?
No, no, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will,
Yes, Your Honor.
and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
June 24th, 2022, at the location of Ann Street on Eastern Michigan's campus. What did you do that makes you think that you're guilty?
It was some copper that was in the bin. It didn't belong to me, Your Honor. It did.
There was copper in the bin and you took the copper out.
That did not belong.
That copper did not belong to you.
Yes, Your Honor.
Was the value of that copper in excess of $200?
Yes, Your Honor.
All right. Sir, I also do have to advise you that if I accept your plea between the time of your plea and the time of your sentencing, that if you commit any type of misconduct, you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
And also that if you were to commit misconduct, the court would not be bound by any sentencing agreement or evaluation. You understand that?
Yes, Your Honor.
All right. Counsel, is counsel aware of any other promises, threats, or inducements that have caused this plea?
No, Your Honor.
None, Your Honor.
And have I complied with the court rule?
People are satisfied.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and reported ordered at 1482 probate. Sentencing will be
July 7th, 23rd, 2025.
July 23rd. Thank you. July 23rd, 2025. What time?
10 a.m.
10 a.m. before Judge Barr.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
You have a nice day.
You too. Court calls the case of the People versus Cody Moore.
Council Lonnie for the people.
And Alex Warren, Green on behalf of Mr. Moore. Mr. Moore, can you state your name for the court? Cody Moore.
Your name, sir?
Cody Moore.
Okay, go ahead.
Your Honor, today's date and time for preliminary examination. At this time, the defense is ready to proceed.
And Your Honor, it is my understanding the defendant does have an active bench warrant out of this court. Is that correct?
Yes.
And I had understood he was in custody in Jackson County. We are not ready to proceed at this time. We would request an adjournment.
The defense would move to dismiss at this time, Your Honor, and if the court has questions about his current status, I can provide some more information.
Go ahead.
So, Your Honor, he was taken into custody by his parole agent to the Jackson County Jail. His parole agent allowed him to be released so that he could make his court date today. We adjourned last time because we were hoping to resolve this prior to coming back to court. Those negotiations, Mr. Moore did not hold up his part of the deal. We came back to court today ready to hold a preliminary examination, and at this time, if the people are not ready to proceed, we would move to dismiss. After speaking to the people, I think my client understands that this case could be reauthorized and it could be taken into custody immediately if the people do choose to go that route and if the court, of course, grants our motion.
He's currently on parole.
Yes, sir. Yes, sir.
People being unable to proceed, this case is dismissed.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Your Honor.
Case of the People versus Javon Smith.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Smith, who's here to my right. State your name, Mr. Smith.
Good afternoon, Javon Smith.
Sure.
All right, what are we doing?
Yeah, this is a date and time scheduled for preliminary examination. I have gone over his absolute right to a preliminary examination with Mr. Smith, and he wishes to waive that exam. We've executed the appropriate waiver form.
Is that correct, sir? Yes, sir. You do understand that a preliminary examination is meaning the people have to show by probable cause that the offense alleged was, or the offense is alleged and committed. Yes. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. Sir, people also waive the right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Your Honor, in terms of arraignment on the information, we'd waive reading, stand mute, acknowledge receipt of the information.
Defendant having waived formal readings, the court will enter not guilty plea. Pretrial in this matter will be set for
August 7th, 5 at 1:30 with Judge Slay.
August 7th, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond.
Have a good day, Your Honor. Thank you.
Thank you, Judge. Court case, people versus Larry Lee.
Your Honor, Mary Tan Haas, Assistant Prosecuting Attorney about the people.
And Mary Rubio, on behalf of Mr. Lee, I am standing in for the attorney of record, David Burgess, with Mr. Lee's consent, to my knowledge. Is that correct, sir? That is okay for me to stand in for you right now?
Yes.
Okay, could you please state your name?
Literally.
What was that noise?
Shouldn't you check? I don't feel safe. Why are you just pointing? What? It'll stop at some point.
I feel very safe, Your Honor.
Oh, I know. He's like, you are all over it. All right, go ahead. What are we doing?
Well, Your Honor, a few things. First of all, I've been in communication with Mr. Burgess and Mr. Arabo, who is representing the victim of the case, Mr. Quasny. Apparently, Mr. Lee called Mr. Arabo and offered to, in exchange of a pending case where Mr. Quasny is the defendant of an AMD against Mr. Lee. Mr. Lee contacted Mr. Arabo and offered to essentially not testify in that case if Mr. Quasny agreed not to testify in this case. There are statements that are essentially saying, in exchange for Mr. Quasny, victim in this case, not testifying, I will also not testify. That is highly concerning, of course. I was given this information yesterday. I asked Mr. Arabo to forward that call to myself, Mr. Burgess, and the officer in charge because we want to document the potential additional charges. But this all happened transpired yesterday. We got the recording as of this morning. With that said, of course, I think it's appropriate to have an adjournment. Mr. Burgess agrees with that.
But does that recording indicate that?
Yes, Your Honor, have either one.
I myself have not listened to the recording. I was just asked to stand in on behalf of Mr. Burgess. He's at a hearing in Lansing. However, I did speak to Mr. Lee about it today. Mr. Lee indicates he indicated some of the content of the conversation to me. He also indicated, just FYI, that he himself recorded it.
But just so that I have this right, the defendant, because of something else, is urging, enticing, or in some other way interfering with testimony of witnesses in this case.
I can't agree to that characterization because I haven't heard it. I don't know.
Well, you want to listen to, because that's what I'm being told.
But yes, I understand. I understand that is what's being presented. I also want to indicate that. Go ahead. I'm sorry. Mr. Lee has indicated to me some things. I have advised him to be careful of what he would want to say to Your Honor, but he seems to feel that he needed to make that phone call because he wants to move to have Mr. Burgess removed and he wants to get a different attorney. Mr. Lee has indicated to me he also wants to address the court. I again did advise him I would not go into the content of that conversation as there could be potential pending new charges. With that said, Mr. Lee, what is it you wanted to say?
Yes, Judge, I indicated to, what's her name?
Ms. Rubio.
To Ms. Rubio that for a little bit over a month, I contacted my attorney, Mr. Burgess, and I instructed him to contact the lawyers from both sides, the prosecution and the other side that represented Mr. Quasny, and I instructed him to offer a plea or to negotiate some sort of settlement, and he indicated that he would do that. He indicated that he had done that. He indicated that he had reached out to Mr. Arabo and the prosecutor regarding making some sort of plea agreement. Him and I discussed what that could be. And so now, fast forward, yesterday, I contacted Mr. Burgess and I said, hey, have you reached out or have you heard anything from Mr. Arabo and the prosecutor? He said, and he indicated that he had not heard anything and that he had reached out to both attorneys multiple times. I knew that to be a lie. I suspected that to be a lie. And I knew that if I were to have him or to ask you to have him removed or substituted, that I would have to prove under Strickland versus Washington that he.
I don't know. Are you a lawyer?
I was,
Mr. Lee, no, to my knowledge, no.
So I knew that I had to prove that he was ineffective. I knew that I had to prove that our breakdown was egregious. So I recorded the call myself. And I called Mr. Arabo and I asked if Mr. Burgess reached out and discussed any sort of plea negotiations. Mr. Arabo said, no, sir. He had not had any communications with my attorneys. So I confirmed with Mr. Arabo that he had not received any communications about any kind of negotiations with any kind of plea agreements on my behalf.
I'm so sorry, Mr. Lee, before he makes more statements.
And I did record the. I recorded the call. I recorded the call.
In his best interest, he might want to listen to this call before he makes any further statements. In the call that was sent to us, there is indication, there's no discussion of a plea. Not what was sent to me. That was reported by Mr. Arabo. There's very clear that there will be no testimony in his case if Mr. Consley agrees not to testify in this case.
So I have the text messages.
Further false statements are made to the court, which is not necessarily a problem for me, but I want to make sure that Mr. Lee's rights are preserved.
I have the text
He
messages.
might want to listen.
You don't know what? That's the third time you've done it. You're gone. Mr. Allen, take him. You better get Mr. Burgess down here because I want to hear those calls because if he's interfered with it, that's going to be a whole other issue.
I will try to reach him, but I know he is in Lansing, so I'm not certain.
Well, even if he appears, like, has Mr. Burgess heard the calls?
I don't know, Your Honor. They were sent this morning. I asked Mr. Arabo to send them right away yesterday, and we received them this morning. Mr. Arabo can also be available via Zoom if necessary.
All right. Okay. I'm just letting you know that what I'm hearing is extremely disturbing.
I completely understand that.
And so I'm gonna give an opportunity for the defense to give me some explanation, but I'm inclined at this point, I'm gonna hold him in custody. I'm inclined at this point to revoke his bond.
I understand.
Okay.
Okay.
All right.
Thank you.
Thank you. Court does call the case, People versus Brandon Carter.
Andrew Tillis, appearing on behalf of people, Your Honor.
Stephanie Cannon, appearing on behalf of Mr. Carter, who I do believe is appearing by Zoom, Your Honor.
For an exam?
Your Honor, the prosecutor and I, yes,
I'm here.
but no.
I'm here. I'm here.
But no, there's a thing, Judge, there's a thing, trust me. So we have decided to, ultimately, we're going to waive it. So we're adjourning for the waiver.
Right here.
Please. T, please.
What do you mean?
So he's going to waive his exams.
Today? Why?
Yes, if you're going to allow it, Your Honor, we'll waive the exams today if you're going
Why
to allow
isn't
it.
he here?
So
Because this is a
Mr.
preliminary exam day.
I understand that, Your Honor. Mr. Carter, how to say this? So he had some things to deal with in Wayne. They picked him up. When they released him, they wouldn't bring him back here because remember, he came here, he was staying at the Lannis. And so he had to go back to Wayne. And then they were like, we don't want you, basically they tethered him there and wouldn't allow him to come back up here. And we found this out this morning and I spoke to the prosecutor about what was happening. And it's my understanding he's okay with adjourning this so we can waive it or we can do the waiver with him on Zoom. Please.
Is he waiving everything up to circuit?
He's waiving everything up to circuit. Everything's going to go up.
Your name, sir?
Brandon Carter.
All right, you're waiving your right to have a preliminary examination in both of these matters?
I don't want to. I don't know what I'm doing. Well, yes.
Which is why we were adjourning it, Your Honor.
He needs to be here. I mean,
I don't want to do the bus thing.
You know what? This took the third case to the bus.
He's not on the bus because when he called me this
No, I
morning.
can see that.
Okay.
There are trees going past the window.
So when we spoke this morning, we discussed what had happened and why he wasn't here and everything that was going on. He was going to get on the bus, but he was like, if I get, it would have been a repeat of the last time because he's in Detroit. And so, Your Honor, we're asking, can we have a 1 week adjournment? He'll get up here for it. He'll come the day before,
Yeah.
but it'll just simply be for a waiver.
This is set for PE. A 1 week adjournment puts it in front of another judge.
We're not going to hold the preliminary exam. We're going to waive it.
I
mean, I understand what you're saying. I do, but I just need to get it to circuit court.
But he says he doesn't want to. Because I can do the waiver with him on Zoom. So if he's going to waive, he can do it now. If he's not going to waive, we've got a problem because he's supposed to be here.
I understand that, Your Honor. And
we wait.
we discussed this, Mr. Carter and I discussed it. He discussed it with my office, the reasons for it. I do believe that this would be in my client's best interest, Your Honor. if we-
But he says he doesn't know.
Okay,
So,
I'm gonna waive it.
no, so he needs to get here or he needs to wait. Did you want to go and phone him and talk to him?
Mr. Carter, are you
Because I
going
am-
to waive?
I'm gonna waive it. I'm gonna waive it.
All right. So you're waiving your right to have a preliminary examination in both of these cases?
Yes,
Have you had an adequate opportunity to speak with your attorneys regarding that waiver?
yes,
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yes,
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
yes.
People also waive your right on these cases?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the one count in the 15th district court matter and on all 4 counts in the 14A2 matter.
Okay.
Your turn.
Thank you, Your Honor. Your Honor, as to both cases, my client would waive the reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to all charges. Pretrial will be set for
August 11th, 2025 at 1:30 for judgment.
August 11th, 2025, 1:30, Judge Hamud.
I do have a question. I'm looking over the notes in my file. The last one I have from the 13th of May is that the bond, the defendant was in Rowe County Jail and the bond it was set at 10,000, 10%. That bond posted.
And I thought he was on,
You said 10,000, 10%?
I know,
Is that May 13th?
May 13th.
May 13th, I'm looking at it. I set his bond at 1,000, 10%
Okay. Oh, no, you're right, 1,000, 10%. But that's,
in both cases.
was that posted?
I don't believe that it was.
I don't think the reason I'm asking Your Honor, the court, I totally unrelated case. We recently had someone who was just let out of the county jail in Wayne. The bond that hadn't been posted here, and that jail didn't seem to mind letting them out of their jail. So I was concerned that a similar situation happened here.
Well, I don't know if it's been posted.
It has not been received by either 14A1 or 15, if it was posted.
Your Honor, I will talk to my client about making sure that bond is posted. But again, this is, I will work with him on it. Yes, Your Honor.
Thank you. I'm trying.
Well, it's going to become Judge Hamud's problem at some point. So I'm just going to continue his bond. He's got to get it posted.
We'll get it posted, Your Honor.
He really should be in.
And again, I'm assuming Wayne did the exact same thing. It's
Okay.
Thank you, Your Honor.
Thank you. Court does call the case. People versus Kayla Keys.
And then on behalf of the people, Your Honor.
Your Honor, Alexis Blumey on behalf of Ms. Keys. And Ms. Keys, could you say your full name once you get up here?
Kayla Alexis Keys.
Thank you.
Your Honor, today's date comes up with preliminary examination. At this time, people are unable to proceed as to count 1 and as that count 2 be remanded to the chief court.
And Your Honor, the defense would move to dismiss count 1. And we would also like to very briefly be heard as to bond after we get that pretrial date.
Continue to defendant's no or not guilty plea as to count 2. Count 1 is dismissed. We'll set a pretrial date in 14B before Judge Washington for
July 21st, 2025. 10 a.m.
10 a.m. before Judge Washington. July 21st, 2025. 10 a.m. before Judge Washington. As to bond.
Your Honor, at this time, Ms. Keys is currently on a GPS tracking tether. That was modified at her last probable cause conference, I believe, from a hot zone tether after it was confirmed that the alleged victim had moved out of their apartment. So currently it is just tracking Ms. Keys, not preventing her from going anywhere. Seeing as the case has now been remanded down to district court and Ms. Keys has had no bond violations thus far and has attended every court date, I would just ask if that tether could be removed and we just do not go to the alleged victim's current address.
Response.
Your Honor, at this time, I would object to a modification of bond. This case originally was strangulation. I have concerns for victim safety. This is still an incident of domestic violence, and I would ask the
Doing everything. I'm not going to modify the bond to take the tether completely off. Motion for bond modifications tonight. Bond. Thank you.
Understood. Thank you.
Court calls the case People versus Clifton Watson.
And is that not back to people, Your Honor?
And Lori Yagi, Assistant Public Defender, with and on behalf of Mr. Watson, who is it for saying? Could you state your name for the court?
Good afternoon, Your Honor. Clifton Levi Watson Jr. Thank you.
Your Honor, today's a time separate preliminary examination. At this time, people are unable to proceed as to count one, and as to count two, be recommended.
Your Honor, we would move to dismiss count one.
People will be unable to proceed on count one or continue the defendant's not guilty plea as to count two. It will then set a pretrial date before Judge Barr on
July 10, 2025 at 8:30.
July 10, 2025. What time?
8:30.
8:30 before Judge Barr.
Your Honor, may I address bond?
Briefly, yeah.
Okay, Mr. Watson does have a separate address. He is a father and he's been really struggling with his mental health and with his physical health since he's been incarcerated. He does deny the allegations. This is the only case he has in Washington County. He does have a few holds, but so he understands that he would have to go. But I have been in touch with his attorney in Wayne County, who is very optimistic that he wouldn't actually be held in custody on his Wayne County hold. He has been struggling with his mental health and his physical health here. He would be able to comply with the no contact order. He has a separate address, separate residence. He's willing to do a GPS tether. He just wants to be able to take care of his children and himself out of custody.
Your Honor, I'm going to object to any modification of bond. In this case, he does have a hold on Wayne where his bond is denied. He also violated his bond while in custody by calling the victim 7 times and attempting to call her, I believe, 9 times, but not so. He already violated his bond while in custody. And given the facts of this case, I would have said bond remained set.
Anything else?
Only that I don't have a copy of those phone calls. His phone privileges were revoked at the probable cause conference. Unfortunately, I mean, I can't really speak to it because I don't have the calls.
Motion for bond reduction is denied. Bond vote.
Thank you, Your Honor.
Somebody needs to listen to him. Just listen to it. Have you heard him? Or-
Just now, Oscar and I listened to it together.
Okay, all right, I'll recall that momentarily.
And then everyone else gets pulled.
Everybody else is holding back. And four. Okay.
Yeah.
So this one we're going last. Right, no.
No. This one.
That's fine. So just hold down. Then it's between these two. What happened to ours?
That was at 2:00. We haven't gotten there yet.
Oh,
I haven't talked to you about those at all yet.
ow. Okay. All right, but this one has 1. And then we're gonna bring Lee back out. So who's on this one?
This is 4 witnesses with Miss Tanha and I believe Miss Aguirre.
So then this is good night.
9 is Burkett.
How many witnesses on that? 1 witness? Okay. Get Mr. Burkett in here. We'll handle that one. I'm gonna take a brief break. We'll handle that one. Then I'll get Mr. Lee out. Okay. And deal with Lee.
That's my order then.
All right, court is getting brief.
All rise. Have you seen?
Sure. My brother-in-law is yeah, we probably do that. Oh, yeah.
I was told I can be right now.
Rise. 14A, District Court for County of Washington, State of Michigan, is now back in session. The Honorable Judge J. Simpson presides.
You may be seated. All right, court does call the case of the people of the state of Michigan versus Lewis Howard Goodine.
Andrew Childers appearing on behalf of the people, Your Honor.
Good afternoon, Your for the record, Raymond Burkell on behalf of
Sir, could you please state your name? All right, very good. Date and time set for preliminary examination. Are we ready to proceed?
We're ready to proceed.
Yeah. Your Honor?
Yes, sir.
Other bedroom, which really didn't have much, like decor or anything else.
And Sergeant Pitt, are you familiar with the term like proofs of residency?
I am.
Okay. What does that term mean to you?
Means, proof that that subject lived in that apartment.
Okay. In your search of the apartment, did you locate any documents, items, or any other things that would suggest proof of residency that would associate this apartment with the defendant, Mr. Goodine?
We did. We located mail. We located his 2 Michigan IDs that were him. I believe that was in the nightstand next to the bed. We also located documents from his landscaping company, Dreammascus Landscaping. That was located in the master bedroom on the desk where the cocaine was located.
Okay. You've testified to 3 long guns located in the master bedroom. Did you locate firearms anywhere else in this apartment?
I did. Besides the 3 long guns that were all AR style rifles, we located several pistols in the secondary bedroom. In, I believe, the closet.
In the closet? Okay.
It was in a cardboard box.
Did you locate any guns in the laundry room?
I don't remember, but I don't believe so.
Okay. And how about the kitchen? Okay. And was there like a living room area?
There was.
Any firearms in that?
I don't believe so.
Okay. So the firearms are basically in the 2 bedrooms.
Correct.
Okay. The other bedroom, not the master bedroom, but the other bedroom, did it appear based on your observations that anyone was staying in that bedroom?
It didn't appear so.
Okay. And Detective Sergeant Pitt, did you locate any large quantities of U.S. currency in the apartment?
We located, I believe, $5,000 in the apartment.
Okay. Do you recall approximately, or do you recall where that was located within the apartment?
I do not, but I'm allowed to part of the.
Would that refresh your recollection? That's fine. Sergeant Pitt, I notice you're still flipping through. I don't know if you have your entire report. I printed off a portion of it. Is it not referenced in the report that you have?
I found it.
Okay, great. And where was it located?
So we found $4,500 on the table in the dining room area, which is adjacent to the kitchen and the living room area.
Okay.
$500.
On the counter? The counter of what? Okay, thank you. And Sergeant Pitts, in your approximately 4 years with LawNet, can you give us a rough estimate of the number of times you were involved in searches of residences associated with potentially drug trafficking?
Specifically narcotics, well over 100.
Okay, and in your training and experience with LawNet, the quantity of drugs located in this apartment in Pittsfield Township on April the 4th of 2022, is that consistent with personal use or with the intent to distribute?
That's consistent with trafficking.
Okay, and that's based on what? Okay, and specific to the facts of this case, is it the quantity that is most jumping out, or is it how it's packaged, or not all of these factors?
Both, because you have a large quantity of scales.
I didn't ask you about that. Did you locate scales in the apartment?
Yeah, we did scale in the apartment as well.
Okay, thank you.
And then also there's a money counter located in the apartment. With the packaging of it, the quantity, and the paraphernalia located, it's consistent with distribution.
Thank you. I have no further questions, Judge Your Honor.
Cross-examination. Thank you, Your Honor. Good afternoon, Sergeant Pitt.
Definitely.
Just a few questions about things that you just said. The search warrant that you got was based on for control by.
Your Honor, I'm going to object at this point. The purpose of this proceeding is probable cause that a crime occurred which relates to the execution of the search warrant. The subject of the matters of the search warrant would be properly motioned and here before the circuit court, which relate to either possibly a Frank's hearing or that the search warrant lacked improbable cause. But as it relates to the validity of that search warrant, for purposes of this proceeding, I don't believe that that is an issue that should be raised before this court.
Your Honor, you have the absolute right. I don't want to say duty, but to hear the background of how he got this search warrant and what he used to get this search warrant, and considering the totality of the case. They just can't come in here and say, I got a.
What are you challenging with reference to the search warrant?
Well, my question was this: you did 4 controlled buys, yeah, and did it involve this defendant? And I want to discuss the controlled buys that this defendant is accused of having, which he told a magistrate in order to get a search warrant. If he gave the magistrate false information or misleading information, it doesn't need to go to circuit court. I mean, you are a judge, you can make that call yourself.
And Your Honor, that's what Mr. Burkett is referencing would be a Frank's hearing under Frank's v. Delaware. You're only entitled to going into the contents of the probable cause of the search warrant if there's sufficient showing by defense attorney that there's either a deliberate falsehood or a reckless disregard for the truth. And it has to be more than just an accusation. There has to be an affidavit or support that the police either deliberately false or reckless disregard for the truth. Otherwise, you risk unfairly disclosing the identity of a confidential informant as it relates to these buys. We don't get to just have an interrogation of this information absent some showing by the defense attorney that it would be warranted.
Your Honor, the prosecutor is so wrong about this. He wants you to believe that you can just show up and say, I had bias from a person, but we need to go to the circuit court to determine whether the information I gave that magistrate was correct. If he presented a bunch of falsehoods to a magistrate.
Okay, and Mr. Burkett, while I might agree with you, I guess my concern is I've asked you what specifically a proffer of what you're trying to elicit.
Well, elicit several things. First of all, it's going to be our contention that he operated on false information. Well, see, here's what our theory of the case.
But who operated?
the officer, correct, and he gave that false information to the judge. But let me explain to you.
Stop. That who gave false information?
Your witness on the witness stand. And it's false information from a confidential informant.
False information from a confidential informant. So
To get a search warrant, the information was not true. The information was hidden from the magistrate. If they would have told the magistrate.
What information are you saying is hidden? I mean,
first of all, that my client possessed any of this narcotics. That's the first thing. And that he sold any narcotics to anybody. We're challenging that. And we can challenge that at this level. But the rule for the prosecutor to come and say, well, that's not important. Take that to circuit court.
Well, I don't think that's what they're saying at all. I mean, but I still don't know. To the extent you're indicating that I could make this inquiry into certain aspects of the search warrant. What are you telling me that was so false as to not?
I tell you what, hold that thought for a minute. Let me go to something else that will lead you right to this. And let me go to another.
Okay, well, I'm not going to hold the thought, or you can go to something else because you're not giving me any answers.
Okay.
I don't know what I'm holding.
I want to talk about the search warrant in and of itself, okay?
Are you going on to something else?
Yes.
Okay.
Yes.
All right. Go ahead.
But that doesn't mean I'm not coming back to this, but okay. Officer Pitts, I wanted to discuss with you the search warrant that you got from the magistrate, okay? Now, you just told this honorable court that you got proof of residency of my client, correct? You were required in the search warrant to file a return where you listed the proof of residency you got. What does the return on the search warrant allege that you took?
I don't know. I don't have the.
Beg your pardon?
I don't have the.
Prosecutor will give it to you.
I didn't print it up.
Okay. You just told the honorable court that, I'm sorry, before we get to that, yeah, would you allow me to approach the witness with a copy of the return of
Certainly.
Well,
yes. Is the prosecutor saying?
I didn't see it.
I'm a prosecutor too, but I wouldn't, okay.
What?
I don't know if you've seen that, but this the first one that they gave us.
Well,
just need to make sure.
But if you pull two pieces of paper out, I don't know that. And I'm just saying, show it to him and then we can go.
Sure. Judge, I agree with you.
I don't see the proof of residency on the return.
Beg your pardon?
I don't see the proof of residency.
You didn't see it because you didn't file it, correct?
Correct, we didn't seize it now.
Okay. Now, the court ordered you to find certain things and to seize them, correct? In the search warrant, or do I need to show you a copy of the search warrant?
We photographed it. That should be.
I didn't ask you that. My question to you was this, straight up. The court ordered you to find certain things and to seize those things, yes or no? Okay. Now, one of the things the court, first of all, you agree then that the proof of residency is not on the return of the search warrant, correct?
Correct.
And no, it's a yes or no answer. The court ordered you to find and seize proof of residency. You didn't do that.
I'm going to object. This is a misstatement of law. The search warrant allowed the police to enter the residence and look for items. They documented those items and seize certain items. The idea that they ordered him to seize certain things I think is a misstatement of what's going on.
Oh, first of all, I haven't seen what the particularities of the search warrant are, so I don't know what was asked to be documented, searched. I have no idea.
If you recall, in the search warrant, do you recall the court asking you to find materials that might be used to dilute controlled substance?
I don't recall if I could do it.
Please do.
I don't think I have a search warrant in front of me.
Beg your
I
pardon?
don't think I have a search warrant in front of me.
Let's see.
I don't have the search warrant in front of me, sir.
Is that the search warrant that was being handed to?
Okay, I see what you're referring to.
Beg your pardon?
I see what you're referring to.
Yes, okay. Now, did you see any weight scales? Yes or no?
No.
Did you seize any records showing that any narcotic transactions have been said? Did you seize any records?
We see the cell phones, but I don't think there's any records of it.
Okay, the answer is no, you didn't. Well, let me ask you this then. Did you seize any material that shows the sale of any cocaine?
No.
When I say seize, I'm going to also ask you, did you put this thing on your return? Did you seize anything that shows he stayed in that place?
No.
No. Okay. There was a computer there. Drug dealers, a lot of times, list their sales and things on the computer. Did you seize his computer?
No.
No. What you seized was $4,500 in cash. Beg your pardon?
5,000, sir.
Well, okay.
And I don't believe we seized his laptop. I'd have to look at the return just to verify, but I don't believe we seized it. We can.
Okay.
So I'm going to give you the answer on that.
Okay. Now, when you went into the place, of the apartment, Sarah, how did you get in?
I believe we used the key to access the front door.
Where did you get a key from?
Management office.
Okay, and you showed them the search warrant or what?
One of the other detectives handled that, so I'm not sure if he showed the search warrant or not.
Okay, and when you went into the office, did you or any of your members ask for any rental agreement to show he was staying in that apartment?
I'm not sure.
Well, did you see any rental agreement?
No.
As you sit here today, you cannot tell this court that Mr. Godown lived in that apartment, can you, sir? From personal knowledge.
I believe he did.
Now, I didn't ask you to answer. Can you tell us that he did or did not? Do you know personal knowledge?
Yeah, he looked.
Tell me how you know that, sir.
We located his 2 driver's license in the nightstand in the master bedroom, photographed that.
Okay, did you see his license and photograph?
Your Honor, asked and answered.
Same.
Okay. Is there any particular reason why you didn't seize his license?
Well, it gets to a point where our facility is only so big, so I mean, the evidence that he lived there would be DNA on his pillow. We're not going to see his pillow, so we have to kind of pick and choose what we're going to.
Okay, so I can't show those license to this judge that you claim you saw that, correct?
There's photographs of it, sir.
Thank you. Now, was anyone else living in that apartment with him? If you know from personal knowledge.
I do not know. Personally, I do not believe so.
Okay. When you did not seize or take pictures of any clothes that were found in that apartment? Yes or no?
There should be photos in the closet, which would contain some clothing. Did you see clothing? No.
Did you take photos of the clothes?
There's photos of the closet, clothes in there.
Okay, the clothes that you took pictures of, sir, I'm sure you have a good memory. Were there any women's clothes?
I do not remember, sir.
Beg your pardon?
I do not remember, sir.
Okay. Was there a woman, based on your knowledge, living in that apartment?
I do not believe so.
No, do you know?
I don't know.
Okay. Did you ever have the apartment under surveillance?
We did.
Okay. And did you ever have anybody go into that apartment?
Any of our undercovers?
Or anybody?
We had a confidential informant.
Okay, he went into the apartment.
The report, but I don't believe so.
Okay, well, it is in your report, though, isn't it? Now, how did he get into the apartment?
Your Honor, I'm going to object at this point where Mr. Burkett is trying to do an end around to get into the identity of the confidential informant without a proper showing under Frank's v. Delaware.
Well, no, that's not what Mr. Burkett is trying to show. What I'm trying to show, Your Honor, basically is this. They claim he was the only person, I think that's what they claim, in the apartment. We're showing that there were other people who lived in that apartment.
How are you showing that?
I'm asking him, he sent somebody into the apartment. Based on what they found, was he the only person living there? That's crucial to our case, because we're claiming the drugs are not his, he belongs to somebody else. How can I get to that if the prosecutor's trying to hide all that?
I'm going to sustain their objection. I think I've let you go much further than I really necessarily should have, because I'm still not sure what direction you're trying to go, Mr. Burkett.
Okay. Yeah, I'm sorry. Will you finish?
I'm done.
Your Honor, our whole theory is there were other people living in that apartment. And what I'm trying to show is he knows there were other people living in that apartment. But let me ask you this way. When your CI went into the apartment, did you ever receive any information that there were other people living in that apartment?
Same objection.
Sustained.
Yeah. So it wasn't important to you then whether or not there were other people living in that apartment. Is that what you're saying?
No.
It was important? Well,
How we keep asking questions that are assuming facts, not in evidence, first of all. Because because you say there are other people, keep repeating that there are other people, doesn't mean that there are other people.
Based on his investigation, did he say that there were other people living in it?
Okay, but Mr. Burkett, even if let's assume for the sake of argument that there are. Okay. I don't know where that gets you for the purposes of preliminary examination, because if your client's there and there could be a notion of joint possession, we're still in the same spot.
You're right, but they haven't.
I know.
I didn't mean it that way, you know that. But they haven't shown my client to be there. That's my whole thing. They have not shown him to be there at all. At no point did they show him to be there.
So but then you asked that question about 15, 20 minutes ago.
Okay. You never saw my client in that apartment, did you?
Inside of the apartment?
Yes. Afterwards. I mean, before this, did you ever see him?
Before, did I personally see him inside the apartment?
Yes.
I did not.
You had no information. Okay, they're gonna check that. You also, sir, went to his bank, and you executed a search warrant on his bank, correct?
Correct.
And what was the purpose of that?
To locate any sort of funds, see if you could locate anything that would be relevant to a narcotics investigation.
Okay, and could you tell Judge what you found based on your search warrant in the bank that would incriminate my client?
Nothing that would incriminate.
Nothing. How many banks did you go to?
One or two, I believe. I'm not sure.
Would you disagree with me if I said you went to 4?
I'm not sure.
Okay. So you wouldn't disagree with me. But anyway, be that as it may, of all the banks you went to, you found absolutely nothing, correct? Okay. I want to ask you about the guns that you found in the house. Were the guns you found all legal guns?
I believe so.
Okay. Did you find out who owns the gun?
I believe so, but I can't remember.
You don't-
That's 3 years ago.
And, okay, but as you sit here, you have your report, you read your report, because you testifying, so you can't tell this court that who owned those guns.
I believe Mr. Goodine did, but I have to.
That would be
read
the-
the report in order to say for certain.
When you went to ask for a warrant, you didn't ask for a warrant for Mr. Goodine, did you, for a felon in possession of firearms? Why not?
I'm gonna object to the relevance of this question. I don't know what it has to do with. He's not charged with felony possession.
I withdraw.
Saying the objection, but you know you shouldn't have asked it.
You don't have no more coffee over there, do you? I can assure you, okay.
The Starbucks down the road. If you want to go now, go for it.
He's a resident of the apartment.
Where's this picture from?
It's from me to you, to show you that that was a resident of the apartment living there.
It's just Your Honor, I've been handing a picture of some random individual with a beard and a blue sweater. I've never seen this person before in my life. This was not tendered in discovery, Mr. Burkett, to you? Was this tendered in discovery to you?
It was.
By me?
I don't know who was who in your office.
I don't know what this is, Your Honor.
Where did it come from?
From the prosecutor's office, I would imagine, but.
So what do you mean you imagine? Was it in discovery or not?
You know, I'm sure, but let me, Judge, here's my.
No. And that's the diversion.
I can't answer that.
Why can't you?
Because I don't know the answer to that. I don't do the discovery much. I don't go through it. I got a staff that does that. But all I want to know.
Oh, really? Okay.
All I want to know.
That's your defense for not knowing?
I can assume like the officer.
Because no, Mr. Burkett. You were about to give a document. I don't know if you're going to try to enter it into evidence, but you were certainly going to have this witness testify as to a photo. You show it to the prosecutor. Prosecutor is wondering where that photo comes from. And right as I ask you, which I think is a legitimate inquiry, you can't tell me where that photo came from.
No, sir, I cannot.
Then it's not going to that witness.
Okay, my only, I understand your ruling.
Okay, then why are you still talking?
I thought, that's what lawyers do, we talk.
I know, sometimes way too much. So young lady, you may sit down because that's not going up there.
Okay, Your Honor, the only purpose of showing that photo was to ask him, is this one of the residents?
Okay, look, I don't care what you were gonna ask. I'm done. If you can't tell me where it came from and the prosecutor doesn't know where it come from, I'm done talking about it.
I understand, Judge, I understand. I'm only doing that for appellate purposes. That's the only reason. All right, but let me.
To appeal a photo, you don't know where it came from and the judge won't let you ask questions about it. Okay, good luck. Go on, next question.
Judge, I'm just about finished.
Oh, we can only hope.
Beg your pardon?
Nothing. Go ahead.
Just so the record is clear, I'm not allowed to ask any question concerning the buys that were made, the 4 buys that were made to my client. Is that correct, sir? You objecting to the 4 buys that were made? Yes or no?
I'm making the same record that I made before.
Okay.
Getting into the substance of the search warrant is improper absent a showing under Frakes v. Delaware that there is reckless disregard for the truth. I'll read it. So
Go on.
the defendant is entitled to an evidentiary hearing in order to show that the affidavit is void when the defendant makes a substantial preliminary showing of a deliberate falsehood or reckless disregard for the truth by the affiant. Absent that, my position is that we are not to go into the contents of the affidavit that led to the search warrant.
I have nothing. I have nothing further.
Any redirect?
I have one question.
Yeah.
Sergeant Pitt, in
regarding proofs of residency, did you find any proofs of residency in that apartment with any person's name on it other than the defendant?
I don't believe so.
No further questions.
You may step down. Thank you, sir.
No further witnesses, people would rest, Your Honor.
Any witnesses for the defense?
None.
Now, at this time, people would move to bind the defendant over as charged on the 2 counts before the court.
Judge, I don't think there's been any short about those guns that were there, about, my client had, about felony firearm statute. I'm asking you, I don't know whose guns they were. They have no proof of residency, but under the law, I think you have to dismiss them.
You're saying this account 2?
Yes.
All right. Anything else?
No, that's it.
All right. The court, having heard all of the testimony in the case, the court does believe that the people have indeed sustained their burden of showing, certainly as to count 1, that there was cocaine, as testified by Sergeant Pitt, that there was cocaine in the Bridal Run apartment in an amount in excess of 1,000 grams. Certainly for purposes of preliminary examination, that portion of that charge has been shown and that it was packaged in such a fashion that it wasn't for someone's personal use, but some type of, as the witness testified, manufacture and delivery. That as to the possession of that, the testimony is also clear that the only person associated with that apartment, the IDs and other information that were obtained via the search warrant all indicated that Mr. Bruton was the only individual in those premises. So the court believes for the purposes of probable cause that the people have shown the actual narcotic that was present, that being the cocaine, but also that the defendant possessed that cocaine with the intent to deliver. As to count 2, the felony firearm, I think defense may be mistaken as to whether or not the guns were legally owned or there was some regard to the propriety of those guns. What's clear is that there were firearms present. Sergeant Pitt was very clear about the location of those particular weapons being in the master bedroom, or at least the occupied bedroom, and then the what could be called the unoccupied bedroom, that there were pistols located there. There was also ammunition and other things that, although those being long guns, maybe under other circumstances, they would have been certainly legal to possess without any interference. When one is in the commission or in the throes of committing a felony, that being the possession, and certainly the possession with the intent to deliver cocaine, the possession of those firearms in and of themselves become a crime. And so for those reasons, the court believes also that the people have sustained their burden of showing that the defendant was in possession of firearms during the commission of an ongoing felony. So for those reasons, the court would find that the people have sustained their burden of bind the defendant over on both counts 1 and 2 to stand trial. To the arraignment.
Stand. I was trying to stand up.
No, that's fine.
Stand mute. We'll wait.
Further reading. Defendant having waived reading, court will enter a not guilty, and standing mute, court will enter a not guilty plea as to both of those counts. Pre-trial in this matter will be set for
August 13th, 2025 at 1:30 with
before Judge Conlon.
August 13th?
Yes, sir.
Thank you.
Any issues regarding bond?
What is the bond set up?
Yeah, you don't want me to tell you. Right. The bond is set at $2,000 cash as surety, which is an amazing thing as far as I'm concerned for an offense that carries
I have the defendant.
life offense.
I have the defendant's guidelines scored at minimum of 108 months with a maximum of 100 months. Shockingly, the defendant does have no criminal history, but we have an individual with $20,000 plus worth of cocaine, multiple firearms, positions throughout the department, a very significant quantity of drugs with a mandatory, as well as the 2 years on the felony firearm. This is a case where the defendant is facing what I would call inevitable time in the Michigan Department of Corrections, and he's on a $2,000 bond on a life offense. I believe that bond is improper and would ask for a $50,000 surety bond.
I will certainly object to that. And the prosecutor is asking for that bond simply because we held this exam. Number one. Number two, which is more important, Mr. Childress and I argued the same motion before your brother magistrate here. And the magistrate
my brother magistrate.
Another magistrate, I'm sorry.
I didn't know.
Well, I am not, I don't know what other magistrate there is. I am not a magistrate.
I'm not a magistrate.
Yeah, I'm a full-blown judge.
Judge, I'm tired and I'm in pain, so I made a mistake. But
No, it's okay.
You know I don't disrespect you.
No, I know you're not.
I can respect all the disrespect. But anyway, one of the things that the court ruled in that when Mr. Childress made this argument was simply this, that this happened in 2022. The government waited over 2.5 years before they even sought a bond. So you can't come in here and say he was a danger to society or he was a menace to society. And then ordered that low bond for that reason, because they waited so long to get a warrant. And now that he got a warrant and he has a tenant, he's done every single thing that this court has asked him to do. We even have to leave court today so he could go next door because he got a buzz while he was here to go next door. To you to issue a higher bond on that based on the conduct that he has shown, it to me is just punitive. He hasn't violated anything. He owns his own business. He has contracts with those businesses. If you lock him up, he'll lose all those things, Your Honor. And there's no basis to lock him up. Not when he's come to court. He's not missed any of.
I have an individual facing a life offense, and now I've heard the testimony. That is the major distinction between what you're talking about occurred previously and now. I've heard the testimony. It is rather clear to me with reference to this offense. And that places the defendant in a very different position. And you know that, Mr. Burkett. Go ahead, I'll let you finish. But
well, it seems like you've already finished me. But what I'm asking for is, if you're going to waive the bond, I mean, let's do something that's reasonable, Your Honor. I mean, these numbers that the prosecutor is throwing out, it's something ridiculous. And he's doing nothing but punishing him.
and what would you suggest? Because quite frankly, the number I had in mind was much higher than what the prosecutor even asked.
Judge, he's been a perfect person since he got that bond. I can see it.
I didn't ask all of that.
But
I asked the question. What are you suggesting?
Well, I'm hoping that you would let the bond stay where it is. That's my suggestion. Because I don't see the basis. These same charges, nothing changed in the charges since he was given that bond.
Anything else?
Nothing.
Having heard argument, court having heard testimony and clarity of the testimony, and with an understanding that the defendant is facing a life offense and it becoming clear to the court that that conviction may be very likely based upon this testimony, the court is going to raise the defendant's bond, and the defendant's bond in the court in doing so now certainly at this point does consider the defendant to be more of a risk of flight than he was before, and also that the defendant, this court believes, does pose a significant risk. And I think, irrespective of the reasons that Mr. Burkett is I think that the bond, without anything else, the bond as set by the magistrate was a clear use of discretion from the get-go. So the defendant's bond will be set the amount of $50,000 cash as surety bond, dependent to remand. But I can't. Can we get Mr. Lee out? No, oh, is he? Okay, all right. Court does call the case of the people versus Larry Lee.
Good afternoon, Your Honor. Marie, Assistant Prosecuting Attorney on behalf of the people.
I forgot to wear a second.
And Mary Rubio, again, on behalf of Mr. Lee, who is making his way to the podium.
There's additional counsel that is on Zoom.
I'm sorry?
Mr. Rubio. Oh, there you are.
Good afternoon, Your Honor. May it please this honorable court, Joseph Arabo on behalf of Stephen Kwasny.
All right. And I'm presuming everybody except the court has heard the phone call.
What I heard was the recording the prosecutor gave me, which appears to be a less than 2-minute portion of a phone call. I think she would agree it's not an entire phone call.
That's correct, Your Honor. It's what Mr. Robles sent me, as well as Mr. Burgess, and law enforcement as of this morning.
All right. And that portion of the phone call, as the court is to understand, is basically this defendant speaking with, is it directly with the victim in this case?
No.
No,
An
Your Honor.
attorney.
It's with Mr. Robles, who's the attorney for the victim.
All right. And basically offering to not provide testimony in another case if his client doesn't provide testimony in this criminal proceeding.
That is how I would characterize it, Your Honor. If Mr. Robles has additional information or different information, he's welcome to.
Yes. Mr.
Yeah, just to clarify the record, that's a portion of a phone call because I didn't anticipate to record the entire thing. I didn't know who was calling me. And then once I realized what this was, which is an attempt to extort and use this other case that he filed against the victim in this matter to use as leverage to have this conversation at a future point in time, I was quick enough to get on my computer and record it so that the court is aware of what's going on in the matter where I represent Mr. Kwasny, who's the victim in this matter, which is the first matter before the court.
Your Honor, if I may, I really object to that characterization that it was an attempt to extort. I've spoken to Mr. Lee at length about the purpose of the phone call. I also listened to the portion of the phone call. Perhaps the court could listen to it. I do not believe that was what was happening at all. And plus, I don't think there was nothing on there that indicated he was trying to extort this attorney or the complaining witness. Frankly, what Mr. Lee has alleged to me is that he and Mr. Burgess have basically had a breakdown of communication, that he's spoken to Mr. Burgess multiple times, asking him to advocate on his behalf to the prosecutor as well as to this other attorney to try to come up with what he has called, not being a lawyer, using the words a settlement agreement or a plea negotiation. That's what he said to me. And that he had the feeling that Mr. Burgess had not, in fact, made this phone call. So he then called this attorney, and right in the phone call,
because it would have been unethical for Mr. Burgess to call to try to say my client won't testify in this other matter.
Of course.
If that, right? That's Mr. Burgess may not have done.
And that may very well be, but Mr. Lee indicates that, and I haven't seen these, he indicates that he has text messages back and forth with Mr. Burgess, and that Mr. Burgess, quote, lied to him about whether or not he made these phone calls. So he indicates the main reason that he wanted to call.
That would be irrelevant.
I know that, Judge, trust me, I know that, but I just wanted to make the record. What, can I just finish though?
Let her finish.
Mr. Lee
Sure.
indicated the main purpose of the phone call was for him to find out whether this attorney could verify whether Mr. Burgess called him. If you listen to the call, the portion of this call, it's literally on there. He says, it starts out with him saying something about plea agreements. It's the call, it's interrupted. And I believe because counsel didn't realize he was going to need to record this. But anyway, it starts out with him, Mr. Lee, saying something about plea agreement, settlement agreement. Was there any, did my lawyer, did Mr. Burgess call you to try to, see if maybe if I wouldn't testify and then your client wouldn't testify? Yes, he says that. But then he goes on to say, because my lawyer said he called you, and then this attorney confirms what Mr. Lee was trying to find out. And this attorney says, no. You see how easy it was to reach me. I didn't talk to anybody named Burgess. That's what he says. So I'm just indicating that Mr. Lee states that was the main purpose of his call, because he claims he wanted to come in here today and tell Your Honor that he did not want to have Mr. Burgess represent him anymore because he feels Mr. Burgess is lying to him. I'm just representing to you what Mr. Lee has told me.
Your Honor, if I may.
I'd like to say
Yes.
something.
Thank you. Mr. Arabo, it's my turn. One moment. Your Honor.
Because apparently that's how it works in this courtroom. Tana says it's her turn, so it's her turn. Go ahead, Miss Tana.
Mr. Arabos had some trouble with interrupting.
That's only because she's there and I'm not.
Your Honor, I don't really, quite frankly, care what's going on with the client relationship with Mr. Burgess, or claims Mr. Arabos making about extortion. That's not something that people are going to get involved in at this stage. What I'm concerned about is there is a clear difference between a plea negotiation and two witnesses not testifying, one of them being Mr. Lee, the other one being Mr. Quadley, not testifying in exchange for something. And I agree that the court should just listen to the call rather than us going around calling it different things. What's clear to me is that there is an offer to not testify in exchange for Mr. Quadley not testifying in this case before this court. That is what I'm hearing on that call. That is what's concerning to people, and that's what may bring future charges. We're in an early stages. This needs to go to law enforcement. If it has gone to law enforcement now, and we can follow up.
Mr. Rubble.
Your Honor, as you know, I'm a defense attorney. I think it's Ms. Rubio is really grasping at straws here to try to help her client. But here's what it is. It's not a plea. We heard her say plea. A plea means a reduction to something other than what he's being charged with, not a dismissal, which is clearly being indicated in this. Second, what's happened here is you could see clearly there has been a subsequent case filed. I don't know how to slip between the cracks, because in over 10 years of practicing, I've never seen something like this, where a victim turns into a defendant. What? During a pending case. Never seen anything like this. So Mr. Lee has done this intentionally so that he can one day use it as leverage to contact me or have somebody else contact me or whoever is representing Mr. Quadney, so that he could use it as a negotiation tactic. And what he's engaged in is third-party communication to get through to Mr. Quadney in violation of his bond. That's number one. He's got a no contact order. Second, this is witness tampering. You don't want to call it extortion. Let's find something else. It is witness tampering. He's trying to tamper with Mr. Quadney using the leverage that he created. And I don't know how the prosecutor's office allowed this to happen. Somebody wasn't monitoring things properly, but this is what's happened. First ever time I've ever seen anything like this. And it needs to be handled. It needs to be handled. It's going to be handled.
Okay.
Can we listen to the call?
Everybody
Yes,
listen to it already.
Can somebody send it to Ms. Weidling, and I will then be more than happy to listen, or if there's an easier way for me to do it, I'll do it. Let's take the defendant back and court listen to the call.
You have to go back.
I'll handle that coming back out. I think Miss Ackerman's on that. So bring me that. Court's going to stay in recess. Everybody can remain seated. Bring me. Pardon? Yeah. 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 Bring those two back, and then I'll.
He would like Miss Tana and Ruli on the Burns matter.
All rise. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge takes that decision.
You may be seated.
Already called.
Then I got this here. Now I got Kennedy Brown. And got it.
Yeah.
Court does recall the case of the People's State of Michigan versus Larry Lee.
Good afternoon, Your Honor. Marie Canhouse, Assistant Prosecuting Attorney about the people.
And Mary Rubio on behalf of Mr. Lee, who is approaching.
Larry Lee.
Okay. The issue is in this case that, first of all, we're adjourning the hearing over.
I believe we are. That was what I thought we were doing in the beginning.
Well, it's got to stay before me. So.
I know Mr. Burgess is already going to be here on July 1st. I just wanted to put that out there.
Yes, but I'm not on the,
Oh.
I'm on the bench, but I'm not doing these.
Okay.
Set his preliminary examination July to defendant's request, so my next date is July 22nd. 2025, and that's another 12 p.m. start, because God, I love that. All right. With reference to bond in this case, I've listened to the recording. I'm not going to say there's an over exaggeration or an under exaggeration. I mean, I think it's relatively clear when somebody very clearly points out an exchange or quid pro quo regarding me not testifying and this other person not testifying, and that is the exchange. I don't know that you get a clearer indication of somebody that is attempting, and especially when they circumvent their attorney, of somebody trying to sort of tamper with and obstruct a case. It couldn't be clearer. I mean, and quite frankly, I don't think there's any design to necessarily frost it over or anything along those lines. I think the idea or what Mr. Lee is saying about what Mr. Burgess wouldn't do is quite frankly just a ruse to hide his own desire to have the exchange that he was speaking with counsel about. Given that, and the court having heard that, with reference to this case, the defendant's bond is hereby ordered revoked based upon the court's hearing of that bond violation.
Your Honor, can I just raise two issues? Before all of this happened, Mr. Lee expressed to me and attempted to express to the court his, as I'm sure the court has gleaned, his displeasure with Mr. Burgess. So I do think there, given some of Mr. Lee's allegations against Mr. Burgess, it may be best if someone else is appointed to the case. I know he doesn't want Mr. Burgess.
And that's fine. I don't know whether or not he doesn't want Mr. Burgess or not, because I think, as I'm indicating, I think that notion of Mr. Burgess not doing something and then his checking is simply a ruse for him to try to get the message that I want this quid pro quo, this exchange.
And I'm not accusing Mr. Burgess of anything. I'm just trying to represent what Mr. Lee has told
And I
me.
understand that.
And Mr. Lee
I
is
think
about
when
jumping
you-
out of his skin trying to talk, just so you know.
And so when you talk to Mr. Burgess, if Mr. Burgess, if he believes that that's the appropriate step, he can bring that motion before this court and the court will hear it in the day that I'm on. Mr. Lee, I will let you talk in a moment, but I'm going to finish this. Revoking your bond because of is a clear violation of the bond regarding, and I mean, I think it's an attempt to try to get indirect contact as well as obstruct these proceedings. Because that was accomplished in the manner it was, and I'm not sure that I can trust you with reference to no contacts and the like. We're at least going to get through this. I am going to, subject to a hearing, defendant's phone privileges for the jail are also revoked. What did you wish to say, sir?
The thing that my substitute attorney here didn't convey to you was that I told her that I have the evidence with me in hand, that my attorney, Mr. Burgess, was the one that actually said that this was a legal way that we can go about it. And no,
You know what, Mr. You might as well stop right now.
I have the text.
Because no, I'm gonna tell you, I don't know if you're misunderstanding something or what, but you are not, Mr. Burgess has appeared before this court. You are not gonna sit here and try to disparage that man, saying that somehow or another, Mr. Burgess represented to you that obstructing a case in this fashion was a legal way to proceed. I'm not gonna believe it, and I'm not gonna hear you. I'm not gonna hear you. I don't know what how do you not understand what I'm telling you? Now, if you've got that information and you think that's what it says, you get it to counsel and the court will take a look at it. But you're not going to sit here and disparage that man. It is not going to happen. I'm done. Bond revoked. Thank you.
Thank you, Your Honor.
Thank you, sir. Appreciate your wait and patience online.
No problem, Your Honor. Are you still on the record?
Pardon? I am.
Are you still on the record? You know, I'm not sure who this kid is or what he's capable of or what sort of messages he can get out to other people. But if the court could put a no contact order because somehow I've become a witness in this matter, I'd appreciate that.
A no contact with you?
Yep. I don't want to be contacted by any third parties. I want out of this thing and I want to be done with it. Didn't ask to be here.
I will add that no contact provision in.
Get one of those, Your Honor.
But counsel, why don't you let us know how you really feel? I know. All right. We'll take care of that.
I think the courtroom's been through enough today. Thank you. Appreciate it.
Thank you, sir.
Take care. Bye-bye.
Thank you, sir. You ready? You got court calls the case of People versus Jerome Burns.
Good afternoon, Your Honor. Marie Tennis, attorney on behalf of you.
Where can really go?
Thank you.
It's like a squirrel.
It's only 4:15.
You know, and I had so much hope and promise for this day.
Assistant Public Defender, Cedric acting really, Your Honor, on behalf of Mr. Jerome Burns. Mr. Burns, put your name for the record, please.
All right. The record should reflect we had an in-chambers conference regarding this case, and this was set to go to there. And I'm going to put it in this way. There is potentially some information that might be beneficial or exculpatory for the defendant, which the defendant has apprised his counsel of. Whether or not that exists or not, no. But there is a request that I adjourn this to allow counsel to explore that, as well as, because of where the information may be located, to fully explore and explain to her client the potential pitfalls of trying to obtain it in certain ways. I think I have said it. All right. So there's an agreement to adjourn the preliminary examination in this case. And my next date is not till the 27th, but because Mr. Burns is in custody, I'm going to give a special date of July 7th 2025, hoping that that'd be enough time to accomplish what needs to be accomplished and not have him wait so long. July 7th, 2025 at
9 a.m.
9 a.m. That's a Monday. And that's before me. All right.
Thank you, Your Honor.
Bond will continue. Thank you, folks.
Thank you, Your Honor.
Thank you. And did I need Mr. Brown? It says. Amazing, but
Yeah, Mr. Belvisi, he's here.
is he gonna, oh, no, but Lauren handled the last time.
Oh, that's.
Well-
That was the assignment for today.
But this,
That's-
oh, no.
You're thinking of the wrong one.
Oh, what are we gonna do?
We're holding anything.
Okay, let me. Counsel on the Branscombe matter approach. Branscombe? All right, court does call the case of the People versus McLaughlin.
Public defender, Mr. Charles McLaughlin.
Hannah Mackey, hearing with and on behalf of Charles McLaughlin.
All right, very good.
Andrew Chill is appearing on behalf of the people, Your Honor.
All right. And this is a continuation of a preliminary examination, which I believe, I think it was Detective Rob was on a call that day.
That's correct.
Now he's here. And so you may call your next one.
I think our people would call Thomas Robb to the stand.
All right. Sir, please come forward to be sworn.
Take seat, raise your right hand. Do you solemnly swear to affirm the testimony about to give the truth, the whole truth, and nothing but the truth?
I am.
State, spell your first and last name correct.
Thomas Rob, TH11HR, RAU.
Sir, thank you, Your Honor. Sir, how are you currently employed?
Detective with Washington County Sheriff's Office.
And how long have you worked with the Sheriff's Office?
4 years.
Were you working in that capacity back on April the 5th this year, 2025?
I have a license as a road patrol deputy.
Road Patrol Deputy? Thank you. Directing your attention to around 7:30, 7:45 in the morning, were you in the vicinity of the West Willow neighborhood?
I was.
Okay. And on that date and time, what was your shift?
Sorry.
What was your shift that day?
I was working day shift,
Okay. What time did you start?
8 a.m.
8 a.m.
I
Okay.
believe the 7:30 time was when the call initially came in.
Okay. At some point, as your shift started, were you made aware of an investigation regarding a possible stolen Ford Explorer?
I was.
Okay. And who made you aware of that?
Deputy Phillips.
Okay. And what, if anything, happened in that morning on April the 15th that led to you being involved with that Ford Explorer in any way?
Deputy Phillips told me that he had taken a stolen vehicle report from that vehicle. He advised that he had gained GPS location for the vehicle from the victim. And I was pinging it, I believe, on Brookside, which was in the West Willow neighborhood. He advised that he was going to go check the area for the vehicle and asked me to assist.
Okay. Were you and Deputy Phillips in the same patrol vehicle or separate patrol vehicles?
Separate.
Okay. To your knowledge, did Deputy Phillips arrive in the area of that suspected stolen vehicle before or after you?
Before.
Okay. How did you know that?
I heard him call it on the radio.
Okay. When you heard him call that out, where were you?
A few blocks away.
Okay. And what happened next?
After he called out that he was out with the vehicle, again, I believe it was on Brookside. I was a few blocks away. I heard mic clicks on the radio. That's pretty much when somebody depresses the talk button on the radio, but doesn't have a chance to get transmission out. In my 7 years of doing this job, normally when I hear that, that tells me that the deputy's in trouble. There's some kind of accident. That caused them to interrupt their transmission, whether they're chasing someone or fighting or something of that nature. So that gave me cause for concern. I continued towards that location where Deputy Phillips was at, and then I saw the, I believe it was 2024 Ford Explorer. That was the vehicle in question, speaking of the neighborhood.
So as you're entering the neighborhood, it's exiting the neighborhood?
Correct.
Okay, what did you do next?
I recognized that it was the vehicle we were looking for. I believe Deputy Phillips was in danger or something had happened, so I activated my emergency lights and siren to try to stop the vehicle.
Okay, and did you have to turn your vehicle around?
No, I was coming right at the entrance to the side street of the vehicle. The Ford Explorer was coming out from.
Okay.
Driving directly at it.
Got it. And did you in fact then begin a pursuit of that vehicle? Okay, and that started in this West Willow neighborhood?
Yes.
Okay. What is the speed limit on the road there where you initiated this chase?
It's a residential neighborhood, so 25 miles an hour.
Okay. Did the vehicle pull over after you activated your overhead equipment?
No.
Okay, what happened next?
The vehicle accelerated and tried to evade me.
And did you continue to pursue the vehicle?
I did.
And for how long did you continue to pursue this vehicle before it was eventually stopped?
I believe about 10 minutes or so. I don't recall exactly the time.
Okay. Where during that time, do you know, Detective Rob, what speeds did you get to?
I believe maximum speed was about 130 miles an hour.
130?
Yes.
Okay. What sort of vehicle were you in?
A Ford Explorer.
Okay.
It was a fully marked patrol car.
Thank you. At what point did this chase terminate in any way?
Van Buren police assisted us with the pursuit. It was a Van Buren officer deployed stop sticks, which the stolen vehicle ran over, which caused, I don't know if it was one or multiple tires to deflate, and then the vehicle crashed into a berm at the entrance to a neighborhood. I believe it was on the end of the Forest Roads.
And that's in Van Buren Township?
I believe so.
Okay. From the time period that you started this pursuit in the West Willow neighborhood to the time that it ended in Van Buren Township, did you ever lose sight of this Ford Explorer?
No.
After the vehicle was hit the stop sticks and crashed into the ditch, were you able to determine if the vehicle was occupied?
Yes, I was.
And were you able to see anyone in that vehicle?
Yes.
Okay. Are any of the individuals that you saw in that vehicle on April the 15th in the courtroom here today?
Yes.
Can you identify an article of clothing that they're wearing?
Yes, it was Charles McLaughlin. He's sitting to my left wearing a green jumpsuit.
And where, Your Honor, may the record reflect in court identification of the defendant?
Without objection, record shows so reflect.
And where in the vehicle did you observe the defendant?
He was exiting the driver's seat.
Okay. Was there anyone else in the vehicle?
No.
And what did you do at that point when you made contact with the defendant in the driver's seat of this vehicle?
He was exiting the driver's seat. I told him to show me his hands and get on the ground. He did. I placed him in handcuffs.
Okay. Did he appear to be injured in any way?
I believe he had some scrapes or bruising on his arms. Maybe, I think he might have had a small amount of blood on his lower lip, if I recall.
Okay. Is it, do you recall, did like the airbags deploy in this crash?
I don't recall.
Okay. I have no further questions, sir. Thank you.
All right, thank you. Cross-examination.
Good afternoon, Deputy Rob. You were in pursuit of the vehicle in question?
Yes.
And you followed that vehicle for around 10 to 15 minutes? And during that time prior to the accident, you got no closer than 50 feet, did you?
I got no closer than.
To the vehicle than 50 feet, would you say?
I don't know how close I got during the pursuit. I guess 50 feet might be accurate about closest I was, but I don't recall without reviewing the camera footage.
And you testified on direct that during the course of the pursuit, you activated your sirens. Is that correct?
Yes.
And at some point you were driving on the highway?
Yes.
Was it a busy highway?
I would say there was a medium amount of traffic.
So that means that there were other cars on the highway during the pursuit.
Yes.
And you had to make several lane changes to navigate through that traffic, didn't you?
Yes.
And some of those cars pulled to the side. Is that correct?
I'm sure some of them did. Well, usually people lane, not very good about pulling over.
And it would be safe to say then that some cars did not pull to the side? And at one point, you had to even drive on the shoulder of the freeway, is that correct? You don't know why some of the people did not pull over to the side, do you?
Well, without talking to the personally, no, I wouldn't know why.
So you don't have any personal knowledge then as to whether or not the drivers of the vehicles could hear the sirens?
I suppose so, yeah, without talking to them.
So then it would be fair to say that you didn't know why those vehicles did not pull over?
I guess so.
And you don't have any personal knowledge that Mr. McLaughlin could or could not hear the sirens, did you?
I suppose not.
Thank you, Your Honor. No further questions.
Right. You redirect.
No, Your Honor, thank you so much.
Sir, thank you.
Thank you.
Your Honor, with Detective Rob's testimony, the people have no further witnesses, the people rest.
Any witnesses for the defense?
None for the defense, Your Honor. Thank you.
All right.
Now, people would move to bind the defendant over as charged on the information before the court. I believe it is 5 counts. Yeah.
Yes.
5 counts.
Mr. Brown responds.
Thank you, Your Honor. Your Honor, the court listened to the testimony previously from Deputy Phillips. It also heard the testimony from Deputy Rob. So the counts that we have that the prosecution is requesting for bind over are assault with intent to murder. That would be on Deputy Phillips. There's fleeing and eluding. That would be Deputy Rob. There's receiving and concealing a motor vehicle, an unlawful driving away, and a resisting and obstructing causing injury. And I think that last one goes to Deputy Phillips. So I know it's been a bit, so we probably should go over what the prior testimony was. The testimony from the Deputy Phillips was that on April 15th, he was on road patrol. He'd gotten a call that a reference a stolen vehicle at the Marriott. He responded, had contact with the owner. The vehicle described as stolen was a gray Ford that was stolen sometime during the night. I don't know if we ever really narrowed that down to exactly what time that vehicle would have been stolen. That was entered into lien. At some point, they got to the cul-de-sac in West Willow where the GPS told them that the vehicle would be found. They first got there, they couldn't see the plate because the vehicle was facing them. I believe that when they pulled up, they were facing the vehicle. They're probably, 20 to 30 feet away from the vehicle. Again, it was facing them. And while they may not have been directly head on, they were in front of them with their headlights facing each other. The officer testified, Deputy Phillips, that he could see that there were at least 2 people in the vehicle at the time, that they pulled up. But then once they came to a stop, they said they were going to conduct a modified felony stop. Deputy Phillips said to unholster his pistol. 2 passengers then got out. And so 2 people got out of the vehicle. And they started walking away from patrol car as well as the vehicle that they were in. Said he couldn't see the driver at first. Later could see who the driver was at about 15 feet. Said he yelled to the driver to turn the car off. So I believe the car was still running at this time. This point, his weapon is drawn. He says that he stepped out away from his vehicle into a space. This is a cul-de-sac. And as the testimony was developed, there was a space between the front of his vehicle, where he was the passenger, got out, and a space in the street from where a vehicle could pass through. He said he got out, couldn't recall whether or not he raised his hand, but he did get out and he got into that space. He said he could see the vehicle, the wheels turning, and that the car then drove at him without veering. He had his weapon drawn. And the vehicle, once it got started, did not stop, drove at him, clipped him on the knee as he had to jump to get out of the way of the vehicle. It did say that the vehicle does not stop after that. I asked him if the driver said anything to him. He said that there was nothing said, no threats made or anything like that. He did say he had recognized the driver as Mr. McLaughlin. He then testified that he and his partner then got into the vehicle and left in pursuit. So what we have then is the vehicle stolen sometime in the night. We do not know, or there was no testimony given as to who drove that vehicle away. We do know when the vehicle is seen again, there are 3 people in the vehicle. And I'm not clear as to how much time has passed. It's been a few hours. So we don't know if the person who took the vehicle, drove the vehicle away from the scene, is even in the vehicle when it's reached at West Willow, because there's been no testimony given for that. If the court remembers differently, certainly they could say, but as I recall the testimony, they spoke with the person who owned the vehicle and they simply said that the vehicle was taken in the night and they had a GPS and they're able to track them. So at the time that the officers or deputies are looking for the vehicle, tracking the vehicle, they have no idea who has taken the vehicle, male or female, white or black, fat or skinny, tall or short. There is no description of the driver or the person who actually drove away with the vehicle. We just don't have that. But what we do have is 3 people who are associated with the vehicle. 1 person is in the driver's seat, and several hours that have passed since the vehicle was driven away from the spot. So let's go back to the first charge, which is assault with intent to murder. So based on Mr. Chalice McLaughlin driving at the officer who was in the space to which the vehicle must pass in order to leave the scene, based on him driving at the officer and hitting him, the prosecution is charged assault with intent to murder. Now, most of the time we see this is usually charged as felonious assault. In fact, every time I've ever seen this, it's been charged as felonious assault. And there is a reason that it's charged as felonious assault. First, in order to prove assault with intent to murder, prosecution must show evidence which would have supported murder had death occurred. And that's first degree. They have to show that it was a first degree murder because they have to, in this, back up. This is People versus Sis Medea. That's 167 Mich 210. They have to show that their murder, that had death occurred, it would have been properly charged with murder. So, second, let's go with People versus Todd, 186 Mich App 625, 1980. There must be an intent to kill in order for you to have, for murder. For you to have murder, there must be an intent to kill. And this is what the prosecution is no doubt going to argue. They're going to argue, you know what, even if he didn't say, I'm going to kill this guy, I plan to murder this guy. And you have to have that. You have to have plan and motivation to murder. They're going to say, well, he created a risk so high that, and he knew the consequence. He knew if he hit this guy, he could die, that's going to be sufficient. And I think would be the logical thing to argue, that the risk that he created with the knowledge of the probable consequence, that'd be sufficient. But the law would not support that. People versus Milton, 81 Mich App 515, 1978. There must be some time for premeditation and deliberation. So remember, the court may recall that it was 6 seconds from the time the officer got out of his vehicle and stood in that area in order to stop this vehicle from leaving. 6 seconds. Now, the law does not define how much time you need for planning and premeditation. It doesn't do that. But it is clear where there is no evidence of planning and motivation, They have to show that. They have to show some plan, some motivation to kill this person. What you've seen is a motivation to flee the area, perhaps. But there is no evidence put before this court that when this vehicle was driven at that officer, that the plan or the motivation, the intention or the premeditation was to kill anyone. And they have to show that. It's not enough that they show, well, it's likely.
But isn't that really a question of fact?
No.
As to whether or not.
Good question.
Evidence is sufficient.
Good question. Because People versus Oster, 67 Mishap says, where there is no evidence of planning or motivation, bind over is erroneous. So no, it's not a question of fact. And it's a great question, but People versus Oster has already answered that for us.
You've already said, have you not, that even though it's a 6-second time frame, that could be, or a fact finder could conclude that that is sufficient time for the premeditation. Right?
Thank you. I've not said that.
Well, I know you're not saying that, but you are saying that the case law does not indicate that de facto says that there is not enough time because the time frame is not spelled out.
Right, the time frame is not spelled out. That doesn't automatically mean that it's an issue for the trier of fact, because they still have some duty, Your Honor, to show that there was some planning and motivation. That's what you're giving. What you would, if you were to bind over based on what you have here, you'd be taking away their duty. You'd be relieving them of their duty to put that evidence in, and that's what they have at preliminary examination. They have a duty to show that there was some planning. You can't simply say, well, you know what? Since the law says that, there's no time frame, then hey, that's enough. They have to actively show that there was a plan, a premeditation to murder. It's not simply, well, you know what? And again, if you couple that with People versus Milton, where even the creation of a high risk of death with knowledge of the probable consequences is insufficient, that makes their duty very clear, Your Honor. They can't simply just toss these things out without showing exactly what they need to show, and that is that there must be some premeditation, some plan to do so. They have an active, affirmative duty to show that. They simply can't say, well, what he did was risky, and that's enough. They can't say, well, since there's no time frame, that's enough. They have to show you that there was a premeditation and a plan. And the most likely thing that was going on here was Mr. Jackson was trying to leave the area. The officer got into that area, and in the 6 seconds that it got for him to get out of his vehicle and to walk into that space where the vehicle had the only space where they could get by, and they ended up hitting him.
Premeditation necessary for first-degree murder implied where it involves a police officer?
There's no exception for police officer. There's no police officer exception.
No. But where it becomes first-degree murder, it's implied because there are certain types of acts that constitute first-degree murder.
Right.
Right. One of those would be the potential killing or the killing of a police officer, where the premeditation is implied.
So you're saying there is an exception for police officers with acts that
I'm not saying it's an exception. I'm just saying there are certain things that will constitute implicit premeditation from the standard definition.
So you're saying that there is a police officer, something that specifically.
I don't know if you want to call it an exception. I'm saying that there's something unique as to police officers, such as it would be where a murder occurs during a first-degree CSC.
That's a felony murder consideration, Your Honor.
Well,
and I don't think
it can be, it can be that. But even when you're talking about it being murder, what you're doing is you're implying the premeditation necessary.
Because it's a police officer, so what you're saying, so I'm clear.
I asked the question, isn't there an exception?
I do not believe there is. I do not believe that the law changes. And that's equal protection. My client is entitled to equal protection under.
I don't think it has any equal protection implication. It's just a question of whether or not
under the statute that gives that there is that exception.
Well, it is.
You're calling it an exception.
It is equal protection in that my client is entitled to, and again, I don't believe that this exists. Certainly, we can research it if the court believes that actions.
I just asked the question.
Well, okay, so my response is, I do not believe that that is a thing. I do believe that that's a thinking and charging what in every other case is always charged as a felonious assault. I do believe that there's a thinking, and that's where the equal protection comes in. That's exactly where the equal protection comes in.
I don't know.
Because my client is.
I don't know if that's equal protection.
Well, I'll explain to you why I think so.
Well, I don't need it.
Okay,
Because I don't think
you've rejected it up front. Okay,
I
fine.
rejected outright.
Oh, yeah, all right, fine. Well, Your Honor, then I have to say I reject the notion that police officers have some sort of protected status.
Well, you can reject it. I asked the question. You're saying
Okay.
no.
I'm saying
I'll
no.
hear from the
I'm
people
saying
when they get
when
there.
they get there. Okay, all right. So let's move past that. Let's go to the unlawful driving away. Now, as I recall the evidence coming out, and the court may remember differently, there was no identification of who drove that vehicle away. And for unlawful driving away, the person who drives the vehicle away, or
Yeah, but yeah, I hear that argument, but does it matter whether it was driven from the scene or from the hotel? Is it really going to matter?
yes, because one is receiving and concealing stolen goods, and one is driving away. The thief has to drive the vehicle away. If they put no evidence before you, let me back it up. Sure, you can certainly say that recent possession of stolen goods leads to the inference that a person knows the property is stolen. It does not lead to the inference that the person stole the property. And they have to put evidence on that Mr. McLaughlin drove that vehicle. That's why it's called unlawful driving away, Your Honor. It's not unlawful possessing later on. It's unlawful driving away. You can't conflate receiving and concealing with unlawful driving away. They have a duty.
Well, the person, so what I'm saying is whether or not he took possession at the hotel or whether or not he took possession at the cul-de-sac, because he was driving the vehicle, and there's testimony to that, he took possession and he's driving it away.
That would be at most unlawful. That would be receiving and concealing stolen property, Your Honor. Unlawful driving away means that he has to have taken the property, knowing that the property was not his, that he was taking the property from the owner. You don't know that he was at the hotel. You can't, and that's.
I'm just saying it won't matter where you start, though. I'm not saying that there's an indication that he necessarily took it from the hotel. If you concede that point, I'm saying the unlawful driving away can happen at the point of the cul-de-sac.
Then how do you get receiving and concealing stolen property? How do you distinguish the two if you're going to say it's always a?
I'm not here for reasonable doubt. I'm not here to answer your questions. So you can go ahead with your argument.
All right, so let's make sure that we're clear on that. Unlawful driving away demands that the person take the vehicle, take possession of the vehicle, in contradiction or in contrast to the owner. If he takes possession of the property from someone else who stole it, he's not an unlawful driver away of the vehicle. He may be someone who receives and conceals. The problem for the prosecution's case, Your Honor, is they have not established who took the property from the owner, or at least where the owner had the property last. And they have to do that. Just because you can say that he was in the vehicle later does not and cannot support a UDAA. At best, it can support a receiving and concealing of stolen property if you go with the thought that recent possession of stolen property, knowledge that the property itself is stolen. But it does not support a claim that the person, whoever is in possession of it, actually took that vehicle. And that's what UDAA demands. They have to have taken the vehicle from the possession or control of the owner, even though it's in the parking lot and the owner may be elsewhere. They have to have taken it there. If they drive it later, at best, that's a receiving and concealing. It's not a UDAA. That's not what the law says for UDAA. If you argue something differently, then always, if someone steals the car, hands me, and that's another thing too. There's not been any evidence put on that my client had the keys or didn't have the keys. But even getting past that part and getting past the notion that someone may have given him the keys elsewhere, I can concede that it's relatively recent possession, even though we don't have enough time or we don't have a specific time period, how long the vehicle was taken or when my client would have come in possession of that vehicle. And that's important when he comes in possession. If someone else steals that vehicle and hands him the keys or hands him whatever, you cannot say that he drove that vehicle or that he unlawfully drove the vehicle away, because that has to come in against the owner's possession and control, and not against someone or anyone else's possession and control. We don't know that any of the other two passengers didn't take that vehicle away, at least not from the evidence that's been presented here, that any of the other two passengers didn't take the vehicle and then give him possession later on. And that's important. So, with respect to the 2, 3, and 5 counts 2, 3, and 5, I believe that those are in fact issues for the trier of fact. With respect to count 1, I don't believe that the prosecutor has met its burden of proof. And if the prosecutor can get up and say that there is an exception for police officers, as the court suggests, and they can cite some case law.
I asked the question, Mr. Brown, so don't put words in my mouth.
I won't.
I'll hear from them.
All right, fine. So, and also with the UDAA, I don't think they've met their burden there.
Response.
I'll start with the assault with intent to murder. So looking at the jury instruction 17 and Michigan pattern criminal jury instruction 17.3, assault with intent to murder requires the defendant try to physically injure another person. Second, that when the defendant committed the assault, he had the ability to cause an injury or at least believe that he had that ability. And third, that the defendant intended to kill the person and the circumstances did not legally excuse or reduce the crime. Intended to kill the person, not intended to commit first-degree murder. That's a very different thing. And looking at People versus Erickson, a Michigan Court of Appeals published case 288 Mishap 192, this is from 2010, specifically states this, points to this jury instruction as the elements of assault with intent to commit murder. It is not assault with intent to commit first-degree murder. It's just assault with intent to commit murder.
So I don't even need to address that issue, whether there's an exception preventative.
There's nothing in the jury instruction
that requires. Okay.
And so then we're left with the question of is the defendant in driving a Ford Explorer at Deputy Phillips intending, can you infer from that behavior an intent to kill? And the argument before the court that the people would put forth is when you're piloting what is probably a 4,500 or 5,000 pound object, accelerating and pointing that vehicle at an individual, you absolutely, that those actions, there's a logical inference that can be argued that would create a question of fact that you're intending to kill that person. That's a mass, we're not talking about a motorcycle or a scooter or a golf cart or anything else. We're talking about a Ford Explorer. This is a large vehicle. The defendant looked, based on the testimony of Deputy Phillips, he was looking right at him. Deputy Phillips is attempting to get him stopped. He steers in the direction of Deputy Phillips, hits the gas, and hits him. Now, granted, Deputy Phillips was able to get out of the way, and it only struck his knee and kind of fell to the ground. But we have to consider the actions of the defendant, and I think to a probable cause standard, there is certainly a question of fact as to the defendant's intent. But unequivocally, if you take a Ford Explorer and you floor it and you aim it at someone, you can kill them. That is just common sense. Regarding the UDAA, again, relying on the jury instructions, unlawful driving away out of automobile requires first that the vehicle belonged to someone else. Second, that the defendant took possession of the vehicle and drove it away. And third, that these acts were both done without authority or without the owner's permission. Fourth, the defendant intended to take the vehicle without authority, knowing that he or she did not have the authority to take the vehicle and drive it away. As the court alluded to, that doesn't require that you must take the vehicle from the first place it was stolen. Now, I think that there's a logical argument and facts such that the location of the hotel versus the location of where this vehicle was found and the time frame that it happened at some point overnight, and this is 7:30, 8 o'clock in the morning. Again, there's a logical inference circumstantial evidence to suggest that the defendant did in fact take that vehicle from the hotel parking lot. We're not talking about one state over or, 200 miles away, something to that effect. But I believe that, again, there is sufficient evidence before this court to a probable cause standard that there is a question of fact regarding that count. And I believe the defendant should be bound over on all 5 counts.
All right, okay. With reference to, there is no dispute as to a bind over on count 2, 3, and 5. Therefore, the court also does believe that the people have sustained their burden and the defendant would be bound over on counts 2, 3, and 5 without objection as they raise issues of fact. In terms of the unlawful driving away of a motor vehicle, again, it would be this court going into the province of the jury as to when they first saw the defendant in the vehicle. Certainly a jury could reasonably infer from the hotel, the timing and everything else that it was indeed the defendant to do that. I don't think that people have to go beyond that. So certainly under that, if the theory is correct that it's got to be taken from the location from the owner, but I don't think that that's correct. But still, even then, I think a reasonable fact finder could conclude that. As it relates to the other piece of that, I think an individual can be charged with the unlawful driving away of a motor vehicle when they took possession or assisted in taking possession of that vehicle. I don't think it excludes, it doesn't get charged or can't be found to the exclusion of something else, a receipt and concealment. Certainly a reasonable fact finder could conclude that the defendant did, even at that location, take and or assist in the taking of that vehicle and its unlawful driving away. So that charge would be proper. A fact finder could conclude that, so the court would bind the defendant over for those reasons on count 4. With reference to count 1, the assault with intent to murder, I also do not believe that it requires first-degree murder and some premeditation within that. It is really the intent to kill, as the instruction indicates. But even though I do believe that if it were to require that, I think that premeditation is implied within the actions of the defendant because of what was happening, and there's no equal protection argument regarding that. However, very clear in the testimony where a reasonable fact finder could conclude the intent was Deputy Phillips' testimony that as he's there, the wheels of that vehicle are pointed right at him as it's accelerating out. It's not a circumstance where they were trying to go around him, they were trying to do whatever. And certainly a reasonable fact finder could conclude that that was an attempt to strike and kill Deputy Phillips. And that, as it then relates to count 5, maybe by the grace of God, Deputy Phillips gets out of the way. His leg is hit and injured. But that would, even though he's able to do that, that doesn't necessarily negate the intent that the defendant, or what one could find as the intent to kill in this case. And the court believes that there is sufficient evidence as it regards that under either theory of the first-degree murder or under the notion of kill. I think there's sufficient evidence to go forth to a jury on that charge, and therefore the court would find that people have sustained their burden and bind the defendant over on count 1. So to conclude, the defendant will be bound over to stay in trial on all 5 counts. Now that you see the information waive its reading.
Yes, sir. I'll let you see the waive its reading for the record. I'm going to enter it.
And having waived formal reading, pleading not guilty as to all counts, court will enter that plea. Pre-trial will be set for
August 13th, 2025 at 1:30 with Judge Collins.
August 13th, 2025, 1:30, Judge Conlon.
Bond will continue. Thank you. All right, Branscombe. All right. All right, how many witnesses are on Branscombe? 2. Ms. Lundy, you had 1 witness. Detective Hart.
Harvest will be the majority. I may have 1 or 2 questions for Deputy Phillips, but if I do, it will literally be less than 5.
So your witness is here and ready to go. Yes. Both of your witnesses. I'm likely going to take the Branscombe matter. I'll take the Branscombe matter first because it'll probably be quicker and I have a young person that needs to testify. So I will do that. What that's going to require is that I'm going to also then order the courtroom closed and at this point, and so that people will have to leave during the course of that testimony. I'm not going to close it for the entirety unless there's an objection. I'm not going to close it for the entirety, but during that individual's testimony. All right. So is that going to be, if I call Branscombe, is that going to be your first witness?
Yes, sir.
All right. So I'm going to, how many people do you have with you, counsel, that are here? Either, is that everybody back there?
Some of the folks inside township.
Okay, and so what I'm gonna have to ask to do, I'm gonna take a very, very break, or at least a brief break. And they're gonna have to be in the hallway, during that testimony. It will be permitted back in at some other points, in the case, so we'll make it clear to you when they can come back in, or as well as yourself. Sir, you in the back, you with them too, or?
No, that's Mr. Branscombe.
That's Mr. Branscombe. Okay, never mind. You stay right where you are, because you're gonna have to come up in a minute. Okay, so that is, we will clear the courtroom. That's gonna be your first witness?
Yes,
All right. So we will clear the courtroom, make sure that's done satisfactorily, and then we'll take that testimony. Court's gonna stand in recess.
All rise. All rise. 14A District Court for County of Washington, State of Michigan is now back in session. The honorable judge may sit.
You may be seated. All right. Let's make sure we have this. I think everybody's outside. Make sure they've got it. You ready? Call it go down. You still up?
I'm still up.
Okay. All right. Court does call the case of the people, State of Michigan versus Robert Lee Branscombe. Council, state your appearances.
Jacob County for the people, Your Honor.
Constable based on Mr. Branscombe, on behalf of Mr. Branscombe, Your Honor.
The truth, the whole truth, and nothing but the truth, so States for your first and last name for the record.
Kegancarney,
You may inquire.
Thank you, Your Honor. Mr. Carney, where are you employed? And how long have you been employed there? And what capacity are you currently employed? And were you working on April 25th, 2025?
Say, was I or where?
Was you? Were you working on April 24th of 2025?
Yes, I was working in Ypsilanti Township.
And were you dispatched to a 1463 Glengrove Street in Ypsilanti, Michigan?
Yes.
And what was the nature of that dispatch?
I was advised that a mother was calling stating that her son had been assaulted by his father.
And then you went to 1463 Glengrove Street?
I did.
And did you come into contact with anyone once you arrived at 1463?
Yes, I did.
Who'd you come in contact with?
That would be Reese Phelan and Zach Branscombe.
Did you observe anything about Zion Branscombe at that time?
I did immediately. I observed his shirt to be torn at the collar, and his neck had red marks on it. Right on the, I believe, the left side of his neck. What
happened after that? What did you do next?
Interviewed both of them. Reese didn't have a whole lot of information. She did state that there was mention of text messages sent from subject that she was concerned about regarding her son. Those text messages involved Robert being upset to some capacity.
Okay.
I interviewed Ryan regarding the incident. He stated that there was a physical altercation between him and Robert. He would advise me that Robert is his father.
Okay. Did you then later come into contact with the Robert Branscombe? And where was Robert when you found or when you spoke with him?
I believe the address would be 2377.
Was it at 2378 Briardale? Yes. Ypsilanti, Michigan. And is Robert Branscombe in the courtroom today?
Yes, yes.
Could you please point to him and tell the court something he's wearing?
He's wearing a white shirt.
Your Honor, let the record reflect that the witnesses identified the defendant.
Record shall so reflect without objection.
And did you ask Robert about the incident?
I did.
And what did he have to say?
He advised me that he didn't have a whole lot to say, but he did state that there was some altercation between him and Zion. He advised me that he was trying to tame Zion from Zion running away from whatever.
And did you notice surveillance cameras on the front of the home? Was it a Ring camera?
I would, from what I saw, I would call it a Ring camera.
Your Honor, this time I'd like to show the court just a brief 1-minute video.
All right.
This time, I don't think proper foundation has been set.
Hold on. You're objecting to the video.
Being shown, being entered into evidence.
On the basis?
On the basis of lack of foundation. I think, Your Honor, this video was sent to the police officer later on as a supplemental report by somebody named Felon. Don't know who that person is. I don't know if this video has been tampered with. I don't know if this is a reenactment or something else. I have no way of knowing. This was not part of the original police report. And as I said, somebody named Felon sent it over to the officer with no other information.
The video is time-stamped, Your Honor, and I do believe that the officer would be able to testify that this is an accurate portrayal of the video that he received. It does have the Ring watermark and the and a timestamp, as I previously stated, and it's very.
Where did it come from?
It's from the Ring doorbell camera from the 2378 Briardale court address. Counsel is correct that this was received from another party.
When you say from another party?
Well, not party in the legal sense, Your Honor, but another individual.
From what?
Another individual, yeah. Who provided this footage to the officer.
The camera's located at what, 2378?
Yes, sir.
Okay, well, that's the address I have for the defendant.
Correct.
So is that his Ring camera?
I don't know if the defendant is the owner of the home or if it's his Ring camera, one that he owns. I just know that it was on the front of the home at the time of the incident. And it is what the officer received.
Who sent it?
Ask the officer.
You can go ahead and ask the officer.
Tell the court who sent you this video.
I can't say for certain the email. I can't recall what the email was, but it was an email believed to belong to a subject named Ellen French, I think. I spoke to over the phone, which was, I believe, documented in my initial report. It had camera footage. I was advised by Robert that Ellen was his girlfriend at the time.
And then that person sent you the Ring camera footage?
It is believed to be her, yes.
So this came through an email to you?
Yes, Your Honor.
That's how you got it? How do I determine that this is authentic?
I think it's very clear from the video that it is Zion in it. You can see his face very clearly. Again, it is time stamped with the Ring watermark.
Okay, but let's assume all of that's to be true. Right? What authenticates that to be what you say it is?
I don't have an answer for you, Your Honor.
And I'm not going to allow it. I mean, I think there are serious issues when we receive something that way. And I mean, there may have been some additional follow-up, maybe not, but I don't know.
Sure. Nothing further from the people.
Cross-examination.
You said you're an officer of the Washington County Sheriff's Officer, that's correct, right?
Yes.
And you said you've been doing it for about 1.5 years? On the Road Control Division?
Road Patrol.
Road Patrol Division, okay, thank you. You arrived on the scene after this alleged altercation took place, correct?
I did.
You didn't observe any assault going on, correct?
No.
You didn't observe anybody acting disorderly, correct?
No.
Okay. Were you the first officer to arrive?
Myself and my partner.
Okay. How many witnesses were on the scene when you arrived?
More than 3.
Is it more than 3, or would it be safe to say more than 5?
Possibly more than 5.
Did you interview any of those bystanders?
No.
Did you interview them at any time?
There was one subject that was questioned later on. I can't say for certain if he was there at the time.
Okay. And that witness told you that he saw Zion approach Robert upset and that Zion may have grabbed Robert. Is that correct?
Yes.
Okay. Did you get this witness's information or name or anything about them?
No, I was carrying a conversation with Robert at the time as well.
And you didn't get this name or information because that witness is, what they were telling you was in favor of Robert, is that right?
Negative.
Okay. And you didn't interview any other bystanders or witnesses to the incident, right?
None were left on the scene.
No further questions, Your Honor.
Thank you. Any redirect?
Nothing further.
All right. Thank you, Deputy. You may step down. Any additional witnesses for the people?
No, not going to be there.
Any witnesses for the defense?
None from the defense, Your Honor.
All right. Do I have a motion?
Yes, Your Honor, the Assembly will provide over on count 1 child abuse in the 3rd degree. I do believe that the testimony from Zion Grants will provide that first, that he is the child of the defendant, Robert Branscombe, and second, that the defendant either knowingly or intentionally caused physical harm to him. Zion testified that he came to the home, 3178 2378, excuse me, Ryerdale in the city of Ypsilanti, Michigan, in Washtenaw County. And upon attempting to enter the home, he got into an altercation with his father, the defendant. But the defendant then grabbed him and grabbed him. They fell off the porch together and then placed his hands around the throat of Zion. And further, Your Honor, Zion also testified that he is 13, thereby satisfying the Michigan criminal jury instructions for child abuse in the 3rd degree. Does they offer their argument for rebuttal?
Your Honor, at this time, we would be moving to dismiss. I don't believe the people have, satisfied their burden. They didn't show whether he knowingly or intentionally, whether my client knowingly or intentionally committed a harm. The only testimony you heard was from Zion, who's unfortunately, his testimony was full of holes and inconsistencies. At one point, he said he did go to school, and he admitted that he didn't go to school. Admitted that his father didn't want him out. Then he said, "Oh no, that's not true." So, Your Honor, I don't believe the burden has been proven at all, and we would move to dismiss at this time.
The court, after hearing testimony in this case, does believe that the people have stayed their burden. The testimony, and certainly it creates an issue of fact as it regards, there's an issue of fact that should go to a fact finder in this case. Is the testimony of Zion reveals his dad was upset because he thought he was doing something, or at least that's from his perspective. He gets there and then indicates that he was grabbed by his father, pushed off of a porch. His father's on top of him. The father being the defendant is on top of him. And at some point, places his hands around his neck and causes scratches to his, Zion's arms, and also, red marks and other marks around the neck area, which Zion testified to. Court believes that that is satisfactory, at least for the purposes of preliminary examination, to bind the defendant over to stand trial. Therefore, the defendant is bound over to circuit court on the single count.
We acknowledge receipt of information, and we would request a transcript to be sent to our office.
Okay, you waive formal reading?
Yes, Your Honor.
And your client stands mute to the judge. Defendant never waived formal reading, standing mute. Court will enter a not guilty plea. Pre-trial in this matter will be set for
August 13th, 2025, at 1:30 with Judge Conlon.
August 13th, 2025, 1:30 before Judge Conlon. Bond with its conditions will continue. All right, thank you. If you need to order a transcript, then you talk to Mr. Wilding about that. All right. So, yeah, we need to get everybody back in. Court's going to stand in.
Have a good one, Your Honor.
Being a district court of the county of Washington State of Michigan is now back in session.
You may be seated. You said. Okay. No, I got it. We need to see your list, because I didn't address.
This one was withdrawn. H was withdrawn. And B was not admitted.
Got it. But then.
And then I have C through F.
Okay. Right. And those are the ones I'm more worried about, because on the people's side, you only have one.
Just A, just one. Yeah.
Okay. And I just want to make sure we get it clear on the record about that. Court calls case, People State of Michigan versus Jillian Carey.
Ashley Lonnie for the people.
Good evening, Your Honor. Michael Boletta on behalf of Jillian Carey, who's present in court.
All right. Your name, ma'am?
Jillian Carey.
All right. Thank you. All right. Just some housekeeping things here, counsel. I have a note that at the last hearing, you had submitted to the court exhibit C through F. But I don't know that I don't have notes of testimony regarding those. And C through F were not addressed at all.
Yes, Your Honor, that's true. The only exhibits that were admitted, we just confirmed with A are exhibits, defense exhibits A and G.
Yes.
Those can be returned. I'm not going to be going.
You will not be
I don't
using.
think I'm.
Okay. All right. That's fine. I just wanted to make sure.
As well as People's One. Those are the exhibits that have been admitted. This
Correct. I didn't have a problem with any of People's exhibits, so we can handle those. I didn't have a problem because I only had one. I had a note that was admitted. I had the admitted, no, those go to defense. And I had defense exhibit A was admitted, B was not, G was admitted, and I think H was withdrawn. I just did not have anything regarding those exhibits, and I just wanted to make sure the record's clear.
B wasn't.
Pardon?
No, B was not.
B was not.
That's what I thought.
Okay. All right. I think that's what I said. So I think we have it. All right. We ready to continue, folks?
The people are ready.
All right. Let me call your next witness.
Alex Phillips, Your Honor.
All right. Sir, please come forward and be sworn.
Before you take a seat, raise your right hand. You solemnly swear affirm the testimony about the truth, the whole truth, and nothing but the truth. Okay. I do. State your first and last name for the record.
Alex Bailey, Phillips, PHILLIPS.
You may.
Thank you, Your Honor. Sir, how are you employed? In what capacity? How long have you been in that position?
Approximately 5 years.
Were you so employed on or about November the 20th of 2023?
Yes.
Did you go to the Scioto Township office on that date?
I did.
For what purpose? And when you went to Scioto Township on the 20th, what were you going there to do on that date?
On the 20th, I believe, was to retrieve the laptop, reference the initial complaint.
Did you retrieve it? Where did you take it?
Back to Station 7,
For what purpose?
for safekeeping until Detective Parker distributed. Forensic, can you check it?
Not your department, correct? Okay. May I have one moment, Your Honor?
Yes.
You log it into a secure location at Station 7 when you kick it in?
I do not recall.
Okay, thank you. I'll pass the witness.
All right, cross-examination.
Thank you, Your Honor, just briefly. Good evening, Deputy Phillips. Now, are you the officer in charge in this matter?
Yes.
And on November the 16th, were you working on duty that day? And before I question any further, Your Honor, I'm going to go beyond the scope of that. Should I?
I'll let you go.
But I'm going to be brief, but I know that I'm going to
As long
ask
as
questions
it's-
that are not.
As long as it's relevant. to-
Okay, thank you.
Go
Thank
ahead.
you. I just wanted to let you know that. Thank you. And so you took the initial report that evening from Mr. Will Hathaway, is that correct?
Yes.
And he told you that, I mean, the complaint was just generally that his email had been breached. I think you said in your report. Is that right?
Yeah, I do think that is hearsay. I object.
I'm just establishing.
Regarding Hathaway's statement,
Yes.
I'm going to sustain that.
All right. Well, I'll move past that then, Judge, and I'll go
Well,
to.
hang on a second. Restate your question again.
I was asking him what was the general allegations, the nature of the
You
complaint.
know, I'm going to change my mind on that. I'm going to let that be answered as long as and we'll only be taking the responses to go to this officer's state of mind and what he may have done.
Thank you, Your Honor.
All right.
Yeah,
Go
thank you, Your Honor. And so the general allegation wasn't it that and I think Mr. Hathaway let you know that his email had been breached. In other words, somebody accessed his email and sent an email to another official at Scioto Township. Is that right? Okay. And then on November 18th, according to your report, you spoke with Detective Parvis. Is that correct?
Yes.
And you gave him a short summary of the allegations. Is that right?
Yes.
And based on this short summary that you gave, Detective Parvis told you that criminal actions had been taken. That's according to your report. Is that right?
Your Honor, objection hearsay.
Oh, I'll overrule it.
Thank you, Your Honor.
And when he made that statement to you, you put that in your report, correct?
Yes.
And that was on November the 18th, correct?
I believe so.
And that was 2 days before you just testified that you went and retrieved the laptop that's at issue in this case. Is that right?
Yes, sir, that sounds right.
Okay. So did you think his declaration? Well, I'll withdraw that question. The warrant was issued for my client on June the 13th of 2024. Is that right?
I believe so.
But without tying you to a particular date, was it around June of last year that the warrant issued?
That sounds right.
Okay. But you didn't swear to it. Is that right? And Officer Howard Schaefer did. Is that true?
Yes, sir.
Did you provide all of the relevant evidence and information to Deputy Schaefer prior to his swearing to this?
I'm not entirely sure how he reviews the reports, but he reads the report that's submitted and swears to it, is my understanding.
Okay. And before you sought the warrant, did you do any investigation yourself?
I interview people.
Did you interview Ian Hubert?
I did.
Did you write a report on that? Or did you like a separate report for Ian Hubert's interview?
It was in one of the supplemental reports, yes.
All right. So it would be like a paragraph or two in the report, but not a separate report. Is that right? Do you know when you interviewed him? If it isn't in the report?
I believe it was in the report, but off the top of my head, I don't know the exact date.
Would it refresh your memory to look at your report?
It was.
Can I approach?
You may.
Look at that and let me know if that refreshes your memory, please. And if that's not the right report, please let me know that too. Did that refresh your memory?
Yes.
And do you recall now when you interviewed Mr. Hubert?
I believe it was the next day.
When you say the next day, would that be the November the 17th?
Yes, sir, I believe so.
Okay, so when you say the next day, so the next day, the day following the day that he came in and made the complaint, correct? And did you also interview Mr. Will Hathaway?
Yes, sir, I did.
And did you also interview Jillian Carey?
Yes, sir.
Did you interview Jessica Flintoff, the individual who is alleged to have received the forwarded email in question? If you didn't interview, what's the reason why you didn't? Were you actually in charge of the investigation, or at some point did you turn it over to Detective Parvis? Okay, just because I don't understand it, would you consider Detective Parvis then the investigator in charge of the case, or are you both investigators in charge, or is there no designation? I don't know.
I wasn't the officer in charge, but I think Detective Parvis and whatever.
All right, just so that I don't waste the court's time, especially if it's late hour, I'm not going to ask you any questions. Then, if you don't know anything about Microsoft Purview audit logs or anything like that that go to the heart of the issue in this case on the computer side of it. You don't know about that stuff, correct?
Correct.
All right. Did you interview Francis Zuma, the recipient of the calendar invitation in this case? And again, is there a reason that you didn't, or was the duty at some point to interview witnesses, was it turned over to Detective Parvis?
Joint venture.
Okay, but do you know why she wasn't interviewed, if she wasn't? And if I can approach you on what Exhibit G admitted, can I approach you on it?
Yeah.
Do you recognize Defense Exhibit G? Have you ever seen that document?
I don't think so.
Okay. Did you, during the course of the investigation, did you speak with one of Ms. Carey's attorneys named Mark Chutko?
I believe I spoke to an attorney, I'm not sure. Though.
Okay. Did Mr. Chutko provide you a copy of Exhibit G, if you recall?
I don't know.
You don't recall? Okay. And do you see what's highlighted on that page? Could you just read that?
Your Honor, the exhibit speaks for itself.
I want to ask him about it. What it
Did you
says.
see the highlighted, the part that starts with sorry?
Well,
Yeah, I wanted to read it so I can ask a question about it.
Well, we'll read it, not out loud, just.
All right, read it to yourself if you
Go
will.
ahead, and then you can ask questions.
Okay. Okay, so it's an email. You see there's an email to someone named Kim Moore, amongst other people, by looks like Mr. Will Hathaway. Do you see that?
Yes.
And do you see that the email says, sorry, this email seems to have sent itself again when I logged in just now? Do you see that?
Yes.
Okay, would that have been an important piece of evidence for your investigation if you're trying to find out whether or not the email in question was sent by Mr. Hathaway or whether it was sent by Ms. Carey? Would that have been an important piece of evidence, do you think?
I'm sorry.
Well, I'll rephrase the question. It was a poor
Thank
question.
you.
Yeah, I'm sorry. If you had seen this, as you read it, as you heard me read it now, and you read it to yourself, would that have been something that you would have put aside or said that this is important to the case?
Yes.
And do you recall doing that? So then do you think you didn't receive this, or do you not recall?
I don't believe I received it.
Okay. All right, thank you. I'll grab that back. And you didn't interview Kim Moore, the woman on this email, did you?
No.
Did you investigate the relationship between Jillian Carey and Mr. Hathaway to see if there's any acrimony between the two of them or any motive by either one of them to either send an email or say that someone sent an email? Did you look into the relationship, I guess, in your investigation?
I was informed of some tension.
Okay, but did you interview anyone based on what you were informed or no?
I don't believe I interviewed anyone specifically about issues that I don't believe it was brought up during the course of speaking to people.
Okay, and then on November 19th, the day before you went and you got the computer, did you interview Jillian Carey at her home? And did you give her any notice that you were going to come out and interview her?
I don't believe so.
Okay, and you did that at night, right? Is that right?
Afternoon.
Okay, and did you go by yourself?
I believe so.
Was there a reason that you went at nighttime without giving her any notification? Did you consider maybe calling her and letting her know you were coming?
I generally just go knock on people's doors first if I can, and I work at the time I worked 4 to midnight roughly.
So it was really based on your shift is why you went later in the day as opposed to trying to gain some kind of tactical advantage. Is that right? And she agreed to speak with you, did she not? And she invited you into her home? Was she cooperative? And did she agree to answer questions about what happened? She did? And and isn't it true that she didn't admit to doing anything illegal? Is that correct?
This time is the hearsay.
Just saying.
All right, in your report, I noticed that you updated your report on occasion. Is that fair to say?
Yes, sir.
And one of the updates in your report, you write, William requested to have Detective Parvis look through the computer. And I can show you a report again if you don't recall that. It's on page 5 of your report. Would you like to see that again?
No, I
All
remember.
right. So was it the fact that William Hathaway requested that Detective Parvis look at the computer? Is that what caused you to go get the computer?
I believe I was coordinating with that, Detective Parvis, trying to examine the computer to see if that would be, beneficial for evidence.
Okay. But you weren't doing it just because William Hathaway asked for it. That was Detective Parvis who said you need to get the computer. Is that right? Now, I understand that you took the what we call the shared laptop. We're going to call it the shared laptop, the shared SIO laptop. You took that to get to Detective Parvis to examine forensically, correct?
Yes.
And did you ever take William Hathaway's cell phone? So it was never imaged as far as you know, correct? It was never extracted, I guess is the right word.
That's right.
Okay. And did you try to determine what other devices that Mr. Hathaway was using at the time this email incident occurred?
I don't know.
So you don't know if he was using an Apple computer, for instance, an Apple laptop? You don't know? And Detective Parvis never had you go get any other devices besides the shared laptop, correct? Is there any reason why you didn't image the other devices if the issue had to do with who sent the email?
Any reason he didn't what?
Any reason that he didn't get any other devices to see what the activity was on Mr. Hathaway's devices?
After speaking to Detective Parvis, he recommended the laptop, pull it out of my wheelhouse.
You were kind of letting Detective Parvis make the calls on what he needed forensically, correct?
Yes, sir.
And do you remember on February 9th of 2024, Mr. Chetko providing you a copy of Exhibit G? I was just wondering if the date would help you. Do you remember getting something from Mr. Chetko in February of 2024?
I do not.
Okay. And are you aware of Mr. Chetko sending you a copy of a report done by a company called N1 Discovery? And my last couple questions have to do with this. You were aware at the time that you were investigating this initially, and I'm talking about in November of 2023. You were aware at that time that William Hathaway was the supervisor of Scioto Township, is that right?
Yes.
And the fact that he was the supervisor of Scioto Township, did that have any effect, either positive or negative, on the way you handled your investigation?
Yes, I believe so.
Okay, can you explain that?
Given that it's a high profile nature, generally it's better to inform people above supervisors and so forth.
So as far as notifications, you were more careful with that because of the complainant's position?
Yes.
Anything else that you did differently? So there was no special treatment given to Mr. Hathaway, certainly, was there?
I believe so. No.
Thank you. I have no further questions.
Can you redirect?
Yes, Your Honor. Deputy, do you still have a defendant's exhibit G with you?
Sure.
Okay, great. I'm just actually, if I can use the system, I may prefer that. May I, Your Honor?
Yes.
Thank you. Deputy, you testified earlier that the date that you initially went to this call and sort of worked on this was in what month of what year?
2023.
And this should be live now. This is defendant's exhibit G that's previously been admitted into evidence. You were asked questions about a few moments ago. Do you recognize this?
Yes.
What's the date on this email?
1/31/2024.
So when your investigation was happening initially in fall of 2023, that email hadn't even been sent yet? Thank you.
Thank you. You may step down. Thank you, sir.
Is he excused, Your Honor?
No objection.
All right, this witness is excused. Thank you, sir.
Thank you, Your Honor.
May I call your next witness?
Kevin Parvis.
Sir, please come forward to be sworn.
Steve, raise your right hand. You solemnly swear affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, so help you God. States for your first and last name for the record.
Detective Kevin Parvis, last name spelled Parviz.
Thank you.
Inquire.
Sir, how are you employed? And how long have you been in that position? Do you have any other prior police experience?
Yes, I was at Detroit,
What role or position do you currently have within the sheriff's department?
I'm in charge of our computer forensics lab.
And what does that entail?
Forensically examine cell phones, computers, digital media in general, and pretty much anything that is computer related.
Do you complete extractions and forensic downloads of different devices as a component of that? And do you, or had you previously worked with Homeland Security as well?
Yes, I worked with them for as a task force officer for nearly 10 years.
What is your educational background?
I have a bachelor's degree in insurance, network security, specification, and master's degree in computer forensics, and a PhD in information assurance with my dissertation specifically in computer forensics. I also did some postdoc research with Simpsons.
Do you currently teach? Have you taught in the past?
Yes, I taught for
Where at?
both at Eastern Michigan University, both graduate and undergraduate classes, and at the Washington Community College.
What types of classes would you teach at those facilities?
Anything from incident response, network security to computer forensics levels 2 and 3, the highest one is 3.
What special training do you have related to computer forensics?
I have more than 70.
You stopped counting? Do you recall when your most recent trainings may have been?
Most recent one was actually last week. Was a certified operator at CPLA, certified operator.
Cellbrite is a tool to extract cell phones. Your Honor, may I approach actually take it to the court, a copy of People's Proposed Exhibit 2?
You may.
And your current title, sir, is that a detective corporal, is that right?
Detective.
And how long have you been a detective corporal?
Since March of 2003.
March of 2003. So you've been a detective since 2003? And your Honor, permission to put People's Proposed Exhibit 2 up on the screen? Have you recently completed or updated your curriculum vitae?
I did. I don't think it reflects my last week's training.
Not last week's training, but up recently. Does this appear to be a fair and accurate copy of your CV? 8 pages?
I believe so.
Your Honor, I move for the admission of People's Proposed Exhibit 2.
Any objection or voir dire?
No, Your Honor.
She was admitted.
Sir, have you previously been qualified as an expert witness?
Yes, I was.
In what fields?
In computer forensics.
How many times have you testified as an expert in computer forensics?
Many, many times.
Have you been qualified as an expert before judges within Washtenaw County? Your Honor, I move to qualify this witness as an expert in the field of computer forensics.
No objection.
So qualified.
Thank you. Detective Parvis, how did you initially become involved in this case?
Deputy Phillips, some cases has come up.
And what is your general process when you're going to become involved in a case and do any computer forensic investigation?
I basically start collecting evidence through the officer in charge of the case. In this case, Deputy Phillips. I ask him to, my role is an assistant to the local patrol, that I can't go and collect and do the computer forensic backlog that we have.
What, if anything, did you advise Deputy Phillips to do in this case, reference the computer at issue?
So initially, I needed to get I believe it was the header, email header information which he provided, and then I needed to get the server logs. That's usually the first thing I do. And I believe at some point, 2 years ago, so I believe that he told me that it was getting too technical, so I kind of stepped in and contacted the Cedric Township IT.
At some point, did you actually get your hands on the laptop at issue in this case, what's been called the Scioto Township shared laptop? Were you able to image that laptop? What does that mean?
It's basically, when it comes to computers, it's a bit by bit graphic image that needs to be that item, digital item on the storage portion of the laptop. It's going to be transferred to graphic machine.
And did you complete, I'm going to start with, did you complete a report and date it December 14th, 2023 related to this case? And does that report contain your expert conclusion and analysis? Your Honor, I have for the court, People's Proposed Exhibit 3, which I move to admit at this time.
Your Honor, I'm gonna object. This witness's report is hearsay. It's not his understanding to testify about findings of the report. I've never seen anyone introduce their actual report as evidence. I don't understand the basis for this. So hearsay is my objection. Thank you.
Your Honor, he is an expert witness and he has come to these conclusions. These are his expert conclusions, excuse me, and the report that he prepared for this case after analyzing the evidence. I do believe he is allowed to have this. I do think this is a proper thing to be admitted for the court to consider.
It's statements of this witness. The witness is on the stand. You could say what his report concluded.
But if you have an expert witness and they produce a report, could have a number of different types of expert witnesses, why wouldn't they be allowed to submit their report?
This reads like a police report, Your Honor. He talks about who he questioned, what they said.
No, but your objection isn't that it reads like a police report.
It's hearsay. Thank you.
Well, right, but your objection is that the report itself should be okay.
Yes, if there's something particular in the report that's not being authored for the truth, I would have no objection, but there's lots of stuff in here that's statements of
As
fact.
an expert, though, he's permitted to give his opinions, his conclusions. That's what's different about this report. And as you compared it to a police report, that's one of the distinctions. I mean, experts are allowed to do different things. They're allowed to deal with hypotheticals. Experts can do different things. So is your only objection to that report that it's hearsay?
That's my objection.
All right.
Most of this is hearsay. Thank you.
I'm going to admit Exhibit 3.
Your Honor, may I approach the witness and the court with copies?
Yes.
Thank
Sorry,
you.
you overruled it, Your Honor. I didn't hear your ruling. You overruled it, correct?
Your objection?
Overruled, right?
Yes,
Thank you.
on that basis.
Okay. So starting on Exhibit 3, page 1 appears to be a cover page, correct?
That's correct.
And starting on page 2, there's a highlighted portion. What was significant to you about the bottom of page 2 where you wanted to highlight this piece of information?
It is showing the email that sent out, and it is using an IP address.
What's an IP address?
An IP address is basically like it's the translation, the technical version, or you want the.
You, sir, I trust your explanation, so you can give us both if you prefer to make it a little more hands-on.
So when a computer needs to internet, actually provide credentials to the internet, then the internet will assign it a number, and that is the IP address, like a house address.
And you were able to determine what about this IP address, if anything, or why was it highlighted for you?
Yes, it's that is the Wi-Fi IP address of Cedric Township.
Okay, thank you. And so knowing that this is the Wi-Fi address of Scioto Township, moving on in your report, and page 3, I see a section called message trace. Can you explain what the message trace is, please?
Message trace is basically a function within a server that an email server that you can command it to information, really detailed information about an email that was sent to receive journal. Whatever happens to an email is going to be.
And you mentioned something about an email server. Is there a distinction between an email server and what's on a computer about an email?
Yes, an email server. So when emails came about, they were using what was called COP, that was the Post Office Protocol version 3.3. And with that, you had let's say, a laptop. When I communicated with somebody, whatever I sent and whatever I received remained on that computer. The problem was, if I'm at home and I leave the laptop behind, all my emails are going to remain on that laptop. So they came up with a newer protocol, and with that, it's called IMAP, and what it does is that the computer becomes the brain of the operation. The laptop will give the illusion that you're actually commanding something, but all your commands are going to the server. And I'm sure we've experienced when we had internet, but then we're trying to send an email and if the server is busy, you're going to get a little circle. And if you click again on your mail application, it's going to turn into a very ghostly looking thing. That's because the server, you are at the mercy of the server.
And when you perform a message trace, are you looking at server data, computer data, both? What are you doing?
It's basically both and then some. It also shows the nodes that it had traveled through. It's the header information provides some information, but the server log is the mail server log has much more extensive.
When you started doing the message trace on the email at issue here, the one that was sent to Will Hathaway on the evening in question, what did you find?
I found out that if I could take a look.
Yes, it's in evidence now, so you're absolutely allowed to refer to People's Exhibit 3.
So
page 3, I think, is where we're at right now.
I see that there was I saw that there was a lot of communications. There was a log of transactions starting at about 6:08. I'm sorry.
If you have a different place you'd like us to look at the information.
So this is UTC time, London time. It's going to be $2,200.
And that's in the back of the report where we have this sort of just raw data, I'll call it, page 7 of 8, towards the end of this report.
This is a because of the communication that we have with our unfortunately a lot of excess.
Okay. So the sheet that we're looking at now, it should say at the very, very top, 2023-11-15T 220450 journal at Scioto Township. Okay. On this page, please come on.
I'm tracking this. I have the page 8 of it.
Okay. Page 7 of it. 7 of it. Yep.
At the top?
Yep. I just wanted to make sure we're all on the same page. So please go. Please, Detective.
Hold on.
Yeah.
7 of 8.
Yep. So it's this attachment is 8 pages. So it is 7 of 8 towards the back, Your Honor. I believe.
No, I see that.
Yeah.
And then you say at the top it says what? Because mine.
May I approach?
Yes, because I'm Council Pro. Because I'm 7 of 8. Yes. This one?
Yes.
Okay.
Perfect.
I
believe that's correct.
Maybe I was looking for a header, so
Yes.
that's why I was, okay, go ahead.
Thank you so much, Your Honor. I appreciate the court's patience. Please, Detective, you're on this page.
Can I put a little dot on where I'm talking because they're small print, so I don't have any court.
Yeah, of course. Whatever you need to do. That's your copy. The court has its own copy.
So the part that I'm starting is 2023-11-50T. 23. That's where. So it's about halfway through the page. 2308.
All right.
That is where it says J. Flintoff at Scioto Township.
And what does that column represent?
So we have one column that has the date and time stamp to the last second, and then you have the name of person that was sent the email to, which is J. Flintoff at sciototownship.org. Then we have the subject line, which is forwarded external RE Election Commission WF. The originating is the Will W. Hathaway at sciototownship.org. And then in front of it, at the very last column, rightmost column, at the IP address 170.218.115, which is Scioto Township's
Okay. So as you began your message trace, that was one of the first things that you looked at?
That was one of the first things that I saw. That was the issue.
And after looking at that, what did you learn from that?
That an email was indeed sent at 23:08:38, which is CTC time, local time would be 6:08 p.m. and 38 seconds. An email was sent out to Jay Flintoff, using, bouncing off of the, Sarah Township Wi-Fi. We also have the name of the subject line for that.
What are these other entries at the same time, just very, very small units of time apart that say journal?
Sure, the computer does, processing unit does a lot of processing. So there are a lot of things that happen. As I mentioned, the server logs in any transaction that happened regarding that particular email. Here we have the journal. Journal is the basically write ahead kind of, it's the older version of the write ahead logs. So the computer is not putting this into its hard drive yet. There's what's called 30 pages in the RAM right now. And before it gets cached in back to the hard drive, that's what it's showing. It's not like a bunch of emails went out, it's just one email, the rest of the computers.
And do you notice anywhere in here where you can see where a different, or maybe a later time or anything else that you observed, or is there any other?
So there, the email that went out at 23:08 is followed by 3:08:39 seconds. So this is 6 hours later. Mr. Hathaway's email was used to it looks like a reply email. It looks like a different IP address was used to send this email with that subject line.
You said about 6 hours later? All right. What did you do next?
Then I basically started asking questions. Again, I was getting to the technical part of it, even though I was still assisting. Phillips may have not known what to ask, so I ended up asking Mr. Hathaway several questions about wherever I was. And then I asked, a later time, I asked Deputy Phillips to get the laptop.
So at this point, you've just analyzed the server logs.
Yeah.
What happened next?
Well, can I look at my report?
Absolutely.
Did I ask, reach out to the IT person, Chris Bailey. I did reach out to Mr. Hathaway by analyzing server logs, and then I received a laptop and did the forensics on it.
How did you complete the forensic imaging or download?
I usually use FPK Imager that I've been using for the last 20 plus years, and then I tried to use FPK 7.6. I got errors. I tried Axiom and other forensic tools. I got errors, and then I had to upgrade FPK to version 8 and successfully acquired the.
This software that you use, what kind of software is this?
It's a forensic tool that I have been using.
Is it available to the general public? Okay. And how do you get it, or how is it given to you?
The county purchased it. It's about a $10,000 a year.
What did you do after you were able to image the laptop?
Once I did that, and then I started, well, the imaging part of it is you just create a file, a bunch of files. These are compressed files, and you have to actually use acquisition to parse out what these files are. What's an email inside this, what's a picture inside of it, all that. So that acquisition part of it took place in FPK version 8. Then I started analyzing. Again, I go straight to what matters in this case. I went straight to the email. I noticed that the email went to the email.
What's the email application on this laptop that had been deleted? What was the email application on this laptop that had been deleted?
Okay, it was Apple, a desktop version. Apple.
And do you have a term that you use when you're looking for pieces of evidence within a computer?
Yeah, they're called artifacts.
Right. Were you able to locate artifacts related to this email?
Yes.
What were you able to locate?
So I was initially I did the general findings and finding out when this application was installed, some inquiry on that, and when it was deleted.
When was it deleted?
It was deleted at 6:24. That same day when that email went out.
And what happened next after you were able to look at that?
I continued with just general looking up at I did some inquiry on who was there operating the laptop. And I also wanted to see if there was any key fob information, people entering the township hall, things of that nature, and pretty much.
What happened next?
So after that, I did some, I usually search for a case like this, again, specific to this case. I wanted to see if there's any possibility that Mr. Hathaway would have get into that laptop when he was in possession of the defendant. And I checked to see if there are any viruses in there, any remote applications. I didn't find any remote applications, no, not even artifacts.
What is a remote application, for the record?
It's like a Zoom call, sorry. Yeah, it's like the team viewer, a bunch of applications that can basically take control of the other laptop in a distance.
Did you find any evidence of that on this computer? Did you find any evidence of a virus on this computer? What else did you do in part of your investigation?
So after that, I went to, because the email was deleted, the email application was deleted, I had to resort to the database called the search database within Windows. And its functionality is basically to, we refer to it as Windows spying on you, but truly what it does is that it tries to maintain to find out what is happening to the computer so that when you're looking for something, you can actually search for it. It uses this version of the laptop. It's Windows 10. It's using an older version. It's called the ESE database. It's kind of an almost text-based database. Things have evolved tremendously since then. So I went into to check for that specific email to see if there are any artifacts left behind of that particular email.
Were you able to find any?
I was.
What did you find?
So I found it in the search. So this is not the email. This is not the actual email. What the search does is that it records it records portions of the user activity. And in this case, I looked at it. Well, this is not automated provided by the forensic tool. It is the manual carving of the data. So I found that email and I carved, and at the bottom of it, this is on page 8 of 11 of my report.
The first set of 8, the first page 8, correct? So on the first page 8 is where we're looking now, right?
Right.
And this is the page that talks about hexadecimals?
Yes.
Okay, we'll come back to that in a second. Please continue.
So this is, as you can see in the screenshot, on the top portion where the numerals 1 and 2 can be seen, that's the actual one. It's a hexadecimal. It shows the forwarding address, which is the same as.
I'm sorry, Your Honor, can I find out where we are? I'm not tracking where he is.
Page 8 of
8 of 11, which would have been starting at the beginning of the.
Yep. I also checked this long thing, yep, for the possibility of a scheduled email.
So the portion on the top that has numerals 1 and 2, that is what is presented to me. The big middle portion that has numerals 4 and 5, that's the tool that I use to interpret the number 3, that's a tiny little timestamp at the bottom.
And what are hexadecimals?
So that's how computer talks. It interprets zeros and ones into hexadecimal. So
rather than binary, it has a different language?
It's based on zeros and ones. They're converted. Other than putting a bunch of zeros for one, right? It's using that to simplify it, make it shorter. So I found that, and I knew that where the time stamp was, so I located it right under the entry, and it is in hexadecimal, and I used a tool called Decode and turned it into English to readable format.
And what were you able to determine about the email in question?
So I saw that the search database you have when the application was touched, we call it Linux touched or opened access. And then you have the closing of it when the activity is done. And then you have a third time, that is when the database is tabulated. So the first and the second, the first one here is showing when this email was accessed. It was accessed at 6:08:00 on 11:15. That's what it's showing.
All right.
Now,
What did you see? What else did you see about this email?
so that takes us to the next page, which is the second entry in the search database. And that is the same thing on the top. This is top very bottom portions from the computer. The middle part is my tool to interpret it. And as you can see here at 6:08:37, this transaction was done. So
What was this transaction?
this transaction was opening the email at 6:08:00, and then the user was done with that. We don't know what happened. He actually did what the user did, but the transaction was completed 37 seconds later.
Do schedule send emails create red artifacts?
So they don't.
Is the first artifact in the hexadecimals that we see on page 8 a red artifact?
Those are actually the computer marks it as red.
Ah.
That's what it does. I always try to be cautious about that. I use the word red in my first report, just following what the computer said. But I wanted to be more accurate. So my supplement report after that, I mentioned this and I said that I erroneously said red. The computer says so. I would change that
Accessed. So does a schedule send email create an accessed artifact? It does not, correct?
No, it doesn't. If something is scheduled, you're not gonna see it.
Okay.
Because it's not done by the user.
Based on your expert opinion and these artifacts, are you able to determine if a human being opened this email?
Yes.
And what is your opinion?
My opinion is that it's, the user double click on that email and open it.
And what happened 37 seconds later?
I don't know what happened, but for that, I have to refer to the server log. Server log is showing that that was sent at the exact time, plus 1 second. So at 6:08:38, 37 seconds, that email was sent.
So we have an artifact on the laptop. It's 6:08:37, and then we have a server log showing a sent email at 6:08:38. What did you do next?
Then I checked for event viewer. Usually the event viewer gets us some system information which that didn't have. And then, but at that time, I thought that I advised the township supervisor at the time, Mr. Hathaway, to issues with a couple of things, security wise. And then operating at Scioto Township. I knew that that email was sent from Scioto Township, based on the IP address. I knew that the email was open at 6:08, and I knew that email was sent at 6:08:38. And based on all of that, I closed this case and turned it over to.
At some point later, did you complete another expert report in this case?
I did. This happened about a year and a half, I believe. If I could.
Yes, I'll have it for you here in just a second. Your Honor, may I approach the witness in the court with People's Proposed Exhibit 4? Thank you. Detective Parvis, I placed in front of you what's marked as People's Proposed Exhibit 4. What do you recognize this to be?
This is my second forensic report. And this was after, myself and, Assistant Prosecutor Childers and the defense, the two defense attorneys at the prosecutor's office.
And is it a fair and accurate copy of that report?
Yes.
Does it contain your expert opinion and analysis of the evidence in this case? Move for the admission of 4.
Objection, hearsay, same reasons as before.
This is a report that is his conclusions based upon his analysis.
Further analysis and investigation, Your Honor, that's correct.
This was, I mean, the participation in this was actually by all parties
Yes, I believe so.
at this point.
I don't think the defense attorneys are named, but my understanding is that defense counsel in the courtroom was one of them.
Yes, Mr. Bellotta's name.
Oh, I'm sorry, maybe in a different area. I'm looking at a different part.
Page, well, named, but it's really referenced to.
Oh, yes, I see it lower here. Yes.
For defensive actions, I'm going to admit the report.
Thank you, Your Honor. Detective Parvis, when you completed this report, what were you attempting to, what hypothesis were you testing?
What happened was that the defense had issued 2 emails, 2 pieces of pieces of paper. One was showing that an email was sent twice, and another one was that a Zoom call that was supposed to go out on November 13th, was a scheduled meeting on the 13th, was actually sent out on the 15th.
Were you able to verify those with server logs? No. Were they presented to you with server logs?
Well, that was the main issue because they were not in the server log. So when you're looking at November 15th activity, you don't see the Zoom meeting invitation going out, but everything be on that server.
Did you do any further investigation contained within this report?
Yes, I actually started, I went and talked to Mr. Hathaway, and what happened. He sent me an email back, and I copied our email, minus the lines of dates. But the what he's doing, and I copied that basically. And then that's pretty much
Is this the shortest of your reports?
this
Okay. And at some time later, did you actually complete a third forensic analysis and report for this case?
Yes.
And Your Honor, may I approach the court and the witness with what's been marked as People's Proposed Exhibit 5?
Yes, ma'am.
Thank you. Detective Parvis, I placed in front of you what's been marked as People's Proposed Exhibit 5. Do you recognize that?
I'm gonna object for
Yes, same objection.
hearsay as well as hearsay.
Okay, same ruling, same ruling. Five's admitted.
Thank you, Your Honor. Shortcut the process a little. Detective Parvis, what is the date of this report?
This one is on April of this year, April 8th.
All right. And what did you examine in this report?
Specifically, the defense had hired a forensic examiner to over the finding on the same laptop. I provided them the image, the forensic image, and then in return, I received a report by the forensic person. My counter to place.
So starting at the beginning, which of the claims or hypotheses in that report did you disprove?
This is, I refer to the forensic examiner by his last name as Lieb.
Lieb as in boy?
And the first thing that I went over was that he stated that, can I give a summary of what the defense's forensic examiner said in it?
If it's part of what forms your expert opinion, you may.
Yes, it's, this was usually when we do computer forensics, it's based on what we see in as evidence. It's completely evidence-based analysis. Here, the defense examiner, what he did was that they had an idea in their head that there was some sort of conspiracy.
You're not going to object to the characterization of what any defense expert had in their head. I think this is inappropriate speculation. He can give his opinion, but he can't describe.
Yeah, but he's describing it as how he sees it based upon then from that, his analysis. So certainly you can question him on what may be the premise of what he's saying, which may or may not lead to his conclusion.
I have no problem.
I think certainly he can state it, so objections overruled. Go ahead.
So you're talking about an evidence-based versus what you saw here. So please continue.
Yes, I'm not trying to do that, but I'm just, based on what I read, the defense examiner was trying to do what's called a Texas sharpshooter fallacy, which is when there's a big difference between shooting at a target and shooting at something and drawing a circle around.
Oh, okay.
That's what they were doing. They started with an idea that there was some sort of a conspiracy, and then they expanded on that following that. And my second page of the report has a direct quote on that. And I started by saying that should I read on what the examiner said?
It's in evidence. You don't need to, but you can start talking about what your conclusions were based on this report.
So the initial part of it is when the login time was, which is correct. That's what I came up with too. It was at again UTC time 11:04, so it's going to be 6:04 seconds. Then the second part that probably the second thing that I actually agreed with the defense examiner was that the Outlook was launched at 6:07. So they logged in at 6:04. Outlook desktop version was launched at 6:07.
So you agreed with those conclusions.
After that, part of it. There are actually two additional things that the defense examiner did not include in his report, and that is between 6:04 and 6:07. There are two additional things that happen, and that is the Zoom application appears to have been activated at 11:05 and 11:07.
What did you look at next? Or what else did you see?
We also have at 11, again, I'm mixing these. I'm going to go with local time, so there's no confusion. At 6:08, we have two event ID numbers 325, of which is basically the computer is rejecting the user's access. Its access is denied. The user was trying to access something that they were denied. After that, one of the things that the defense examiner was saying was that their idea was that Mr. Hathaway was somewhere else and forwarded that email to Jay Buntoff, and the defendant had nothing to do with it. And the problem with that was that we have the server logs, and it's showing that it was coming from the South Township Wi-Fi, was hitting the South Township Wi-Fi. We also have the artifacts of that email, as I mentioned in my first report that I manually carved out, that laptop, that very laptop was involved in that email setting. So we have the location and we have the device. And the defense examiner completely ignored all of this and just pushed on with the idea of having a second email. The rest of his report is pretty much talking about I had to mention in my report, I referred to the email that was sent out that we're here for, as the election email.
The election email, okay.
And the defense had, in my second report, as I mentioned, we had a meeting with the defense and they kept bringing up this Zoom invite that was supposed to be scheduled for the 13th, but it was set on the 15th. And at the same time, or almost at the same time as when the defendant was operating the laptop. And the defense examiner were basing a lot of their goal to try to prove that the email invite and the Zoom invite and the election email were sent at the same time. And that's why there's somehow Mr. Hathaway was somewhere else on sending. So, and that's I'm not gonna read it verbatim here at the bottom of page 3.
And that's an excerpt from the other report, correct? Okay. And then going to page 4, what else did you do when you were analyzing this again?
So even though I had done this before, this time I went to the automatic version of this email, that election email. So on page 4 of my report, you see that I have a screenshot of what Axiom is telling me that, as you can see, there's 3 transactions done by search. This is Windows search again. We're not looking at the email, that was deleted. We're not looking at Outlook, we're looking at Windows search tags. And as you can see, it's showing that at 6:08, I'm translating to local time, there's a user communication. It's tagging it as such.
Why is that relevant to your analysis?
Because it has to be, when you click on it, there's something, and I think it's an attachment to this report. There's a little signature at the very bottom, and it says MAPI. MAPI is a messaging application programming interface. And that is for Outlook, and it's when the user is actually interacting with the application. And based on that, Axiom, in this case, Axiom Forensics that picks up on that and says, okay, this is a user communication they clicked on.
What is a user communication?
the user communication with a human being that is using Mappy, which is the email container. So it's two factors.
Not automated, not the computer.
And then you can see the second entry here, again, looking at search database at 6:08:37 seconds. This is the part that I had manually carved out. This is the automated version. As you can see, it says user communication. That's the column. That's because a user was using it. The last entry, as you can see, there's no user communication. This is because databases have those three actions. The third action is this is an entire semester of teaching it, but
Let's get the cliff notes.
much shorter.
Thank you.
It's basically so if you're just think of database as an Excel sheet. Something constantly adding things to it and constantly taking things out of it, you're going to consume your entire computer's processing power. What happens is that when a bunch of transactions are happening, for example, if you're on the internet, you're going from page to page, things are changing in your database as since the internet is actually in the backbone of it, SQLite database. So it can't just keep up with you. So
what does it do instead?
So what it does is that it actually bundles all these changes that have happened and puts them in your RAM. So they're called, these are 64 kilobyte chunks that sit in your RAM. So if power goes out right now at that stage, you're going to lose all that activity. So if somebody was doing something nefarious at the time, you pull the plug, you're going to lose all of that, because that's in RAM. Then there's several steps after that. I'm going to make them very, very short and say at the end of it, all of these old transactions wait until the computer is done doing its main primary transactions. So let's say your internet is more important to you than Excel sheet, than your database. So it's going to wait until you are done with your whatever you're doing. So it could take up to, sometimes I've seen it in more than weeks, that third entry is just blank because it hasn't written back into the database. It's still sitting on the hard drive. It's or in the form of a cache in the RAM. This is all automated. That third transaction is all automated. So that's what you're looking at. So we see at 6:14 p.m. The database actually recorded that, finished its transaction.
Did you apply this Axiom forensics tool to these Zoom invites?
Yes.
What happened when you did that?
So when you're looking at the Zoom one, it's the same concept, but that's on page 5 of 14.
On page 5? Okay.
Which report is this?
Page 3. Report 3, page 5.
What we see here is the Zoom call, that the Zoom invitation. When you look at that, it says that 11:08:08, but you see the bottom category where the orange box in there is no user communication. This is an automated transaction. And as a matter of fact, the defense examiner agrees that this was an automated thing. The thing is that they didn't produce any evidence that this was an automated thing. Their mind was to go after making the entire thing programmed, pre-programmed, which is not the case. And we'll get to that why. And I broke it down into a more expanded version of it at the bottom of that page 5, what each one of those entries gets.
And when these are artifacts as well at the bottom of page 5? What is the distinction between the two artifacts?
So one is a calendar, the other one is a sent item. It's accessing the calendar and it's accessing the sent item. That's the different paths.
Neither done by a user on the computer. Thank you.
Not on that,
Say it again for me, please.
not on the 15th.
Not on the 15th. What did you analyze next while you're doing your expert analysis?
So here but first of all, you have to mention that this also, this transaction is not seen, I have to reiterate that it's not active with the server log. When any transaction happens that's pertaining to email, it should show in that Excel sheet that I had. It was not.
Are you familiar with the possibility to link a Zoom account to an email account?
Yes, I am. You have an add-on within your Outlook. Because the Outlook was deleted, I don't know if it was an add-on.
So you can't speak to that because it had been deleted?
Yeah, one of those kind of an unfalsifiable issues that I can't say one way or another because this is all happening a year after this was brought up to our attention. The server log doesn't last for, I've seen server logs that don't last more than 2 days. A year later, obviously was not there. So I don't have any basis for any of this. Just brought up something that got brought up.
What was the next step in your analysis?
So, so one of the things that I try to still figure out what this Zoom application happened. Again, based on the evidence that I can see, there were two event ID 325 that I said. That means that the user was denied access, which means that it could have been that when the defendant was opening Zoom application, maybe it was cashed out. Cashed out meaning it was in the outbox and it was sent when it was opened up. That could be a possibility, but one way or another, I cannot say what happened.
Okay, you cannot draw a conclusion about that definitively.
And then the defense forensic examiner also mentioned that verbatim, this is what he said prior to the forensic imaging of Scioto Township laptop used by Jillian Cleary on November 15th, 2023 to conduct a Zoom meeting. All email contained within the laptop itself was permanently deleted beyond recovery.
Is that accurate?
That's not accurate.
Why not?
I actually recovered 69,000 emails.
And how did you do that?
So Windows has volume shadow copies, and basically in the background, every time you're installing something that is going to change things within the system, it creates a little shadow copy. It's not a backup. It's very technical, but it's a shadow copy. It's sitting there, but it maintains what happened before that. You can always go back to it.
Is VSC the term you would use for that, the abbreviation?
Correct.
And you were able to recover 69,000?
Yes, it was in the VAC, but the problem was that the VAC happened on November 13th, 2 days before this happened at the township. And so I don't have the emails from the 15th. However, I was able to recover that Zoom invite, which is at the bottom of page 7. You see that email was sent. It's got a timestamp when it was sent. Start time and the end time, and it's all on the 13th when it was clicked on. I don't know if it was sent or not, but all I can say based on what I'm seeing is that it was clicked to be sent.
What happened next when you were completing your analysis?
So just to verify that Zoom invitations use a unique Zoom numbering system for the planned meeting, and that number corresponds with the exact number.
Represented on page 8?
Yes.
Thank you. What was the next step in your analysis?
The next one was that I believe this is when the defense examiner stated something to the effect of 9 emails were sent at the time when the defendant was operating the laptop. That is completely.
How come?
Because I manually looked at this laptop. I ran 2 forensic tools that I've used for more than 2 decades, and they never showed that. And primarily because the the email server logs don't show anything but that 1 email. They don't show 9 emails. This was that's why I always teach my students that you have to manually check anything that's okay. So
Yeah, actually, I could use a break if you don't mind, Your Honor. That would be okay.
Sure. I was gonna, we're about 5 minutes off of where I was gonna call for one inning, but this is a good point.
I think so.
Let's take a break. All
Thank
right,
you.
quarter standing. How much more do you have? of Your, no, I know you have of your questioning.
Just the end of this report. We're on page 10 of 14.
Okay. And then we'll see where we end up.
Thank you.
All right. Quarter standing. All right.
The 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge State Cedric Simpson presiding.
You may be seated. All right, counsel, because it was involving scheduling, I had come out, you weren't here. And so I hope there's no objection. I was giving Mr. Villada a hint that we'll finish your direct examination and then come back, get another day and begin with cross.
No objection at all, Your Honor. I completely understand.
All right. Okay, so we are back on the record in the case of Jillian Carey. Sir, I just remind you that you're still under oath since we took a break. I'm sure you know that. You may continue.
Thank you, Your Honor. Detective Parvis, looking at page 10 of your third report, what was the next part of your analysis? I think we left off when we were talking about some of the logs related to the Zoom and the email, and what you were doing next as contained in your analysis on page 10.
Okay, the 1-page report at 9.
I'm sorry, 9. I apologize.
It's the mistake made by the examiner, the defense's examiner. As you may recall, I actually used the stage of search database the first time when it's accessed, the second time when it's closed, the action is done. The third one is that automated transaction for the database is happening. The defense's examiner looked at that third column. In his forensic software, that column is named search gather time, and he thought that that when the user was gathering the information somehow, it had something to do with the user, which is based on if one of my students said that, I would tell him to read the book over again. This is just complete ignorance of how databases function. The next phase of this was that, the defense examiner, based on many mistakes that I have, some of them I have, explained here, typed a 10-page portion of his report is about this experiment that he conducted, showing that if you turn off your Wi-Fi and type an email, it's going to be in the outbox, and then when somebody opens that laptop, that email is going to be sent.
Why is that not relevant in this case?
Because number one, we know that this was trying to say that somebody other than operating that laptop sent that email. It's not relevant because that laptop itself is telling me that somebody who was operating that very laptop sent that email. We have the artifacts in that laptop. Number two, we have the bouncing off of the San Township Wi-Fi. We know the location of that laptop. You know who was operating behind that. It's completely, again, this is the drawing a circle around this target. And then they went through 10 pages of doing the experiment, showing that if you turn off the Wi-Fi, close the laptop, and the next person, when they open up the laptop, it's going to send that email. That's the gist of it, is I'm making that 10-page.
What is a Wi-Fi event log?
The Wi-Fi event log actually shows when you're turning off the Wi-Fi on a computer, and I provided a screenshot of what it looks like on my computer, and that is missing in the laptop. So the laptop is not showing that the Wi-Fi was turned on.
And the screenshot that you provided, that's on page 11?
That is page 11. On the top, you have my computer. When I turn it on the laptop, you're going to see a firmware that is operating that particular Wi-Fi card. Mine, it's version 2, and the one on the laptop was version 6. So when I'm looking for any activities by that firmware on that laptop, I see that the last time that laptop was even accessed, that driver was even accessed, was on November 8th, which is 7 days before this event occurred. So
Are these also artifacts? Would you call these artifacts? And you don't see any support for the Wi-Fi having been turned off and on?
I don't see support, but I see conflicts artifacts contradicting what the defense examiner was saying.
Is it your expert opinion the Wi-Fi had been turned on and off on that date?
No, it wasn't. It's we never had any indication by the defendant to talk to Deputy Phillips. We don't have any indication from the log that Wi-Fi was turned. Then the defense's examiner constantly brought up this issue of the Microsoft audit log.
What is a Microsoft audit log?
I guess at this point, I'm going to object to the testimony about what our examiner said. We have not called that examiner as a witness, and it's the prosecution's burden to prove their case. I don't think it's necessary, and I think it's wasting the court's time and everyone here's time to talk about what in a report that's not in evidence, and our expert is not here to defend himself on his report. So I think that's not appropriate.
Well, but I would imagine that, and just anticipating that your questions to the detective are going to go from some analysis of your expert. I mean, would I, whether right, wrong, or, okay, thank you. Thank you. All right.
Thank you.
Go ahead.
What are Microsoft audit logs, please?
It is it's part of the subscription with Microsoft. It's Microsoft will maintain your actions as if you're in front of your laptop. So if you delete something, an email, you do any kind of activity with your email. How much you pay for the amount of storage that it's going to keep it for as long.
Is it the same thing as a server log?
It's not. The server log is by far more particular than the Microsoft audit log actually pertains. The server log pertains to this case. Microsoft, all it's going to provide is that an email at that time was sent. I know that based on examination of the laptop and based on the server logs. The examiner kept harping on that over and over again. I did contact IT Township, Township's IT person, and I asked over and over again, not for particularly Microsoft audit logs, because it is the township, you're gonna have full access to what everybody did. I didn't want that. What I was specifically asking for was that they're using the TFI archiver, which in my experience is the best foolproof and you cannot contaminate that server. It's made for deep discovery, so you can actually go in and without worrying about any contamination, extracting information. I wanted that, and I knew that the township was using my archive. That's what I wanted.
Were you able to get that?
Over and over again, I contacted the IT. Even I was hopeful I could get access to it a year later when my second report was done. I could not get it.
Directing your attention to Appendix A in this report, which is the last page of it. Can you explain to the court what this shows?
So this is the database entry in, I'm reiterating that, and I'm actually this time, the same screenshot in my first report did not include the mappy note at the bottom where the computer says red. And I just wanted to bring attention to the fact that the computer says that email was read again. I hesitate to say it was read, I say it was X.
And Your Honor, may I approach with Defendant's Exhibit G that has been admitted into evidence?
Yes.
Detective Parvis, do you recognize the Exhibit G I've just placed in front of you? And have you seen that before?
I saw it when you pulled it up here today. I think I vaguely remember this from our meeting last year with the defense.
Okay. And were you able to do any analysis based on this?
No, it's just a paper. This is just a printout of some email. There's not even a header information in this. Not that the header information gives much information. I do need the server logs. I do need to find out. It's the question that it's coming back to me. It was about something about why it was sent twice, an email was sent twice.
And did you do any analysis or expert forensic? Why not?
The problem is that this is this is the defense's paper. It has nothing to back this. Was sent. It could have been that it was busy. Emails are not made to be instant at all. That's not emails are there for. Maybe you're at the mercy of the server, the email server. And at this point, maybe the server upgrades, maybe it could be anything that caused this. This is just something that this is one of those unquantifiable claims. I don't have anything to research. They don't have.
Detective Parvis, in your expert opinion, was this email, the election email, sent automatically or by a person?
It was sent by a person,
Was it accessed automatically or by a person?
by a person.
Who was it sent and accessed by?
Based on the interview with the defendant was there operating that laptop at the time when this email was sent. And we know the location based on both the defendant's statement and the Wi-Fi.
Thank you, Your Honor. I'm done there.
All right, very good. So what we will do, having finished the direct and detective departments, is we'll, as indicated with counsel, will adjourn to another date for the beginning of cross. What dates did we have?
So Tuesday.
Okay, all right. I can continue this. This works. We can do June 30th in the morning. Or I can do July 1st at 1.
July 1st at 1 works for the people?
Your Honor, both of the dates work for me, but I would ask that we put it on a date where we know we're gonna get it in. I'm gonna probably have at least 2 hours for the witness and cross. So I'd like to, is there a day that you know that you're gonna have a couple hours with us? Because, you know,
I gave you like 4 today. I always have
I
time.
know, but I mean, I appreciate it.
What?
I'd like to do it
You
for
want
the
to,
business.
you want to
That's-
sleep?
that's-
I don't sleep, so I get it.
Maybe yes.
No, these are dates that we're kind of giving you a special time.
Okay, good. 1 o'clock is fine.
All right, so we will adjourn this and for its continuation and follow up, but I'd like to finish it that day.
Yes, Your Honor.
Thank you, Your Honor.
July 1st, 2025 at 1 p.m. Okay.
I previously checked that day with Detective Parvis, so I do believe it works for him as well.
Does that work for you?
Yes, Your Honor.
Okay.
Will the court?
The only thing I would note to you is that that's a Tuesday, correct?
Yes, sir.
So that's preliminary exam day. I'm not on that day for preliminary examinations. So if this courtroom is available, just to let you know, then we'll do it here. If it is not available, we may be delayed, but I might be in another courtroom A, the first.
Okay, thank you.
All right, but so that you know.
Your Honor, is the court okay keeping people's exhibits 1 through
Yes.
5?
Yes. So we have those exhibits. All right. And
All right. 14A District Court for County of Washington, State of Michigan is now in session. All those present are near. The Honorable Judge J. Cedric Simpson is done.
may be seated. Lonnie.
Good morning, Your Honor.
Lonnie, no see.
I know. Your Honor, Ashley Lonnie, for the people at this time, the people would waive any conflict between this honorable court and the office of public defender. The people do not believe that any conflict exists. They waive the avoidance of all doubt.
Let it be Miss Payne. Mr.
It could be mispaid.
No, go ahead.
But I'll mess up the word. Public defender, Natalie Pate, on behalf of the public defender's office, Your Honor. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we would therefore waive such a conflict.
All right, thank you. And Miss Parity, there was no disrespect. All right. The court, for its part, does not believe that there's a conflict either under Michigan court rules or the cases decided they are under, to the extent conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Diane Mohammed.
Good morning, Your Honor. Christina Bergdorn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley.
It's good that you've taken the first seat. Permission to practice is granted.
Thank you, Your Honor. Christina Bergdorn for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Mohammed Diane. Please state your name for the record, sir.
Mohammed, pronounced Diane, spelled D-I-A-N-E, Diane.
They have it backwards in here, but anyway, all right.
Thank you, Your Honor. So it appears that last time when I requested an adjournment of this length, I was a little too optimistic in how quick I may be approved for a visit by MDOC. I did get notified, it was about a week and a half ago, that I had to supplement my online application with some stuff through the mail. That being said, I did submit my paper application through the USPS. I have not heard back yet whether or not I have officially been approved. My client is located in a facility very up north, but I am optimistic that within a few weeks, hopefully I would be approved and be able to get that video visit scheduled. Progress has been made, but we are still on that journey. So I would be asking for an adjournment. Frankly, it might be a while, maybe a month out.
That's what I was thinking. So today's the 18th, right?
Yes.
I was gonna say, I have court coming up in a different county too, so if I would be included in this scheduling, it'd be good for us.
I'm sorry?
I have court coming up in a different county, so if you let me know what date y'all gonna pick it, help me out, so, 'cause I have a court date coming up in a different county. I don't want it to
Okay,
interfere with.
do you know when that is?
I think it's, give me 1 second. You know when my next court date is? I think it's July 15th or, you know when my next court date is, for Jackson? You know when my next court date is for Jackson?
It's on the calendar.
Alright. Now, if you give me 1 second, you guys can tell me right now, he's looking at the calendar.
Mr. Diane, you think it's sometime in July?
Yeah, I think it's July 15th, if I'm not mistaken.
All right. Well, rather than give you, my next court date would be July 16th, but that may be a bit early given what they're trying to do here. So let me just adjourn this to August 6th.
Since I'm gonna be going on the writ over there, that's why I was saying I'm not gonna be in MDLC, I'm gonna be going out there to Jackson.
Oh.
When is that supposed to happen?
That's what I'm saying. Is it July 15th? Is it July 15th?
Okay. All right, Mr. Dan.
What's that?
Did you look at that calendar for me?
I haven't got a chance yet.
Yeah, I'm not, I think it's July 15th. I haven't got the paper yet though, but they haven't sent me the paper, but I know it's like July 15th or something.
All right, let me do this. I'm gonna keep the date of August 6th. If they move you, we'll get notification in time to do a writ if necessary. Okay?
Okay.
All right. Thank you, sir. Bond will continue.
Thank you, sir. Thank you, Your Honor. Thank you, Your Honor.
Court does call the case of the people versus Gabriel Boyd.
For the people. Good morning, Judge Aida Spahich on behalf of Ms. Gabriel Boyd. Judge, hello, all the way from Bosnia.
Oh.
It's nice to be able to be in another country, Judge. Thank you for letting me allow me to appear via Zoom. I don't see my client on.
Yeah.
And they are not in the courtroom.
There, okay, let me just double check with my client because I spoke to her yesterday. Can we pass this matter, Judge, for about a couple minutes?
Okay.
Thank you, Judge. I appreciate it.
Not a problem. I was hoping to issue an overseas bench warrant. Court does call the case of the people versus Michael Klustra.
People.
Good morning, Your Honor. Uwe Daus on behalf of Mr. Klustra, also joining us by Zoom. Thank you for the remote attendance. Mike, please unmute and identify yourself.
Michael Klustra.
Here, this says people are going to be filing annulling in the interest of justice.
You're going to be filing annulling on it?
Yes, Your Honor.
All right. Any objection to that, Mr. Duff?
No, we don't. We spoke with Ms. Landy and it's much appreciated.
This case is dismissed.
Thank you, Your Honor.
All right. Thank you.
Thank you.
You can go. Today is 6/18. Court does call the case of the people versus Damian Poupette.
Ashley for the people.
I'm here, Your Honor. My attorney is supposed to be on here too, but can't seem to find him.
in Zoom, Your Honor, but he is not right now.
My staff is indicating he was in Zoom, but he's now not. So let me pass it and see if he reappears. Okay? Thank you, sir. Court does call the case People versus William Parker.
Escalante for the people.
Good morning, sir. Tom Pietrowski on behalf of William Parker, who's in court today, standing to my right. If you would identify yourself, please, sir.
Yeah, my name is William Parker.
Thank you. And good morning, Mr. Pietrowski.
Good morning, sir.
All right, what are we doing?
I've had a chance to talk with Ms. Lundy regarding a potential resolution of this. We're going to look into sobriety court. We're going to ask the court for some additional time to take care of the necessary.
I'll adjourn the matter then to July 16th, 2025, 9 a.m. I'll mark the file that you're looking at sobriety court.
Thank you, sir.
Thank you, Your Honor.
All right, thank you. Court does call the case of the People versus William Dapkowski.
Christina Berger for the people.
What is this set for?
This is an arraignment and pretrial, Your Honor. Mr. Tefelsky is physically here.
Dapkowski?
Yes,
Where is he?
not in the court. But he has been here.
You know what, Ann? You're gonna make this day longer for me, aren't you? Can you?
I can do it, Your Honor.
Good morning, Your Honor. Paul Tefelsky, P52844 on behalf of Mr. Dapkowski.
Okay. And I don't have an appearance, counsel, for whatever.
Oh, you don't? I'll make sure I file one with the clerk. It should have been filed
very good
a couple weeks ago.
I just don't have it. All right.
Okay.
Okay, as to the arraignment in this case.
Judge, I'll waive the formal reading. My client stands mute.
Been in having waived formal reading, standing mute, court will enter a not guilty plea.
Judge, I understand that the prosecutor is requesting a tether. My client is not opposed to proving his sobriety and taking and testing. However, we would ask the court to consider an alternative to the tether because he is a mechanic and he works with a lot of chemicals. And he was just explaining to me how the other day he was removing a gas tank from a vehicle and about 1.5 gallons of gas spilled on him. And I have had experience with clients before where if they get alcohol-based products on their bodies and on their clothing, it can cause false positives. And I don't want to have that happen with him. So I would ask the court to consider.
Well, but it's only going to look like a drinking event if he drank the gas.
Well, I think even
when they run it through the bottles, it's not going to look like a drinking event. I mean, I'll take that into consideration, Counsel.
That's fine, Your Honor. I've had clients before that worked in paint booths, and the manufacturer recommended against it in those instances. But that's our only concern, Judge. It's not proving his sobriety. So we would either ask for a sober link or a random ETG testing. And
all right, you want the pretrial adjourned?
We'd ask for the pretrial to be adjourned, Your Honor. We're going to have him screened for sobriety court, see if he's a good candidate for that.
I'll adjourn the pretrial to July 16th, was it?
We have the second.
We also have a second. Well, if he's going to get screened, he's in Saline. So actually, he might qualify for ours. So let's do July 2nd, 2025.
Judge, I'm going to be out of town that day.
July 16th.
Thanks.
2025, 9 a.m. As to bond in this case, alleged BAC.
0.13, Your Honor.
Your Honor, if I may, it was 0.137 and 0.134.
Accident.
Your Honor, no accident. He was pulled over for speeding 30 miles per hour over the limit.
All right.
He does have a prior OWI from 2022.
He has a prior.
Yes, Your Honor. For those reasons, that's why we were asking for the scram.
Anything else you want to say before I step out? Counsel?
No, Your Honor.
All right. Bond will be set in the amount of $15,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
Yes.
There should be no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I am given the prior in this case, and we'll monitor it, and I'll hear argument if there is a problem. But I am going to order the defendant be placed on a scram tether. And you'll need to report to community corrections within 24 hours. It might be best just to do it before you leave this facility because they're right over there.
Okay, thank you.
Okay.
Thank you, Judge.
They are. Court does call the case of the people versus Jason Brooks.
Christina Berger. Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Brooks.
Mr. Brooks, can you state your name, please?
Jason Brooks.
Thank you.
Your Honor, I am requesting an adjournment. I did not have a chance to speak with Mr. Brooks prior to today's hearing. I would ask that he return my calls, please.
All right, sir, you need to keep in contact with your attorney. You hear me?
Yes.
I'll adjourn this to July 2nd, 2025, 9 a.m. Thank you. Court does recall the case of the people versus Damian Coupet.
Echelon for the people.
Morning, Your Honor. May it please the court, Ezra Goldman. I'm asking Mr. Pupett. I'm sorry if I missed it previously, Your Honor. I was in another court.
Okay. So you'd rather appear in another court than mine? No, never mind. Don't answer
No,
that.
okay.
All right. Is this an arraignment?
Yes, it is, Your Honor.
All right, this is an arraignment on an OWI. IBAC.
Waive reading and stand mute, please, Your Honor.
All right, defendant having waived formal reading, standing mute, court will enter not guilty plea. You wish an adjourned pretrial date, sir?
I do not have discovery yet, Your Honor.
All right. I'll adjourn the matter to July 2nd,
Your Honor, I have to
2025.
be in, I'm sorry, Your Honor, I have to be in the district court in Taylor that morning. And while I would rather be in Ann Arbor, but
Yeah, okay. All right. Yeah. July 16th. Will that work for you, sir?
Yes, it will, Your Honor.
All right. July 16th, 2025, 9 a.m. As to bond in this case.
Your Honor, the people are requesting a scram tether. The alleged VAC in this event is a 0.192 blood alcohol content. The defendant has a prior OWI that was reduced to a reckless in 2020 and a conviction for OWI in 2024. So we are concerned in this case that the blood alcohol content and the recent prior, there was no crash.
Sir, anything you want to say regarding bond?
I can't dispute those priors. I don't have the discovery to know if the blood alcohol is correct, but I have no reason to think that it isn't. So,
all right.
I will tell the court that Mr. Pupett is not driving.
Okay.
And he lives down. So his work is remote. So that's something.
All right. I will set the defendant's bond in an amount of $20,000 personal recognizance bond. All other standard conditions, including no assaultive behavior or possession of any weapons or ammunition. I'll indicate you are not possessing any alcohol, recreational marijuana, or any illegal drugs. I will at this time order that the defendant, given the what may be two priors, but at least one prior and the high BAC, that the defendant is placed on a scram tether. All right. You need to report to community corrections within the next 24 hours, sir. Okay. All right.
Your Honor, I'm attempting to get into the Zoom call to give defense counsel where he needs to send his appearance for discovery. It's just taking me a moment, so if he could hold the line for a second, I'll have that to him momentarily.
I will be happy to stand by. Thank you.
All right. Thank you. Court does call the case people versus Andre Smith.
Ready, Your Honor.
Echelon for the people.
And Your Honor, Joe Simon, on behalf of Mr. Smith. Mr. Smith, when you get up here, state your name, please.
Andre Smith.
Thank you.
Your Honor, I believe, well, sorry, we're here for arraignment as well. Waive formal reading of the complaint and stand mute.
Defendant have a waive formal reading, standing mute, court will enter not guilty plea.
We're going to be making a travel request in a little while, but we've reached a resolution on with respect to the pretrial.
That's correct, Your Honor. The defendant is going to be pleading guilty as charged with the prosecutor's deferred sentence.
Your Honor, that's accurate. Mr. Smith and I reviewed his rights of rights form today. He signed it. It should be before you and he's ready to enter his plea. Just have a half a step forward, Andre.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth shall be God?
I do.
State your name.
Andre Smith.
All right. So he's pleading guilty as charged with the prosecution.
Yes, sir.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes, Your Honor.
All right. You signed any advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
I know, Your Honor.
Please look at paragraph 5 of that form. You'll see a copy of it. Further, to your rights which are part of a trial, you understand that by pleading guilty, you'll be giving up those rights as well as all the rights under the form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
All right. Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
And of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
I would also indicate to you that if I do accept your plea, between the time of this acceptance of the plea and time of sentencing, that if you commit any type of misconduct as defined by the court rule, this court would not be bound by any type of sentencing agreement. That would include the prosecutor's deferred. You understand that, sir?
Yes, Your Honor.
You also would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
All right. On the date of November 20th, November 20th, 2024, location of 7,000 East Michigan Avenue. What did you do at the Walmart that makes you think that you're guilty?
We were at the self-checkout line, and I had scanned some items and then moved some items away to not be scanned purposely.
All right, so you were skip scanning?
Yes, Your Honor.
All right. And the amount of the items that you skip scanned, was that in excess of $200?
I believe it was just under 300.
All right, so that's in excess of 200. Okay. You didn't have anybody's permission to do that, did you?
No, Your Honor.
The store was open to the public?
Yes.
All right. And these items that you skip scanned, these were items that were offered for sale by Walmart?
Yes, Your Honor.
All right, counsel, I should first of all ask counsel, are there any other pleas, threats, or inducements that counsel would be aware of that have not been placed on the record that is led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
All right, court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th, 2025 at 12 p.m.
July 30th, 2025. You said 9?
At 12.
12 p.m.
You'll be back, right?
The 29th, correct. I'll be back.
Your Honor, regarding travel, my client's girlfriend, who's actually on your docket in the next block because she's hearing impaired and needs an interpreter, is having a surgery in the state of New York. My client and she would like to travel to New York to have that, and they're staying for extended recovery time with her family in New York. His travel dates are July 3rd, returning July 29th, and he will be here. And I'll try to get his PSI done before that time, or ask if it could be
July. When are you leaving?
3rd to the
Third.
29th, pardon me.
To the July 29th, and that's to the state of New York.
Yes, Your Honor.
I will allow and give permission for the defendant to travel to the city of New York.
Thank you, Your Honor.
Thank you.
Wait from the outside.
Sure.
Okay.
Bond in this case.
Oh, sorry.
Bond in this case will be set in the amount of a personal cognizance $5,000 bond. I will order standard conditions, including no possession of any weapons and no assaultive behavior. I would also indicate the defendant at this time is not to possess or consume any alcohol, recreational marijuana, or any illegal drug. I would indicate also that he is not to enter any Walmart in the state of Michigan. You understand that, sir?
Yes, Your Honor.
All right. Great. Thank you.
Go ahead. Outside.
Court does call the case of the people versus Ali Hari. Is it Hiari?
Yes, it is. Your Honor, Joe Simon on behalf of Mr. Hari. Go ahead and state your name, Ali.
Ali Hayari, Your Honor.
Okay. All right. What do we do?
If I can just tell Miss Lundy one quick thing.
Andy and Simon is never a quick conversation. See?
Yes. Thank you. Your Honor, we're requesting the matter be set for final settlement conference.
All right. Jury final settlement conference will be set for August 8th.
Yeah.
August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Bond will continue.
And
Court does call the case of the people versus Natasha Olmos.
Ashley Lonnie for the people.
David I. Goldstein appearing on behalf of the defendant. Ms. Olmos is approaching the podium.
Morning, Natasha Olmos.
Thank you. All right, what do we do?
Your Honor, I just recently substituted in. Mr. Burdell did provide me with the written discovery, but I understand there are videos which I do not have. Ms. Londy is going to provide them. I also anticipate a motion to dismiss one of the two, either count 2 or count 3.
Turn this matter out to July 15th, 2025, 9 a.m. I think July 16th, I'm sorry, 2025, 9 a.m.
I figured you said it for the 15th, so I'd be on time for the 16th. but
Yeah, it was a thought.
I read quiet.
So I just want to make sure, because we had some complications in this. We have your appearance, however, because there was previous counsel, I do need a substitution. I
thought we sent one, Your Honor.
Pardon?
Let me look. I thought we sent one.
I have one.
You have the substitution?
Yeah, it should be in there. I'll double check, but I do know I received one.
Oh, wait,
Yeah, his
there it is.
application.
There's, excuse me. Okay, that's why. Okay, we have it.
All right, thank you, Your Honor.
Thank you. Court does call the case People versus Kyle Burmeister.
Christina Bear for the people.
Okay, Boyd is here.
Assistant Public Defender Natalie Pay on behalf of Mr. Burmeister. I do not know, Your Honor, if he is logged in via Zoom.
I do not have him.
It's my understanding he's still at Oakdale and set to be leaving Oakdale on the 27th of this month. And it was my tardiness. I just provided the Zoom to Oakdale via email yesterday afternoon. I would respectfully request an adjournment. I did reach out to the people in hopes to adjourn this by stipulation, as Mr. Burmeister is set in
I'll
front of you.
adjourn it to July 2nd, 2020.
Thank you, Your Honor. That was July 2nd?
Yes.
Okay, perfect. Thank you.
Court calls the case People versus Ashton Edler.
Assistant Public Vendor Natalie Pate and on behalf of Mr. Keebler, who is present via Zoom. Sir, can you please unmute and state your name for the court?
Ashton Ebler.
Thank you.
Thank you, Your Honor. I have discussed this matter with both my client and the people, and we would respectfully request to set this for a final settlement conference.
And an unregistered trailer?
Yes, excuse me. Yes, Your Honor.
It's my request, Your Honor.
Pardon?
It's my suggestion that we set it for final settlement.
Oh, joy.
I know.
Jury final settlement conference will be set for August 8th, 2025 at 9 a.m. Jury selection if necessary. August 11th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. And thank you, Mr. Ebler.
Thank you.
Thank you, sir. Court does recall the case of the People versus Gabriel Boyd.
Christina Bergdorf for the people.
Good morning, Judge Rita Spavich on behalf of Ms. Gabriel Boyd. Judge, thank you so much for passing this on for a little bit. My client has some technical issues this morning.
Okay, not a problem. Ms. Boyd, can you state your name, please?
Gabrielle Boyd.
Thank you. All right, what are we doing?
Judge, I'm respectfully requesting that this matter be scheduled for an evidentiary hearing at the touch base with Ms. Lundy yesterday.
All right, an evidentiary hearing as to what issue?
Judge, I believe I'm going to be filing a motion as to no probable cause to arrest.
All right. And how soon will you get that motion in?
Judge, I can get it done within I fly back home next week, but I can still get it done within the next week. I guess if you would just give me 2 weeks, if it's not too far out.
Okay, that's fine. We'll do that. So I will indicate that you're to have that by July 2nd.
Okay.
(2025) Close of business.
Thank you, Judge.
Prosecutor's response would be due by July 16th. That's close of business. And then I'll set an evidentiary hearing on this matter. Give me my trial week and put it on that.
I'm sorry, you said you want your trial week in July. That would be July 30th at 9 a.m.
And I'm not available on that date. Actually, one of the people, I apologize.
That's that whole week, right? So give me, you're not available that week?
That week or the following week.
Well, that's gonna be a problem. All right. Then what I'll do is I'll set an evidentiary hearing then. If you get it in by the 16th, I'll just have to. July 23rd.
Thank you, Your Honor.
Thank you, Judge.
I don't have that date. I don't have that date? Why? Oh, that's right. I don't have that date. Well, and give me a date I do have that. Apparently you'll have to fit with Miss Lundy's schedule.
Well, it's not just Ms. Landy, it's also my schedule as well, Judge, just in her defense, because I'm out of the country.
Oh, you don't have to.
I mean, it's true, Judge, you know.
We have to use jury selection.
Yeah, which would be Monday, the 11th of August.
Okay. Set an evidentiary hearing then, August 11th, 2025 at 1 p.m.
1 p.m. Awesome.
Okay.
That works. Thank you, Judge. Thank you so much.
Thank you.
Judge.
All right.
Thank you.
All right. Thank you, ma'am.
Ms. Lundy.
Godspeed on your travels back, Counsel.
I appreciate it, Judge. I don't want to leave yet, but you know, got to come back. So.
Got it.
Thank you, Judge. See you. Bye-bye.
Thank you. Court does call the case. People versus Alexis Berry.
This is an arraignment pre-trial, Your Honor.
Your name?
Alexis Berry.
All right. You are before the court on a misdemeanor complaint that alleges that on or about April 10th, 2025, at the location of Ellsworth near Stone School Road in Pittsfield Township, Washington County, State of Michigan, that you did operate a motor vehicle while intoxicated. Do you understand the nature of that charge?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days jail and $500 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. Court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. First question I have for you is, do you want to be represented by counsel?
Yes, Your Honor.
All right. It's a public defender case. I think you are represented by the public defender.
Correct, with my previous one, which with you.
Assistant Public Defender Natalie Pate with and on behalf of Alexis Beery, who stands to my right, we would waive any further reading. My client would stand mute and ask that a not guilty plea be entered and ask for an adjourned pretrial date, please.
Pending every waive, formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned July 2nd, 2025, 9 a.m. As alleged BAC in this matter.
0.062. Oh, my bad. I apologize.
That's okay. Big knows.
Your Honor, if I could, the alleged BAC 0.062 and then the 10 nanograms of THC as well.
All right.
There's a prior in 2020. I did want to check with you if you have the updated charging documents indicating that this is the second offense.
I do not. When did you send that in?
We sent that in, I believe, late last week, so they should be coming to you soon.
I don't have the only complaint I have in the file is for OWI first.
Okay, this is the second offense. I believe we had requested an updated charging document to indicate that.
All right, so they'll be sending an amended complaint. Ms. Berry, you understand that?
Yes, I do. My first one was.
Well, I don't want to know that.
I got you.
I just need for you to understand that they're charging you with a second offense.
Yes, yes.
All right, that's going to make this punishable by up to 1 year incarceration and $1,000 fine plus court costs. Everything else is the same. You understand that?
Yes, sir.
All right. Okay, well, we'll await that, I guess. But there was a prior. When did you say the year on that prior was?
2020 year.
Was there an accident in this case?
There was a crash into the curb of the scene, resulting in disabling damage to the vehicle, Your Honor. So yes, there was a crash. Considering the crash and the BAC and the prior, we are requesting a strip this time.
Guess I'm a little bit confused because when I look at this complaint, I have the location described as Ellsworth and Stone School, but then there is a reference to a Marathon gas station, and if I remember, there's not a Marathon gas station there on Ellsworth and Stone School. There's an almost.
Echelon people, Your Honor, the defendant was observed by a citizen operating the vehicle at the one location and then followed her to another location where she did crash into the parking lot of the Marathon gas station, is my understanding.
So the observation then took place. I guess I'm just trying to be clear. The observation took place at the Stone School Ellsworth location
I believe so, Your Honor.
and then followed all the way to the Marathon gas station. I'm not sure what Marathon gas station I'm talking about because that's.
I thought I had included yes, The address on the complaint, the one on 4970 Washington, Your Honor.
Got it. Okay, I see. All right. Okay, all right. So there was an accident. All right.
If I may briefly, Your Honor, I would request a PR bond, and I would ask that Alexis Berry not be on a scram tether at this time, given from what I heard, the allegations are that she was intoxicated but under the legal limit, and that the allegations were of marijuana. Given that, I would ask that a scram tether not be imposed. I would ask for a PR bond, and I did previously represent Ms. Berry on her previous case, and based on my prior representation of her, I had known her to not be a flight risk and to both come to court and comply with bond. I would ask for a PR bond and standard supervision, but ask that the scram tether not be imposed.
Your other cases of what type of cases are?
Your Honor, that was a DV, and my understanding is, and the people can correct me if I'm wrong, that this charge stems from that same discovery and alleged incident.
Okay. So just so that I'm clear, you can correct me if I'm wrong. The DV incident or alleged DV, that involves the use of alcohol, or alcohol was
There was
consumed.
Yes, Your Honor. The allegations were that both cases stem from the same day and time and chain of events.
But
So yes, Your
I
Honor.
think two criminal events coming out of what may be the use of alcohol. Is what
Possibly, Your Honor, yes.
Possibly. All right. Anything from the people?
Yes, Your Honor, I'll just reemphasize that while the blood alcohol level was under the legal limit, the defendant was under the influence of 10 nanograms of THC. There is a prior from DOWI from 2020, and this did involve a crash, and this is why we're requesting a screen.
What I'm going to do is I'm going to set bond at a $10,000 personal recognizance bond. I'm going to order standard conditions, including no assaultive behavior or possession of any weapons. You understand that?
Yes, Your Honor.
There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. I am going to order that the defendant is to report over to the Department of Community Corrections for two things. And that is that she's to report over and be placed on a SoberLink testing device. I'm not sure how long I'll have that last, but I want it on at least at this point in time. And then drug testing 1 time per week. And I will let you know that we can get levels, and the court's expectation is the THC in your system will exist, that will go down and become non-existent. You understand that?
If I may, Your Honor, if Ms. Berry was to have was to have a valid medical marijuana card and provide the needed documentation to community corrections, would she be able to continue using that as prescribed?
Does she have one now?
I do. I've had it.
I'm gonna have some concerns about that.
I've had it since I was 18, since the 2020 charge. That's what I was trying to say. The 2020 OWI charge is from marijuana, not alcohol.
I'm gonna put her on testing. I've issued my order in terms of bond conditions. I'm not gonna get into an extended argument about of what the court can order regarding medical marijuana.
So just to clear my client So just so my client understands, Your Honor, no marijuana of any kind is your order at this time?
I've issued my order. I'm not trying to be I've issued my order. Thank you.
Understood, Your Honor. Thank you.
Court does call the case People versus James Bowman. Mr. Bowman? Okay, come on now. Is that her? Did I ask you to state your name? I'm sorry.
Oh, no, James Bowman.
Thank you. All right, Mr. Bowen, you are here on a complaint that alleges two charges. And it alleges that on or about July 25th, 2024, the location of State Street near Textile, that you did possess or transport open alcohol in a motor vehicle. That's commonly known as open intoxicants in a motor vehicle. You understand that, sir? Yes?
Yes, sir. Yes, Your Honor. Sorry.
That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. The court could order community service and any substance abuse screening. You understand that?
Yes, Your Honor.
Count 2 alleges that on that same date and at that same location, you did operate a motor vehicle without security or insurance as required by statute. Understand that?
Yes, Your Honor.
All right. That's a misdemeanor punishable by not more than 1 year incarceration, or incarceration, not less than $200, nor more than $500 fines plus court costs. You understand that, sir?
Yes, Your Honor.
All right. So the first question I have for you, sir, is do you want to be represented by an attorney?
No. No, Your Honor.
Really? Okay, what do you want to do on this?
This is my first time being in this situation.
Really?
Yeah, I have no idea.
Really? You have no idea?
Yeah.
Don't
Yes,
have
sir.
a law degree?
No, Your Honor.
Don't know what I might do?
No, Your Honor.
So you don't know what you want to do?
Not really, Your Honor.
No?
I'm sorry.
Okay, so I'll ask the question again. Do you want to be represented by an attorney?
Yes, Your Honor.
Yeah, good choice. All right. It's a public defender case.
Good morning. Assistant Public Defender Lauren Perry on behalf of Mr. Bowman. We would waive formal reading, stand mute to the charges. I request another pretrial date.
All right. Defendant having waived formal reading. Standing the court will enter a not guilty plea on his behalf. You wouldn't have known to do that either, would you? No, right? You wouldn't have known to do that, right?
I would not have you.
No, okay. All right. I'm just making sure they're helpful for you. I'll adjourn the pretrial to July 2nd, 2025, 9 a.m. Any issues regarding bond?
Your Honor, we just request standard bond conditions in this case.
All right. Ms. Faraday, anything?
Your Honor, I'd ask for a personal bond, given his
Would he have known to do that?
No, Your Honor.
Okay, all right, go ahead.
I like being helpful.
All right.
Given his representations that he has no criminal history and these are both they're both misdemeanors.
Yes, they are. All right. I'll set his bond at a $5,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons. There should be no use of alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes, Your Honor.
All right. Thank you.
Yeah.
Court does call the case of People versus Alexis Brown.
Right, well, I'll be in touch.
Alexis Brown? You're not here. I will issue an order to show cause. Court does call the case of the People versus Issa Awad.
That's one. Your Honor, for the record, I just spoke to Mr. Awad and asked him if he heard from his lawyer and if she was. So those are the only contents of our conversation. He is present.
Mr. Awad is present?
He is.
Where? Oh, wait.
He's conveniently hidden by that.
Okay.
That thing.
Yeah. I said he's always appeared. And I was like, where is he?
I don't know.
Well, I
if
was
it's-
actually sending people out to find him, but I'm glad he's here.
I don't know what
I'm
the report
messing.
is. I have not heard from her.
Have you heard from your attorney, sir? All right, why don't we, do you have an email for her?
I do have an email for her.
All right, why don't we email and try to call, see if they're done. You're welcome, sir. Court does call the case of the People versus Timothy Haslem.
Conrad Siller on behalf of Pittsfield Township.
Christina Berg-Jaron. Good.
Sorry. Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Haslett.
This facility is not signed. It's in Macomb County.
He's in Macomb County. And they've not signed on. All right, what I will do is I will adjourn all of these matters out to July 2nd. 2025 90. Is that my next block up there? Or is that-
Yeah, you're done.
This one, but there are only two cases on. Perhaps on. Is there only two cases on? Okay. Okay, so what I'll do is I'll finish up that block. I'll just push Mr. Watts into the next block while we try to find your turn. Okay, thank you. Court stands in recess.
All rise. Oh, yes. Fourteen A District Court of County, Washington, State of Michigan is now back in session. The Honorable Judge Page has
You may be seated. Court does call the case, People versus Linda Downer.
Conrad Siller on behalf of Pittsfield Township.
Morning, Your Honor. Dan Garrett on behalf of Linda Downer. She's stepping forward. Your Honor, for arraignment, okay, state your name, Linda.
Linda Downer.
Thank you.
Your Honor, for arraignment purposes, we would waive reading and stand mute.
And in every way for a reading standing mute, court will enter a not guilty plea.
Your Honor, for pretrial, I inform Mr. Siller, my client is going to just plead guilty to the charge. I'm going to be moving for immediate sentencing, but of course, that's not a part of the plea, and understand that as well.
All right. So she's just going to be pleading.
She is, Your Honor.
This is a 90-day.
Yes.
500. All right. May I have your sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Linda Downer.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of open intoxicants in a motor vehicle. Is that correct?
Yes, Your Honor.
That is a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court costs, community service, and any substance abuse treatment the court deems necessary. You understand that?
Yes, Your Honor.
All right. Understanding that, you still wish to plead guilty?
Yes, Your Honor.
All right. And to that charge, how do you plead?
Guilty.
All right. You understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You've signed any advice of rights for him today?
Yes, Your Honor.
All right. Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will. And because you believe that you are indeed guilty?
Yes, Your Honor.
All right. On the date of April 24th, 2025, Laura Road, Pittsfield Township, Washington County, State of Michigan, were you a driver of a motor vehicle?
Was I driving?
Yes.
No.
Well, you drove to Meyer, is that correct? Across the street?
Yeah, across the street, yes.
Okay. All right. And were there open intoxicants in your motor vehicle?
Yes, Your Honor.
All right. What were they?
It was some wine that I'd been there for about a week or two.
So it was wine?
Yeah, about that much.
How much? That much?
Lighthearted, yeah.
Huh?
Low calorie, low alcohol.
All right. And it was yours?
From karaoke, yes, Your Honor.
All right. Very good. I do have to advise you, ma'am, that well, it may not be applicable in this case, since I'm going to do an immediate sentencing, but if you do commit misconduct, like within the next few minutes, then this court, any evaluation or sentence agreement, the court would not be bound by. You would also not be permitted to withdraw your plea. That you understand that?
I understand that. Yeah.
Counsel, have there been any threats, promises, threats, or other inducements which have led to this plea that have not been disclosed?
None from the prosecution.
No, Your Honor, thank you.
All right, very good. Counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. All right. Anything you want to say, or she gets?
Oh, she doesn't look at, Your Honor.
Gallery, whatever.
Ms. Downer is 75 years young. You've heard the facts of the case. I would respectfully request a fine.
Ma'am, anything you want to say?
Yes, thank you, Your Honor. I mean, no.
It's okay.
I don't.
Sentence of the court, fines and costs of $250. When can you get that paid, ma'am?
Today.
Thank you. Pay $250 today. Also spend 90 days in jail.
All right. Thank you very much, Your Honor.
Thank you, Your Honor. Okay, thank you.
Let's call the case. People versus Kamara Reed.
Ashley Lonnie for the people.
Morning again, Your Honor. Dan Guerin on behalf of Kamara Reed. She's stepping forward.
Go ahead.
Your Honor, Ms. Reed is here, I believe for a pretrial and a bond violation. In however order Your Honor would like to proceed, she will be admitting to the bond violation and then ultimately pleading guilty as charged. So however Your Honor would like to approach that.
Well, she's admitting to the violation.
She is, Your Honor.
Is that correct, ma'am? Yes.
Yes.
Yes. Thank you. All right. And what are we doing on the case?
She's pleading as charged, Your Honor.
She's pleading.
Yes.
As charged. May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Kamara Reed.
All right. Ms. Reed, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated. Is that correct?
Yes.
That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Understand that? The court could also order any community service or rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order you to pay the costs of the prosecution as well as the cost of any emergency governmental services. You understand that? Yes?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
She didn't, Your Honor, because she's in custody. I could have her do that now, or we could do that verbally, however you prefer.
Okay. You recall signing an advice of rights form? Yeah.
Yes.
Any questions regarding any of those rights?
No.
You'll see on the podium, I need you to look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
November 27, 2024, location of Carpenter near Chester Drive in Pittsfield Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, did you consume intoxicating?
Yes.
What did you have and how much?
I had a couple of seltzers.
Seltzers? All right. Were you stopped by the police or was there an accident?
I was stopped by the police.
Why'd they stop you?
My lights were off.
All right. Were you ultimately arrested?
Yes.
Were you taken to the station?
Yes.
Was there a blood draw or a blood test?
Both.
Blood draw?
Yes.
All right. What were the results of that blood draw?
I would stipulate for the plea, it was a 0.09 blood test.
You have any reason to dispute those blood test results?
No.
No? All right. I do have to advise you that if I do accept your plea, if you commit misconduct between the time of my acceptance of the plea and the time of sentencing, that any evaluation or sentence agreement, the court would not be bound by. You understand that?
Yes.
I also would have to indicate that if you do commit misconduct during that period, you would also not be entitled to withdraw your plea. You understand that?
Yes.
Counsel, I guess the first question is, have there been any promises, threats, or other inducements which led to this plea which have not been stated on the record?
No, Your Honor.
No, Your Honor.
And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Your Honor, I would say for the record, just so it's clear, the stop happened just after midnight. So the stop for no headlights and is a valid stop. I think we're going to stipulate that it was dark outside.
I don't.
Other than that, I'm satisfied.
We're satisfied as well, Your Honor.
All right. Court will accept the defendant's plea of guilty to this charge. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be July 9th, 2025. At what time? 9 a.m. All right. Either as to bond, but as to the violation.
The violation first, Your Honor, my client would waive her right to a hearing and be prepared to admit to drinking and ready to do that this morning.
All right. And that is correct, ma'am?
Yes.
You're waiving your right to a hearing?
Yes.
And you do admit, have you seen the violation report, ma'am?
No.
Okay, your counsel went through it with you, however?
Yes.
All right. And that there were on June 13th, 2025, that you were drinking?
Yes.
Very good. Court will accept that admission. How long have you been in?
Turned herself in yesterday morning. Is that, what time is it?
8 a.m.
8 a.m. yesterday morning.
All right. How old are you, young man?
21.
How old are you?
21.
Where were you drinking?
All right. My dad passed away a couple of years ago. My dad passed away a couple years ago, and I'm not handling it probably in the best way.
So you were 19?
18.
18 when he passed away?
Yeah.
Let me ask you this, was that where your drinking started, or?
Yes.
And let me ask you this, I'm not gonna hold it against you, were you drinking a lot?
Yes.
Looking back on it, when you were drinking a lot, what do you think would happen for you? Probably don't know how to answer that question. I mean, that's a tough question, isn't it? Suffice it to say, young lady, it would kind of make you forget and have the pain go away a little bit, right?
Yeah.
Okay. So, are you in school?
Yes. I'm supposed to go back next semester.
Did you finish up this semester?
No.
What happened?
I stopped attending my classes, so I had to withdraw.
Where were you in school?
It's my sophomore year.
At what school?
Eastern Michigan.
So when your dad passed away, had you already enrolled in school?
Yes.
And you made it through how many semesters after that?
2, and then I took a gap year, and then I went back.
Those 2 semesters that you took, how were your grades?
They were pretty good. I think I had a 3.2, 3.5.
Okay. You took the gap year, then you came back. How were your grades?
Okay, I think I had like a 2.
Pardon?
I think I had a 2.8 when I came back.
Where'd you graduate high school?
In high school.
Did you do well there? You got siblings?
I have a twin brother.
You have a twin brother.
Yeah.
What?
It's with mom in the corner of the courtroom.
Mom's on? Oh, okay. All right. So what do you think I should do with you? Well, before you answer that, let me ask you this. As you were going along struggling, trying to deal with your father's passing and things, did you let your mom know?
A little, but
Pardon?
a little, but not as serious as it had gotten. I don't think.
What about your brother?
I think he noticed.
You think he noticed?
Yeah.
Probably because he's your brother and also a twin, he probably did. Probably felt it. Did you reach out to anybody?
I've been seeing a therapist weekly.
You were?
Yes.
Okay. So how long have you been doing that?
I was seeing one I've been seeing her for like 7 years, and then I've been seeing one who specializes in grief for the last 3 months, I think.
Okay. So something that you started heading in that direction, dealing with her. Okay. How's that working for you?
It's going okay. I think I've been thinking about seeing someone else.
Pardon?
I've been thinking about seeing someone else. I don't know if it's a good fit.
Okay. So your therapist might not be fitting with you, right? Okay. All right. Now I'll get back to you. What do you think I ought to do with you?
Sure, I guess whatever punishment fits.
Give you a chance to prove you can stay sober.
Yeah. A chance to prove I could stay sober. I think.
You think you can?
Yes.
That wasn't real confident the way you said that.
I want to. And I think that I can.
Young lady, why do you think I asked you all of those questions?
See why I did it, I guess.
Yeah, maybe. Here's the thing that you don't understand and are just beginning to kind of explore. Grief is a horrible thing in a lot of ways. It becomes real bad if you don't deal with it. It kind of just sits there, and then at some point, while you try to sort of bottle it up and push it down, it somehow or another just all of a sudden begins to explode. Right? And then at some point, because you're not dealing with it, you're kind of out of control. And then it becomes harder. At the beginning, you probably could have told somebody, but by that time, you don't tell anybody because it becomes hard to explain. Right?
And it becomes real difficult to, no matter how close somebody is, then talk to anybody because they're not, you don't know if they're going to listen or they're going to take time to listen. And the reality of all of that is what you want is you just want that hurt and other things to disappear. Right? Were you close to your dad?
Yeah.
Something's gonna. I'm gonna guess, but I know I'm right because I'm always right. But I'm gonna guess that you were a daddy. All right. Look, more than anything, and I'm going to tell you, I don't always talk about myself, but I'm going to tell you why I asked the question. Here I sit all these years later. I lost my dad when I was 16. So when I'm asking you those questions about grief, I get it. Okay. I'm going to let you know that if you find a way to kind of deal with it, you're going to make it through it. Okay. I didn't know your dad, but I can almost bet that he'd want you to make it through. He wouldn't want you trying to do this, trying to deal with all of this on your own. Okay. So in the interim, how am I gonna keep you sober? Young lady, there's just right now, and partially because of the age you are, partially because of what you've been dealing with, a lot of things in life are real confusing right now, right? You're not sure the next step that you're taking, what direction that's going to head or what you're going to do, right? Okay, here's a suggestion I'm going to make to you. I want you to take whatever steps you're taking slow. I'm watching your mother over there. She's goosenecking trying to look over Miss Pilara's head, but your brother has been right all up in it. Okay? What that tells me is you got a family out there that'll just love you, they'll support you, and if you hadn't told them, probably after today, they'll sit for whatever time and just listen to you. Okay? And as you let it pour out to them, and I'm going to tell you, it's going to come out wrong. It's going to come out crazy. You may think yourselves crazy as it's coming out, but just let it come out. Okay? Said she turned herself in yesterday.
Yesterday morning, yeah.
Here's what I'm going to do. I indicated defendant is admitted to violation. I don't think it does any good to keep you incarcerated at all. All right. So I'm going to sentence you on that violation of 2 days in jail, credit 2 days use. I'm going to let you go. I am going to, however, order that you report over to the Department of Community Corrections. We're going to put a scram tether on you. Okay? You got that?
Yes.
All right. You are going back to school in the fall. That might have sounded like a question. It wasn't. Okay. And that you can take that as an order. You're going to go back. You're going to just sort of walk that journey through life and do that. Okay. You hear me?
Yes.
And I'll sign that scram order and we'll get you over there. All right, young lady.
Thank you.
Thank you, Your Honor.
Well, you're welcome. And most importantly, sometimes what you just have to do, you just have to be kind to yourself. Okay?
Okay.
Got it?
Yes. Thank you.
All right. Take care.
Thank you, Your Honor.
Thank you.
You. Guys, take care of yourselves. I don't know if you heard that, but she's getting out today. You're welcome. You're welcome. Court does call the case People versus Tasha Beavers.
All right, so on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Beavers. Who's approaching Ms. Beavers? Please state your name for the record.
Tasha Beavers. All right.
Your Honor, we are requesting an adjournment. Ms. Beavers is enrolled in treatment at Home of New Vision. The resolution on this case that basically depends on her completing or substantially completing a portion of treatment. So I just asked for a lengthy adjournment so she can kind of get in and start.
Was she at home now?
So I've never seen this. I was explaining this to Ms. Beavers. She was released from the jail yesterday to Home of New Vision. They said she wasn't eligible for inpatient and told her she can do outpatient. So I know Your Honor ordered her to do inpatient, but they told her she can't, essentially. So I've never seen that, because typically if Your Honor orders inpatient, but they did do an assessment. I did review that with Ms. Beavers. It's pretty lengthy. It's like 30 pages or something. And I guess that's what she assessed her for. So, but she is enrolled and she'll be going 2 to 3 times a week at Home of New Vision.
All right. Any objection to the adjournment?
No, Your Honor. Ms. Pilar just handed me an email from Home of New Vision.
Yes.
It said that Ms. Beavers did not meet the criteria.
Correct. And was discharged to home. Okay, and that's for outpatient
Okay.
treatment. All right. So what I will do is I'll adjourn this then, so we can figure out to do, and I'll adjourn this to July 16th. And then I'd like a report as to where she is.
Sure.
Okay. All right. Her bond will continue at this point.
Thank you.
Thank you. Court does call the case of the People versus Jacqueline Murray.
Conrad Silver on behalf of Township.
Kyle Burdell on behalf of Ms. Murray.
Sorry about that, Your Honor. Assistant Public Defender Natalie Pate on behalf of Ms. Murray, and the case ending in 1190 and anticipating appointment on the case ending 0617.
Your name?
Jacqueline Murray.
All right. I'll start with the new case, 0617. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about May 14, 2025, you were in possession of drug paraphernalia at the location of Harper Road, Pittsfield Township. You understand the nature of that charge, ma'am?
I understand.
All right. It's a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
Hmm?
Yes?
Yes.
All right. Do you wish to be represented by an attorney?
Yeah.
Public defender case.
Thank you, Your Honor. Assistant Public Defender Natalie Pate again on behalf of Ms. Murray. We would waive any further readings, stand mute, and not ask for a bond at this time, Your Honor. I believe this case will be resolved today.
All right. All right. So what are we doing?
So as to my 2 cases, Your Honor, Mr. Siller has extended an offer in which Ms. Murray was offered to admit responsibility to double parking in the case ending in 1190. And in exchange, the misdemeanor would be dismissed, and that then case ending in 0617 would be dismissed in its entirety. I did discuss that with Ms. Murray, and she would like to accept that offer today.
That is correct, Your Honor.
And what are we doing on the other case?
Your Honor, we are just asking for an adjournment. The people and I are trying to work out a global resolution involving some cases in some other courts.
That's
So we're asking
correct.
for
There's
an
a pending retail fraud as well on 15th. So we're trying to see how it's all going to shake.
And when is that one set for?
I don't recall.
I have to, let me look it up. I don't have it.
I think it's the middle of next month, but I'll know here in a second.
I've got it right here.
Actually, retail fraud set for pretrial on June 26th.
Oh,
June 26th.
26, okay, so.
All right.
Next week.
So would it still give you enough time if I set this for July 2nd?
I think so, Your Honor.
I'll adjourn this matter then, that being the case ending in 1360, July 2nd, 2025, 9 a.m.
Thanks, Judge.
Bond will continue on that case. In the other case, Ms. Murray, you admit responsibility to the fact that on or about August 2nd, 2022, at location on Washington Avenue in Pittsfield Township, Washington County, state of Michigan, that you double parked a motor vehicle.
Yes.
All right, court will accept that admission. That is in case 1190. That's count two. Count one is dismissed. And also case 167, ending in 167, is also dismissed.
It's 0617.
0617. What did I say? Yeah. Okay. Is dismissed. On the double parking, fines and cost of $180. You're incarcerated. What I'll make that do is I'll make that do 90 days after release.
Thank you, Your Honor.
All right.
Thank you.
Judge. Court calls case People versus Nadia Costley.
Right, so I'm
Actually, want to for the people.
Assistant Public Defender Natalie Pate, with and on behalf of Ms. Causley, who should be present via Zoom, standing in for Ms. Perny.
She's not. Both are on, correct? She's not in Zoom.
So, Your Honor, for the record, I'd respectfully request an adjournment. It's my understanding that she has a Secretary of State appointment scheduled for today after court. I don't have a further explanation for her failure to appear and respectfully request an adjournment.
In these matters, bench warrant will issue for defendant's failure to appear. Bond in each case is set in amount of $5,000. Will give a 10% privilege. Both of those warrants will issue immediately.
Thank you, Your Honor.
Thanks, Your Honor.
Court does call the case People versus Caitlin Morgan.
Actually, want to for the people.
Good morning, Assistant Public Defender Lauren Penny on behalf of Miss Morgan, who is approaching.
Your name?
Caitlin Morgan.
All right. This is special time set for sentencing in this case.
Yes, Your Honor.
You know, we did review the pre-sentence report. We have no material changes, additions, or deletions. I did review the recommendation with Miss Morgan and would like to, we do ask that you adopt it, and I would like to make a few statements on Miss Morgan's behalf when appropriate.
All right. Just so that we're also clear, did you review, there was a victim's impact letter that was sent. Were you able to review that also, counsel?
Yes, I think there were two original, and then I got an initial one this morning, and I was provided that from the victim's advocate.
All right, very good. And I know that the victim in this case is present. My understanding is she at one point wanted to make a statement. I don't know if this letter is.
Your Honor, I believe that provided she just decided to provide you the statement in writing, so she can.
All right.
That's the understanding of the people as well, Your Honor.
All right, go ahead.
Your Honor, today is a special time for sentencing, and I want to start out by thanking Your Honor, as well as Ms. Pilara, in considering some additional information that I provided to her. It was a 22-page memo, so it was quite lengthy. And again, I do thank her for considering this information. I did want to, again, there was a lot of stuff that's provided on the record, and I do want to focus on some mitigating information on behalf of Ms. Morgan. In December, I first want to address her health. In December 2024, she got into, a very serious car accident. She's in the hospital for some time and is still dealing with those repercussions. She's seeing both a neurological doctor for the effects of her nerve damage, and she's had one surgery on her arm, and is scheduled to get an additional surgery on that arm. It's not functioning properly, her arm. She does not have full range of motion. She did miss a post-op appointment while she was in custody, and when she gets out of custody, she'll be returning to see that doctor. She is trying to get disability because of that injury, and is engaged in another civil suit because of the crash. Even though she is having that difficulty with her arm, she is working and engaged in school. This semester she was at Ross Medical Center, studying to be a certified medical assistant. Her plan is to go to nursing school. She was working as a health health aide, for an elderly man. Her mother explained to me that she was essentially doing this job with one working arm, but needs to support her children and assist with the man's daily tasks. She is planning on, or is set to graduate from Ross Medical Center with her certification as a certified medical assistant. However, there's one last test she has to take that includes CPR, and because of her arm, she can't do that CPR portion of the test. She is engaged in mental health treatment. She has a psychiatrist that she sees monthly, and she's also engaged with who she's also engaged with talk therapy with. She does have the support of her family. I have been in communication over the last couple of weeks with her mom every couple of days. Her mother submitted a letter on her behalf, as well as her grandparents. Because of her injury, she does need a caretaker. She is moving in with her mother, so her mother can help her with her own daily tasks, as well as the care of her children. She has 3 children, 7, 2, and 1. Her oldest father died when he was young, so she's desperate to get out of custody and get back to. Oh, she said he died when she was pregnant with the oldest. Given all of this, her engagement in mental health services, her physical health condition, her children, schooling, employment, I am asking the court to adopt this recommendation. She does have the support of her mother, who is here, and I think would like to speak to your honor. I've had multiple conversations with Morgan over the last couple of weeks, and I think she's quite desperate to change her life. She's already made some changes in the relationships in her life, and I think she's dedicated to the betterment of herself and her children's lives.
Very good. Her mother wanted to address the court.
Yes, if that's okay with your honor.
Where is she? Come on now. Hello.
Hi, Your Honor.
What's
If I
your
may,
name?
just one moment, your honor. It's okay.
I'll try. I'll try.
All right. Your name?
April Moylan.
All right. Go ahead. What would you like to tell?
Your Honor, I'd like to tell you that Caitlin is a good person. She has a good heart. She's active. We are active in 2 churches. We go monthly, feed the homeless down in Cass Park. As a matter of fact, a month before Caitlin's bad accident, we were down in Cass Park handing out hot meals, essentials, clothing, whatever we could do to help the homeless. Caitlin has 3 children, which I'm currently caring for. And it has been a hardship on me because I'm trying to work full time and care for 3 grandchildren. Instead of being the grandmother, I'm being the mother, which Caitlin should be doing. I understand that Caitlin's behavior has gotten her where she is, but Your Honor, this has been going on for 7 years with these 2. baby mama daddy drama. Okay, it's been back and forth, back and forth. I just wish that Caitlin gets herself together and stays away from the negativity. Her kids need her. They cry every day. My grandson wrote a letter to you. I don't know if you got it.
Yeah.
It was pretty sad, to see him, crying for his mom. And it's really hard on me. And I just ask that you find it in your heart to let my daughter come home.
Thank you.
Thank you.
And anything you'd like to tell the court before I impose sentence?
No, Your Honor.
All right. Court has reviewed extensively the information that has been provided and looked it over, and the court does believe and will follow the recommendation of the probation department. In this case, I think it's well suited to kind of deal with a number of different issues that are sort of permeating this entire case. So it's the sense of the court. I will place you on 36 months probation. That's 3 years. You are to pay $655 fines and court costs, $1,080 probation oversight fees. That will be on a payment plan as arranged by probation. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the life skills program. You're to enroll in that within the next 60 days. You are to attend individual therapy with status reports to probation. There is to be no contact with Sarah Tessier or her children directly or indirectly. You understand that, ma'am?
Yes, Your Honor.
There is to be no use of social media whatsoever. Delete and or close all accounts on social media immediately upon your release. You understand that?
Can I ask one? Can I ask one question? I have one page where I'm friends with my son's dad, and that's the only way I can see pictures of him and show my son. Is that okay if I just
See
keep
pictures of
his father, who's deceased?
Yeah, I think if it's okay, Miss Pilar and I can work something out.
regarding that. I'm going to order that. So because I think there's been an abuse of that, and so I am going to order that her social media accounts are to be closed and deleted. All right. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You are to comply with any and all circuit court orders if there are any. You are to contact probation within 24 hours of your release from custody and then report as directed by probation. I am going to order a GPS tether through community corrections with the exclusion zone. Are you indicating exclusion zone of the entirety of Washington?
Yes, Your Honor.
All right, with the exclusion zone of Washington County. I'll schedule a review hearing on this matter for August 27, 2025 at 12 p.m. I will order 365 days in jail. Credit 17 days that you served. You're to serve an additional 14 days for the bond violations to date, and then the balance will be suspended with placement of a GPS tether as indicated prior to your release.
Yeah, I'm sorry, I should have brought this up before, regarding the exclusion zone, and again, this is something that Ms. Pilar and I can work out. Her doctors, like her orthopedic surgeon is at Trinity Health in Ipsy, so we can, if the court's amenable to that, and Ms. Pilar, I can provide documentation regarding
I would
medical appointments.
correct. And for medical, if that's where her medical appointments are, that will be allowed. All right, but strictly for that medical or any other necessity that she has to have within Washington County, as she would be able to report to probation.
Correct. Understood. Thank you.
All right. Thank you. Court does call the case People versus Christopher Minor.
Conrad Solo on behalf of Eastville Township.
People.
Good morning, Assistant Public Defender Lawrence Kearney on behalf of Mr. Minor. Your Honor, I did attempt to make contact with Mr. Minor. I was unable to make contact.
Oh, those two separate groups there. Ma'am? All right, I'm gonna have you're with Miss Morgan, correct? You're with Mom and everybody. I'm gonna have you wait to let the others go.
Okay.
And then, okay? Thank you.
Thank you.
All right, go ahead. I'm sorry on the minor matter.
No, I apologize. I was not aware of what was happening behind me, but yeah, I attempted to make contact with Mr. Minor multiple times. I have not heard back from him. I did speak with the CMH caseworker yesterday, who indicated he did call her yesterday. So it seems like he is engaged with services, but not present.
Bench warrants will issue for defendant's failure to appear in all of these matters. Bond is set in the amount of $5,000. 10% privilege. Those warrants will issue immediately. Thank you. Court does call the case of the People versus Anton Brooks.
Conrad Solo on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Brooks, who stands to my right. Please state your name for the record, sir.
Tom Brooks. All right.
Thank you, Your Honor. There is a resolution in this matter to which Mr. Brooks will be accepting the offer from Mr. Siller of pleading to added count 2 of allowing an ineligible person to drive, and in exchange, count 1 will be dismissed. I did go over Mr. Brooks's advice of rights form with him yesterday in the jail, and he is now signing right there.
So Your Honor, operating, allowing an ineligible person to operate MCL 257.326. You thank you legally and dismiss the
May I have it sworn?
Raise your right hand. Do you solemnly swear in affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, sir.
State your name.
I'm Tom Brooks.
There it is. This court's understanding you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail and or a $100 fine plus court costs. You understand that, sir?
Yes, sir.
And understanding that you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed any advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. Right? You understand that, sir?
Yes, sir.
You understand you're giving up your right to appeal of right? I didn't say so.
Yes, sir.
Are you on probation or parole?
Yes, sir.
You are?
Probation.
Probation? Were you on probation at the time of this offense?
Yes,
In
sir.
April?
Yes, sir.
All right, I do have to advise you, then your plea could be a violation of that probation. You understand that?
Sir.
If it is considered a violation of your probation, that court could sentence you to the maximum allowable under that other charge or charges. You understand that?
Yes, sir.
Understanding that, you still wish to plead guilty to these charges?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
Yes?
Sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On the date of April 6, 2025, the location of Washtenaw near Gulfside, Pittsfield Township, Washtenaw County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes, sir.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes, sir.
All right.
You understand also, sir, that if I do accept your plea, and again, I'll be immediately sentencing you, so there would not be a period in time between acceptance of the plea and that, but if there were misconduct, you would not be able to withdraw your plea in any agreement with the court or any evaluation by the court. The court would no longer be bound by that. You
Yes, sir.
understand that, sir?
Yes, sir.
All right. Counsel, have there been any other threats, promises, or other inducements that have led to this plea?
No,
Not that I'm aware of, Your Honor.
All right. Has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Anything either of you want to say before I impose sentence?
Just briefly, Your Honor, we'll note that Mr. Brooks has, I believe as of today, 34 days of credit. So I would ask the court would consider sentencing him to a credit for time served sentence. He is being held on other matters with his next court date being the 26th of this month.
Sir, anything you want to tell me?
No, sir.
Fines and costs of $250 that will be due and payable 90 days after release. Other 90 days in jail, credit 34, balance suspended. Thank you.
Thank you, Your Honor.
No. Court does call the case People versus Brendan Williams.
All right, so
Assistant Public Defender Natalie Pate with and on behalf of Mr. Williams, who should be present via Zoom.
And that's a lot of good people.
Mr. Williams, state your name, please.
Brendan Williams.
Thank you. 578 is annoying. Got it. All right. Before we go on to the other case, sir, you have a new case before the court that alleges that on or about April 3rd, 2025, at the location 5915 West Michigan Avenue in Pittsfield Township, that you did operate a motor vehicle with a high blood alcohol content. Do you understand the nature of that charge, sir?
Yes.
That is a misdemeanor punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could order community service, any rehabilitative programs the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes.
I would also indicate that there is a second offense notice so that the penalties on this would be increased to a misdemeanor punishable by up to 1 year incarceration and a fine of up to $1,000. You understand that, sir?
Yes.
First question I have for you, sir, is do you want to be represented by an attorney?
Yes.
This is a public defender case.
Assistant Public Defender Natalie Pate, again, on behalf of Mr. Williams, we waive any further formal reading, stand mute, and ask for an adjourned pretrial date in this case, Your Honor, please.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. As to bond in this case, alleged BAC.
0.294. And I will note for the record as well, Your Honor, the court noted the incident date of April of 2025. The prior conviction date is October of 2024. The arrest date for that case was August of 2024. So extremely close in time. I am requesting a scram tether.
Is there any accident?
There was not a crash. The defendant was located laying sideways in the front seat of the vehicle and was making comments about he should be in the driver's seat, things of that nature. There was not, but there was no crash.
All right. As to bond.
As to bond, Your Honor, I would request a PR bond, and we have no objection to any of this standard bond conditions. I just want to note that Mr. Williams does currently have a scram tether on him for his probation that he was sentenced to last week through 14A1, and so he does currently physically have a scram tether on him. We certainly
Was that going to expire at some point?
I looked at the sentence and it didn't have it written on there when it would. I would speculate that it would expire at some point. Yes, I don't have that date of when that is, though.
And Your Honor, if I recall correctly, I do believe that's a case that also had a drug and disorderly charge attached to it. So alcohol does seem to be a major problem.
Set his bond in that case at a $30,000 personal recognizance bond, all order standard conditions, including no assault behavior or possession of any weapons. There is to be no alcohol, recreational marijuana, or illegal drug use by you. I will sign a community corrections order for a scram tether, that one would be placed after expiration of the current order on the other matter. All right. What are you doing in the other case?
Your Honor, regarding the other case, I'm moving this as the defendant's conduct does not satisfy the elements of the offense.
On the disorderly person?
I'm the disorderly person, correct.
Any objection?
No objection, Your Honor.
That being case 0546, that case is dismissed. All right, we'll see him on the second.
Thank you, Your Honor. And thank you, Mr. Williams. You're all set for today, but we'll be in touch for the next time.
All right, thank you.
Court does call the case of the people versus Matthew Vanessa. Amsica, I think is how it is.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Fonseca? State your name, please.
Matthew Fonseca.
Thank you.
Your Honor, we're asking for an adjournment in this case. Mr. Fonseca has a PCC before Your Honor on the 26th. I was in communication with Ms. Londi this morning as well, and I'd like to relay some things to my client about possible resolution of this case. So, and of course, the felony may drive the bus depending on what happens there. So we're just asking for an adjournment.
July 2nd, 2025.
Thank you.
Thank you.
Thanks. Have a good one.
How many are in my limit? You can put them up there. I'll start rolling them. I mean, we can actually start calling somebody between cities.
Yeah.
Or, well, they're still part of the same lot. So if I got one that I can call.
So this one is ready. He's gonna call.
Court does call the case of the people versus Gabriela, is it Herrera?
Christina Bergeron for the people.
Good morning, Your Honor. Tina Saxon on behalf of Ms. Herrera, who's approaching. Gabriela Herrera.
What are we doing?
Your Honor, today's day and time for a PCC. My client is
No, it's
willing to enter.
It's for a pretrial.
I'm sorry, pretrial felony mode again. My client's interested in entering a plea, and in discussion with the prosecutor, will be pleading as charged with HIDA.
HIDA.
That's correct, Your Honor. The offer is to plead guilty to charges of IDA.
Thank you. Sever sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Gabriela Herrera.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of embezzlement by an agent or trustee less than 200. Yes. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Understanding that you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
Yes, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are the rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Sure.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you? Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and because you believe that you are indeed guilty of this offense? Yes.
Yes.
Between the dates of May 27, 2020, August 10, 2022, at the location of 7,000 East Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you employed at Walmart?
Yes.
All right. And what'd you do that makes you think that you're guilty of this offense?
I was working there and I took several items while on the job.
You took several items like what?
Without paying for them.
Okay. So you took items during that period in time from the job, you did not pay for those, correct? You didn't have anybody's permission from Walmart to do that?
No.
That was not some benefit of your employment that
No.
you take that, build
No.
that property. This property you took, was it valued in excess of $200?
No. It was under that.
Okay. And you came into possession of this property that you took by virtue of the fact that you were employed at Walmart? Yes. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied, Your Honor.
Defense is satisfied.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred, before I say that, I guess I do have to advise you of this. If you understand that if I accept your plea, ma'am, if between now and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, that any sentence agreement or any evaluation like for HIDA or other things would no longer be in play and the court is not bound by that. You understand that?
Yes.
You understand also that if you do commit that misconduct, you would also not be entitled to withdraw your plea.
Yes.
All right. And counsel, is counsel aware of any promises, threats, or other inducements that have made this plea come about other than those that may have been disclosed on the record?
No, Your Honor.
No, Your Honor.
All right. Thank you. Court will accept the defendant's plea then of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th at 2025, 12 p.m.
July 30th, 2025, 12 p.m. All right.
Your Honor, I'm sorry, I'd like to add for the record that the prosecution consents to hide it in this case as the defendant was 23 years old at the time.
Got it. Okay. Thank you. All right.
Thank you.
Thank you. Court does call the case People versus General Frederick. All four cases.
On behalf of student township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Frederick, who stands to my right. Please state your name for the record, sir.
Frederick. All right. What are we doing?
Thank you, Your Honor. There is a resolution in all four matters to which Mr. Frederick will be pleading no contest as charged in the case that ends in 1042. And in exchange, all other three cases will be dismissed. Sorry, Your Honor.
Go ahead. Go ahead.
I have reviewed Mr. Frederick's advice of rights with him in the jail yesterday.
He's
And
pleading
he
no
is signing.
contest in the case ending in 1042 and the others are being dismissed.
Correct, Your Honor.
Yeah. Someone that came in. Yeah, that's all. All right, may I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Frederick. Sir, it is this court understanding you're going to be pleading no contest to the charge of retail fraud under the Pittsfield Township ordinance.
That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. You understand that?
I do, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
Two things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Basis for the no contest plea.
Potential civil liability.
Sir, to that charge, how do you plead?
You plead no contest, guilty or not guilty.
No contact?
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes,
of your own free will.
that's correct.
And because, well, I won't ask you that. Counsel, the court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 247634. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Sir, I do have to also advise you that if I accept your no contest plea between the time of today's date or its acceptance and the time of sentencing, if you commit misconduct as defined by the court rule, that any sentence agreement or sentence evaluation would no longer bind the court. You understand that? I wouldn't be bound by that. You understand that, sir?
I do, Your Honor.
You understand also that if you commit any misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right. Counsel, is counsel aware of any other promises, threats, or inducements which have resulted in this plea?
No, Your Honor.
No, Your Honor.
All right. And based upon a review of the police report in this case, the court does find that there's sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right, court will accept the defendant's plea of no contest to this charge.
Excuse me.
The case is ending in 0671, 0944, and 1267, all 2024 cases. Those matters are dismissed pursuant to the plea agreement. Defendant is referred to probation for pre-sentence investigation and report. Sentencing in this matter will be
July 7th, no,
July 9th.
July 9th, 2025 at 9 a.m.
July 9th, 2025, 9 a.m. Fine, we'll continue. Thank you.
Thank you, Your Honor.
Court does call the case People versus Adams. Swords.
Ashley for the people.
Good morning, Your Honor. Timothy Dinan, P49499, appearing on behalf of Mr. Sowards, who's also present on Zoom today.
Sir, please state your name.
Adam Swords.
All right. All right, what are we doing?
Your Honor, I have received some of the discovery. I'm still waiting for the police report. I've just asked for an adjournment and have this matter set for another pretrial, please.
Adjourn the matter to July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue.
Bye-bye.
Bye-bye. Court does call the case of the People versus Justin Goltowski.
Christina Bergjan for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Goltowski, who should be present via Zoom.
Goltowski, I don't have him.
So, Your Honor, I don't have an explanation for his failure to appear. We actually spoke yesterday and we had a scheduled appointment for Friday at 2 to further review his discovery and options. I did provide him with a Zoom link and was expecting him to be here today. I would respectfully request an adjournment for the record.
Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10%. That warrant will issue immediately.
Thank you, Your Honor.
Court does call the case of the people versus Stephen Grisbeck.
Conrad Solar on behalf of Plainville Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Grisbeck, who is approaching. Please state your name for the record.
Stephen Grisbeck.
Your Honor, Mr. Grisbeck is going to be pleading guilty as charged. We would be asking for immediate sentencing. He has 84 days credit as of today.
He has 84 days.
Yes.
I have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Stephen Grisbeck.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of possession of drug paraphernalia. Is that correct?
Yes, Your Honor.
That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You cited advice of rights form?
May I approach?
Yes.
Yes, I do.
Any question regarding any of those rights?
Oh, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Okay.
Yes?
Yes, Your Honor.
All right. You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
To clarify, Mr. Grisbeck is on probation before Your Honor, but
Yes, he
this
is.
incident
yeah.
occurred before he was on probation.
Yes. Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
All right. I do have to advise you, although I'm likely to impose immediate sentence, that if you commit misconduct between the time of this plea and the time of my sentence, that you would not, first of all, be allowed to withdraw your plea, and that any potential sentence agreement and or evaluation would no longer bind the court. You understand that?
Yes, Your Honor.
All right. So, sir, on the date of September 3rd, 2024, at the location of Packard Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have drug paraphernalia in your possession?
Yes, Your Honor.
What'd you have?
A syringe.
All right. And you used that for the taking of drugs?
Yes, Your Honor.
All right. Counsel, have there been any other promises, threats, or inducements that you're aware of that have led to this plea?
No, Your Honor.
No, Your Honor.
All right. Has the court complied with the court rule? Would it be proper to accept the defendant's plea?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Sir, anything you want to say before I impose sentence?
Not this time, Your Honor.
Anything, Ms. Barney?
No, Your Honor, as I stated, we would ask for credit for time served. He has 84 days of credit in the Washtenaw County Jail. And when he's released from here, he will be on probation before Your Honor in Ms. Pilara.
This is last case before me.
I think so, yep.
Been showing up forever.
I'll see you again on July 7th.
So no.
He's back.
He's back.
Just for probation review, though. It's
Okay.
not a nude case, so.
All right. Sentence of the court. State minimums of $125. I will then sentence him to 84 days. Washtenaw County Jail, credit 84, sir. All right.
All right, thank you.
Thank you.
Court calls the case of the people versus Lamar Hampton.
Echelon of the people. Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hampton.
Mr. Hampton,
Lamar
can you state
Hampton.
your name, please? Thank you.
Lamar Hampton.
Your Honor, I am requesting an adjournment of the pretrial hearing. Mr. Hampton will be over some documentation regarding his efforts towards getting his license, and I would like to have another conversation with the people.
July 2nd, 2025, 9 a.m. Thank you, Mr. Hampton. Court does call the case of the people versus Roman Hop.
Stand very adjourned for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Hop. Please state your name.
Verlon Hop.
We will make sure that he has full pants on when he comes here again.
We'll have a conversation about pants, Your Honor.
All right, what are we doing?
We're asking you to set this for final settlement, please.
Jury final settlement conference will be August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in.
Thank you.
Court does call the case People versus Otis Elliott.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Elliott. And Your Honor, I did attempt to contact Elliott. I didn't hear back from him. I'm not sure. He was sitting present in the courtroom. I'm not sure if he's on Zoom.
He is not.
I do not have an explanation for his failure to appear for the record. I request an adjournment of this trial.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue immediately. Who? They're coming here right now. Court calls case People versus Ariana Jenkins.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Jenkins, who stands to my right. Please state your name for the record, ma'am.
Ariana Jenkins.
Thank you, Your Honor. Today we're here for both a bond violation and a pretrial. As to the pretrial, well, I'm happy to address whatever, Your Honor.
Go ahead.
So as to the pretrial, I'm just requesting a very brief adjournment. The people have extended an offer of this case for my client to plead to an added count 2 of operating while intoxicated. I was able to briefly discuss that with her. However, we need more time to discuss both the ramifications of that potential resolution. So I would be asking for a very brief adjournment. And I am also prepared to address the bond violation when appropriate.
Turn it to July 2nd, 2025. As to the bond violation.
Thank you, Your Honor. As to the alleged bond violation, which is that Ms. Jenkins did not report to community corrections to obtain her SoberLink device, I have discussed that with her and she does admit to that bond violation. She did turn herself in yesterday at 2142 to the Washtenaw County Jail on this warrant on my advice to do so. We are asking that the court would release her today. She does understand that if she were to be released, she would have to, it is likely that a community corrections re-referral will be ordered and that it is likely that that may be a scram tether at this time. She does understand that she would likely be fitted with that before her release from the jail. I am asking that the court release her. She does have strong ties to this community. She does live in Saline with her mother, her cousin, and her grandma. She has full-time plus employment, working 6 days a week at a senior residential living / nursing home. In speaking to my client and upon what I can access, it is my understanding she has no prior criminal convictions and no other pending matters. She has strong family support. Frankly, I asked her when I received this bond violation and was in contact with her, I asked her why she did not go to pick up the SoberLink. She did state to me that she went to the court counter, was told that it might take a couple hours for the SoberLink to be ready after the order was provided, and she was in fear of losing her job if she didn't show up in time to her shift, so she left and went to work. I did advise her that candidly, she should not have done that. She should have waited and complied with this court's orders. My client does understand that, and she does understand that this is a very, very serious matter. After the bond violation was issued, she was in both contact with me and then on her own did submit a bench warrant recall. Since this, we've had many conversations. She did turn herself in on the warrant yesterday. She takes these court orders seriously. She just wants to apologize to the court and ask for another chance. It is my understanding that there is no drinking events and that there are no other alleged violations.
I will grant her a personal recognizance bond with a teller prior to release.
Thank you, Your Honor.
Thank you.
Thank you.
Second.
Thank you, Your Honor.
Yes, SoberLink.
Get her on it. Court does call the case People versus Jessica Fox.
Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. Fox.
Ms. Fox, can you state your name, please?
Jessica Fox.
Your Honor, we're requesting an adjournment. Lonnie and I did have a conversation this morning about this case. I just want you a little time to speak to my client.
July 2nd, 2025, 9 a.m.
I'm gonna call you, Ms. Fox. Thank you, Your Honor.
All right, thank you.
Court calls the case People versus Marcus Moore Jones.
I didn't get the Zoom information, that's why I'm here.
What?
I didn't get the Zoom information, that's why I'm here.
What's your name? Okay, you can be here. Come on up. Is that because you're wearing shorts? You didn't want to come up?
No, I kind of woke up late today. I thought I was gonna miss court. I gonna lie, Judge Simpson. I woke up and came straight here.
And had no pants?
Nope, this is exactly what I had on. Except for the shoes, but.
No, we won't let that happen next time, right?
Yes, sir.
All right. Mr. Moore Jones, you are before the court on a misdemeanor citation that alleges that you did operate a motor vehicle without proper security or insurance that is alleged to have occurred April 29, 2025, US 23 in Pittsfield Township. You understand the nature of that charge, sir?
Yes, sir.
That's a misdemeanor punishable by up to 90 days, a minimum of $200 and up to a $500 fine plus court costs. You understand that?
Sure.
First question I have for you is, do you want to be represented by an attorney?
Yes, sir.
It's a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Moore Jones, we would waive any further reading, stand mute, and ask for an adjourned pretrial date.
Retrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. You think you can make that time?
Yes, Your Honor.
You ain't going oversleep?
No.
You sure?
No. I'm not going oversleep.
All right, well, if we do, I got your address. We'll come get you.
All right. I know that. For sure.
Stand in every way for all reading, standing mute, equivalent or not guilty plea. July 2nd, 2025, 9 a.m. Set his bond at a $5,000 personal recognizance bond. All order standard conditions, including no assaultive behavior or possession of any weapons. I will also order that there's to be no use of alcohol, recreational marijuana, or any illegal.
Thank you, Your Honor.
Thank you. Thank you. Thank you.
Oh, sir.
No.
Court does call the case of People versus Chad Jones.
Conrad Soder on behalf of Pittsfield Township.
People.
I have 3 cases.
Sorry. Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Jones. Mr. Jones, please state your name for the record.
Chad Jones.
As Your Honor knows, Mr. Jones has felonies before Your Honor at the PCC stage. Everyone's working to get him into treatment, so we're requesting an adjournment for that and also work something out.
So his felony cases, we adjourned to what day?
July 3rd?
July
3rd.
3rd. Okay. Well, dear, doesn't do any good to put these on the 2nd then.
Probably not.
So I'll adjourn these all then to July 16th, 2025 at 9 a.m. And if we get a resolution, have to do something, we'll try to deal with these early. Yeah. All right.
Thank you.
Thank you, Mr. Jones. Bond continue. That's called the case of the People versus Pauline Marcharia.
Assistant Public Defender Natalie Pate with and on behalf of Macharia, who is present via Zoom. Ma'am, can you please state your name for the record?
Pauline Macharia.
All right. What are we doing?
I have discussed this matter with Miss Londi. It was my understanding that this case was going to be dismissed.
Crickets.
Sorry, Your Honor, I'm so sorry.
My notes are on a slow bus from Detroit. It's
Whoa.
a long time.
Wow.
Thank you, Alan. Yes, this case will be dismissed. Thank you.
All right.
Get the paperwork over.
Case is dismissed without objection.
Yes,
All
there's
right.
no objection.
Thank you, ma'am.
Thank you.
Thank you, ma'am. You're all set.
All right, thank you,
Court
ma'am.
calls case people. Court calls case people versus Todd Reberg.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Reber. Mr. Reber, please state your name for the record.
Todd Brian Rayberg.
Your Honor, we are requesting an adjournment of the pretrial. I do have an order for the court to consider releasing him to treatment. He was before Your Honor yesterday, and
Yes.
I believe Your Honor signed that.
When did we adjourn your case yesterday to?
Third.
Okay.
Order courtesy of Ms. Yagi.
Pardon?
The order's courtesy of Ms. Yagi.
I know that. I'm glad you
So,
finally have talked to her and listened to her.
I know, it's
Trying to get the others to do the same.
a pretty nice order.
It's a beautiful order.
So that's our
Done
only,
correctly. Not something I expected from your office. Go ahead.
hang, catching.
Wow, that was a shot.
That wasn't even a straight. That was a direct hit. So that's our only request. Well, I guess both requests an adjournment and the order to be released.
All right. And again, you're looking at some type of global resolution ultimately.
Right. This is a possession of drug paraphernalia case. So the standing offer from Mr. Silish dismissed if treatment's completed, and he has felonies, multiple felonies or one felony?
And Your Honor, he does have 2 drug paraphernalia cases in this court. That's why his case is 0195.
Oh, that's correct. It is set on July 2nd.
The other case.
Yeah.
Okay. Then, well, why don't I just put this on July 2nd, understanding we might have to adjourn it, but then everything will be together.
Yeah.
And he may get out on this.
Yeah. Thank you, Your Honor.
All right, thank you. Thank you, Mr. Wood.
Thank you.
Court does call the case People versus Chad Maurer.
Echelon for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Maurer. I'm not sure if he's on Zoom.
Chad Maurer. He's there, but he's not.
Hey, there we are.
State your name, sir?
Chad Maurer.
Okay.
Your Honor, I'm requesting an adjournment. Mr. Maurer and I did not have a chance to connect prior to today's hearing. His mom did inform me, though, he started a new job, and that's likely why he's been working a lot, and that's likely why we have missed each other. So I just like a chance to speak to him about resolving this file.
July 2nd, 2025, 9 a.m.
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Maurer.
Yep.
Court does call the case of the People versus, is it Aneja O'Hearn?
Echelon for the people.
This arraignment. Court will issue an order to show cause for their failure to appear. Court does call the case of the People versus Brandon Smith.
Conrad Solar on behalf of Pittsfield Township.
This is an arraignment.
Yes, I'm sorry.
You know what, Your Honor, I'll make it easy. I'm going to dismiss. Defendant's conduct does not satisfy the elements.
Sir, you have any objection to that?
I do not, Your Honor.
I didn't think you did. All right, case dismissed.
Thank you,
Take
Your
care
Honor.
of yourself.
Thanks, sir.
Court calls case People versus Rebecca Miller.
Echelon for the people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller, who appears via Zoom. Ma'am, can you please state your name for the record?
Rebecca Miller.
Thank you, Your Honor. So fortunately, Ms. Miller is back at Dawn Farm, no longer at the hospital. So today we can do the resolution that we intended to do at the last pre-trial before Ms. Miller was unfortunately had emergency surgery. I do have a plea form here, and Your Honor should be in receipt of the police report as well as signed advice of rights form that I submitted prior to the last pre-trial.
I don't know that I still have the police report in the file.
The offer that is writing in front of you is to plead to that add count 2 of retail fraud in the 3rd degree, dismiss count 1 retail fraud in the 2nd degree.
All right. We have a report.
I'm sorry, I should have submitted it again probably, or
Yeah.
twice. I didn't
All right.
know if it was kept.
Ms.
in file or
Miller,
not,
we'll
sir.
come right back to you. Let me pass this matter briefly. I'm sure I reviewed the report. I just don't have it in front of me. Okay. Court will pass that case. Court does call the case People versus Leo Stringa.
People.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stringa, who is approaching.
Your name, sir?
Leo Stringer.
All right, what are we doing?
Thank you, Your Honor. This is the first pretrial in this case. I'm respectfully requesting an adjournment to, well, first of all, fully discuss this with my client as well as in tandem with his other matters. He's scheduled for his next court date on July 3rd. I believe the probable cause conference on his new felony retail fraud case. I would request an adjournment possibly till after that date, if Your Honor would allow.
July 16, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case People versus Kenneth Miller.
Echelon for the people.
He is in Zoom.
Kenneth Miller.
Kenneth Miller.
Sir, you are before the court on a misdemeanor complaint that alleges that on or about March 19, 2025, at the location of 7,000 East Michigan Avenue, Pittsfield Township, Washington County, State of Michigan, you did operate a motor vehicle while intoxicated with an occupant less than 16 in that vehicle. Do you understand the nature of that charge, sir?
Yes, Your Honor.
That is a misdemeanor punishable by a fine between $200 to $1,000, not more than 1 year in jail. The court could order community service as well as any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. Do you understand that, sir?
Yes, Your Honor.
All right, first question I have for you is, do you want to be represented by an attorney?
Yes, please.
It's a public defender case.
Good afternoon. This is the public defender Lauren Kearney on behalf of Mr. Miller. We waive formal reading and stand mute to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to these charges. You're asking for an adjournment.
Yes, Your Honor.
I will adjourn this to July 2nd, 2025, 9 a.m. As to bond.
Your Honor, in this case, the defendant, as charged, did have a person under 16 in the vehicle. I do believe that was his 6-year-old child. There was a crash, and his alleged VAC is .210. I am requesting a scram tether.
Your Honor, I'd ask for a personal bond. I think a scram tether is reasonable request.
Bond in this case will be set in the amount of $20,000 personal cognizance under standard conditions, including no assaultive behavior or possession of any weapons. There is to be no use of any alcohol, recreational marijuana, or any illegal drug. You understand all of that, sir?
Yes, Your Honor. I have one question about is the scram tether, is that an alcohol tether or a GPS tether?
That's well, it has GPS capabilities, but it is an alcohol tether.
Okay.
I'm going to order that you report over to the Department of Community Corrections for placement on a scram tether. You need to do that within the next 24 hours, sir.
Yes, Your Honor.
All right. Thank you.
Thank you.
Next date was 7/2, Your Honor.
Yes.
Thank you.
Court does call the case People versus Shania Williams.
Conrad Solar on behalf of Pittsfield Township.
Afternoon. Assistant Public Defender Lauren Perny on behalf of Ms. Williams. Okay, nice. Your Honor, I did attempt to make contact
Did
with.
your computer get on the same bus as Miss Lounge?
Yeah, it was, and maybe my brain as well. Hi, good morning. I didn't have contact with Miss Williams. I did not realize you were in custody, so I apologize. This is a license case. Are you being held on other cases, I presume?
Yes, ma'am.
Okay, so I would just ask for an adjournment of this case.
July 2nd, 2025, 9 a.m.
Thank you.
And I don't know if you stated your name for the record. Can you state your name, ma'am?
Shania Williams.
Thank you. All right. Thank you. Yeah.
And the problem, okay, yes, I'll come. and we'll
I did not
okay?
start anything on this. Court recalls case People versus Miller.
Rebecca? Karen?
Yes, Rebecca.
That's
Miller.
the one you can people.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller. Ma'am, could you please state your name for the record?
Rebecca Miller.
Court's understand, she's gonna plead no contest to the charge of retail fraud in third degree. Upon their successful no contest plea to that charge, count one would be dismissed. That's the court's full understanding of the.
Correct. Yes, Your Honor. And that is my understanding as well as my clients that we have discussed, and she would like to accept that offer, pleading no contest today.
Ma'am, can you please raise your right hand?
Sorry.
You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. State your name again for the record, please, ma'am.
Rebecca Miller.
All right, ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right, 2 things about it I have to make sure you understand. It first of all means that you're not further desirous or wanting to contest this charge. You understand that?
Correct, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. So, ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Correct.
You had previously signed an advice of rights form, is that correct?
Yes, Your Honor.
All right, do you have any questions regarding any of those rights?
No.
You understand that you're giving up all of those rights, including those contained in paragraph 5 on that form, which are your trial rights. You understand that?
I do.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you in any way?
They have not.
You're doing this voluntarily and of your own free will?
I am, Your Honor.
All right. The court had previously been provided and has again been provided Pittsfield Township Department of Public Safety report for their case number 2414501. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Ma'am, I do have to advise you that if I accept your plea, if you commit a misconduct between the time of this plea and sentencing, that any sentence evaluation or any agreement regarding sentencing, the court would not be bound by. You understand that?
Absolutely.
All right. I also have to advise you that if you do that, you are also not entitled to withdraw your plea. You understand that, ma'am?
I do, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt to the defense counsel. Have I complied with the court rule? Would it be proper to accept this defendant's plea?
You are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed, I should say, and I need to ask counsel, were there any other promises, threats, or other inducements which led to this plea?
Not that I'm aware of, Your Honor.
None that I know of, Your Honor.
All right. Court will accept the defendant's plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th, 2025, at 12.
July 30th, 2025, 12 noon. Okay. And are they on? Yes, they are. All right, Ms. Miller, I'll ask you to, bond will continue. I'll ask you to wait on the line. We're going to put you into a breakout room with our probation department to start that intake process, okay?
All right, thank you, Your Honor.
Thank you.
Thank you, Your Honor. Thank you, Ms. Miller.
Court does call the case People versus Rick Artuso. 3 cases.
Good afternoon, Your Honor. May it please Honorable Court, urges on behalf of Rick Artuso.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Rick Artuso, and the case is ending in 1657 and 1656. State your name for the record, sir.
Rick Artuso.
Thank you. What are we doing?
Your Honor, there are felony matters that are pending at circuit court, which we're looking toward resolution of the case. I'm just suggest we adjourn this matter pending resolution of those cases.
And I did discuss Mr. Artuso's options with him. He stated to me he did not want to adjourn at this time, these 2 cases. However, there are no current offers. I would be requesting an adjournment to join to follow Mr. Burgess' case.
You've got other cases up there?
Yes,
sir.
Your Honor. Sorry.
Is that right?
Yes.
In circuit court?
Yes.
Okay, you understand the reason they're asking for the adjournment? I understand you don't want it, but you're not going to be going anywhere and they're trying to get all of your stuff resolved.
Oh, okay.
You follow that?
Yeah.
Okay. It makes sense to do that. Do we know when your other cases are set up in circuit?
The second.
Yeah, pre-trials on the second. Yep.
July 2nd. Okay. So that would be the same date I'd adjourn these, but those are going to be at 1:30. I'd be hearing them before then. So here's what I'm going to do, sir. And if we got to figure out scheduling wise how to do something different, I'm going to adjourn these to July 16th, 2025 at 9 a.m. And if we have to figure out something before then, we'll do that so that you can be heard. Okay?
Okay.
All right. Thank you.
Thank you, Your Honor.
Yeah.
I have not yet had one that is mine.
Okay. They are out of custody.
They're out. Oh, and now that I say that. I'll let you know what she says. Oh, here she is. She's doing now. Good afternoon, Melanie. You're in front of the Honorable J. Cedric Simpson of the 14th District Court of Washtenaw County, State of Michigan. We need your assistance with one matter this morning. Our number is 142.
I need you to hold on.
Okay, go ahead with that number. 1423. 1423. Okay, got that. One moment. Okay, and my name is Melanie with Language Line Solutions. I'll be your sign language interpreter, and your call may be monitored and quality assurance. And let's see. Who is the person I'm interpreting for?
We will.
Since we're on Zoom, it just keeps jumping back and forth between all the screens. So I just need to pin whatever screen we're on.
Yes, we're going to lock the podium. And
Okay.
would call the case of the People versus Orlania de la. Is that right? Not sure how they're doing. I know.
Christina Baragarian for the people.
Hold on. May I first of all have the interpreter sworn? Oh,
Can you raise your right hand, ma'am? Do you solemnly swear or affirm that you will interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into American Sign Language, and from American Sign Language into spoken English, in the manner not before the court, so help you God?
Yes.
council, state your appearances.
Christina Baragarian for the people.
Dan Garin on behalf of Miss De La Rosa.
And ma'am, if you could state your name.
And this is the interpreter speaking. Again, I'm not sure which person I'm interpreting for because it keeps jumping around on all of the screens. So I'm seeing like 5 different people.
Okay. We don't have it locked, I don't.
I have it locked on the podium, but the interpreter would need to pin.
All right. Madam Interpreter, I'm informed you would need to pin the courtroom.
Okay.
We have it locked on the podium.
Let me see. So is it the one that says 14A District Court? Or
What is our
screen name that I'm going to be pinning?
14A1 District Court? Yes, ma'am.
Okay, I do have that pin, but for some reason it's still jumping. Like right now I have whoever is at home with the glasses on.
Got it.
And their hair pulled back.
Okay.
Even though I don't have them pinned. They're the one I can't
actually,
see the District Court
the one that, do you see one that says 14A District Court bench?
Yeah.
Is she a speaker?
Just a second. Do you see that one, ma'am?
Are you asking the interpreter?
Yes.
Yes,
I'm asking you. That's the one that I think needs to be pinned.
I do have it pinned, but for some reason it is not the one showing up. I have it pinned,
Wow.
and when I go up, if I remove, it says I can remove. Let me try doing something else here. Hold on.
All right.
I'm closing. I had something on my screen saying something about breakout rooms, so I'm closing that out. Okay, it looks like I might be okay now. Let's give it another try. Let's go ahead.
Okay.
I was just apologizing to her. We're going to go ahead and try again.
All right. Could you ask her to state her name, please?
Orlina Madeira De La Rosa.
Thank you. What are we doing on this case today?
We will waive reading.
I'm here for the retail. Go ahead.
We will waive reading of the complaint and stand mute. But there is a resolution for pretrial, Your Honor.
And what is that resolution?
My client will be pleading guilty to retail fraud second degree. but under the prosecutor's deferred sentence program, and she has signed an advice of rights.
Ma'am, if you could please raise your right hand to be sworn. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? One moment, Madam Interpreter and Ms. De La Rosa. We're trying to get the interpreter pinned on our large screen a little bit larger for you.
Okay.
Won't we tell those two they need to shut off their monitors? We've got that. Make it a little bit easier here. De La Rosa, it's a court's understanding that you are going to be pleading to the charge of retail fraud, second degree.
Yes, I understand.
That is a misdemeanor punishable by up to 1 year in jail. A $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property taken. If that's greater than 2,000, that value would become the maximum fine. Do you understand that, ma'am?
I understand.
To that charge, how do you plead? Guilty or not guilty?
I don't know. I've never experienced this before. I guess I want to try to do probation.
Ma'am, the judge is asking if you plead guilty so that you can proceed to probation like your husband.
Oh, yes, guilty.
Okay. So that we're clear, you are pleading guilty to this charge, ma'am?
Yes, guilty.
You understand that by pleading guilty, you will not have a trial of any kind.
I understand.
You signed an advice of rights form today, is that correct?
Yes, I did today.
Do you have any questions regarding any of the rights on that form?
I just want to know about how long I will be on probation.
I cannot answer that, ma'am. As to the rights that are on the advice of rights form, do you have any questions?
No.
Please look at paragraph 5 on the podium. Those are your rights which are part of a trial. You understand you're giving up those rights as well as all the rights on that form.
I understand.
You understand that you're giving up your right of appeal of right.
Yes, I understand.
Are you on probation?
No,
Are you on parole?
no,
Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
no,
Has anybody threatened you or coerced you in any way to get you to plead?
no,
You're doing this voluntarily and of your own free will?
yes, I think so, yes.
And also because you believe that you're guilty of this offense?
Yes, yes, I did, yes.
I do have to advise you that if you commit misconduct between the time of this plea and the time that you're sentenced, you would not be able to withdraw your plea.
I understand.
And also, there would then be no guarantee that you would receive the prosecutor's deferred sentence.
Okay,
Ma'am, on November 20th, 2024, at the location of 7,000 East Michigan Avenue in Pittsfield Township, that being the Walmart store, did you come to the register to purchase items?
yes,
There are items that you were going to purchase that you skip scanned or did not run through the scanner.
correct.
And you knew that the items were not being scanned.
Some I paid for, some I didn't, yes.
The amount of the items that you did not pay for, that was in excess of $200.
Yes,
The store was open to the public at the time.
yes, it was open.
You did not have anybody's permission to take that property, did you?
No,
And the property that you took was property that Walmart had offered for sale?
what do you mean?
The,
Can you say that again?
the property that you took was property that Walmart was selling.
Oh, yes.
Counsel, are you aware of any other promises, threats, or any promises, threats, or other inducements that have led to this plea?
No, Your Honor.
And no, Your Honor.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation. Sentencing in this matter will be
July 30th, 2025 at 12 noon.
July 30th, 2025, 12 noon.
Okay,
Your Honor, I have a travel request.
She needs to go to New York.
Yes, Your Honor.
Is she going on July 3rd?
Exactly correct.
yes, Your Honor.
When will she be returning as opposed to the other defendant?
July 29th.
Okay. Defendant may travel to New York July 3rd through July 29th.
Thank you, Your Honor.
I will set the defendant's bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of weapons. There is at this time to be no use of alcohol, recreational marijuana, or any illegal drug. And she is not to enter any Walmart in the state of Michigan. Thank you.
Thank you, Your Honor.
All right, thank you. Madam Interpreter, thank you. Wonderful job. Do appreciate it.
Sorry about everything setting up at the beginning, but I'm glad it smoothed out. Thank you so much for using our services. Have a nice day.
Take care.
Bye.
Okay. All right. Court. Okay, well, I know what's going to happen this time. Court does call the case, People versus John Farrow.
Your Honor.
You're ready to start counsel, Your Honor.
I'll issue an order to show cause. Court does call the case, People versus Armani Denario. Denario,
Actually, Reed.
pardon? Oh, it is Reed.
Actually, wanted to.
Why did they do? Oh, yes. Armani Reed. Not checked in. Issue an order to show cause. Kristen Singleton.
Actually, wanted for the people.
Singleton, not here. Order to show cause. Herdarian Daphne Towns.
Special officer people.
It's an arraignment that they are due.
They are in Zoom.
Yes.
Hello,
Hello, what's your name, sir?
Adarian Townsville.
Sir, this is an arraignment. You are before the court on a 1-count misdemeanor complaint. You understand that, sir?
Yes.
That complaint alleges that on or about November 11th, 2020, at the location of 3825 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, it alleges that you did commit the offense of false pretenses, 200 or more, but less than 1,000. Do you understand the nature of that charge, sir?
Yes.
All right. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. Do you understand that, sir?
Yes.
All right. My first question to you, sir, is do you wish to be represented by an attorney?
Yes.
All right, this is a public defender. Yes.
Good afternoon, this is the public defender Lauren Perry on behalf of Mr. Stephanie Towns. We waive formal reading and stand mute to the charges, please.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. You're requesting an adjournment.
That's correct, yeah.
Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m.
Okay.
All right, Esteban.
Your Honor, in this case, the people are not requesting any monetary component to bond. We are only requesting standard bond conditions as well as a no contact order with a person named Geo, G as in George, E-O, last name Joy, J-O-Y.
Your Honor, I'd also request a personal bond. Mr. Stephanie Towns, any reason you need to have contact with this person?
No, I don't even know who that is. So.
All right.
And no objections to that, then.
Here's what I'll do. I will send his bond at a $5,000 personal recognizance. I'll order standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir?
Yes.
I will order that this time you are not to possess or consume any alcohol, recreational marijuana, or any illegal drugs. I'll order no contact with Geo Joy. All right, I'll leave it there. All right, thank you. We'll see you on the 2nd, sir.
All right, thank you.
Yeah. Court does call the case of People versus Isa Awad.
Echelon of people.
Good afternoon.
Good afternoon. All right, state your name, sir.
So,
All right. What are we doing on this?
well, we had 2 prior Zoom hearings on this. This is an animal cruelty case. And so I thought it would be best to have an in-person hearing. I don't have discovery. I know he wants to fight it. So I think I had said that before. So I know you're feeling too about see discovery first. But so either I would like to ask for, I guess, a final pretrial.
Okay, I can set a final pretrial and get this. So I'll set.
Yes, sir.
You understand that charge?
Yes, sir.
That's a misdemeanor punishable by up to 90 days in jail, a fine between $200 to $500. You understand that?
Yes, sir.
Okay, my first question for you is, do you want to be represented by an attorney?
No, sir.
Okay, so what are you going to do on this case?
I would like to pay the fine if I could.
Okay, you understand that this is a misdemeanor charge?
Yes, sir.
It carries potential jail time. It's unlikely, but it carries potential jail time.
Yes, sir, I understand. I generally don't ever do that.
Okay,
I've had the same insurance company.
I don't want you saying anything that admits to anything.
Okay.
Okay?
Yes, sir.
So do you want to be represented by an attorney?
Uh, no, sir, I just,
Okay,
no,
so
sir, I
what do
just,
you want me to, what do you want me to do, ma'am? What are you gonna do on this case?
could I please pay a fine and not go to jail?
Okay, look. You would have to plead guilty to this charge. Do you really want to do that right now?
Yes, sir. I was, yes, sir.
Okay, let me ask you this. Let's say there might be the possibility that if you have insurance, everything can work out and it can be beneficial. You may or may not owe anything.
Yes, sir.
So would you want an attorney to help you through that?
Yes, sir, if I can get it
Okay,
over with.
great. This is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Stewart, we would waive any formal reading, stand mute, ask for a PR bond as well as an adjourned pretrial date, please. Your Honor.
Defendant having waived for a reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to what date? July 2nd, I actually knew that, I thought. July 2nd, 2025, 9 a.m. Defendant's bonds, $5,000 personal recognizance bond, although under standard conditions, no assaultive behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. Okay, ma'am, so get in contact with your attorney. You have the public defender's office and they'll see what they can help you work out on this.
Yes, sir.
All right, fantastic.
Thank you, Your Honor. And Ms. Stewart, if you can call the main office for the public defenders and update or give a good phone number for you.
Do you have that number? I'm
Sure
not sure.
do.
I live in Monroe County.
You got something to write with?
Yes, sir.
Okay, it's area code 734
734
222
222
6970.
6970. And should I wait until tomorrow to call there?
No, call them today. Give them your name,
Okay.
give a good email and a good phone number.
Okay, thank you, sir.
Thank you. Have a great week. Well, not weekend, I guess it's not.
Thank you.
Like that day. Thank you. Court calls the case, People versus Nicholas Stemmel.
Ashley Lonnie for the people.
Arraignment, okay. Easier. What's your name, sir?
Nicholas Stemmel.
Right. Sir, you are before the court on a misdemeanor complaint that alleges that on or about September 25th, 2024, the location of 3825 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you did commit an assault and or assault and battery against a Reggie Harrell. Do you understand what you're charged with?
Yes, Your Honor.
All right. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. You understand that, sir?
Yes, Your Honor.
All right. First question I have for you, do you want to be represented by an attorney?
Yes, Your Honor.
Yeah, okay, fantastic. He was listening. This is a public defender case.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stimmel, who stands to my right, we'd waive any further reading, stand mute, ask for an adjourned pretrial date as well as a PR bond, please, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in this matter will be adjourned to July 2nd, 2025, 9 a.m. or as your invite indicates. Defendant's bond will be set in the amount of $5,000 personal recognizance bond, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon. You understand that, sir?
Yes, Your Honor.
There should be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Yes, Your Honor.
I'm also going to indicate you're not to have any contact with Reggie Harrell. You understand that?
Yes, Your Honor.
All right. Thank you. For close case, People versus Jim Valensky.
Yes.
It's you, sir?
Yes.
Come on up. Your name?
Jim Valensky.
All right, sir, you are before the court on a misdemeanor citation that alleges that on or about May 10th, 2025, at the location of East Ellsworth Road in Pittsfield Township, Washington County, State of Michigan, that you operated a motor vehicle without proper security and or insurance. You understand that, sir?
Yes, I do.
It's a misdemeanor punishable by up to 90 days in jail, a fine between $200 to $500. You understand that, sir?
Yes, sir.
All right. My first question for you, sir. Do you wish to be represented by an attorney?
No, sir.
Okay, what do you want to do on this?
I want to plead guilty and pay the fines, whatever is involved.
that really what you want to do?
Yes,
Let
sir.
me just say this. What if there were an opportunity that if you were to present certain documentation regarding now having insurance, this could all work out in a very different way where you might not have to pay a fine?
Well, I already have that information available.
Okay, so somebody has to help you through that process to be able to get that and to try to maybe work that out, right?
Correct.
So then I would ask you once again, do you wish to be represented by an attorney?
Yes, sir.
Thank you. This is the public defender.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Valensky, we waive further reading, stand mute, ask for an adjourned pretrial date as well as a PR bond, please.
Pending having waived formal reading, standing mute, court will enter not guilty plea. Pre-trial in this matter will be adjourned July 2nd, 2025, 9 a.m. Bond is set in the amount of $5,000 personal recognizance bond on order standard conditions, including no assault behavior or possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. All right, thank you.
Thank you,
Thank you,
Your
Your
Honor. 734-213-2064.
213?
Yes.
I think.
That's fine. Thank you.
French. Don't understand. That's kind of. Court does call the case People versus, is it Monai Williams?
People.
Monai Williams? No response. Bench warrant will issue for defendant's failure to appear to show cause. Bond is set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue. Court calls case People versus Tony Williams. Tony Williams, no response. I'll issue an order to show cause. Court calls case People versus Christopher Akron.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public
Oh, what is
Defender.
Nothing.
Sorry, I think I might have missed something. But I
You
do
did.
have- sorry, I forgot my name. Assistant Public Defender Natalie Pate on behalf of the client, Mr. Chris Akron, who is present via Zoom. Sir, can you please state your name for the court?
Chris Akron.
Thank you, Your Honor. So Mr. Akron has been diligently working to try to get proof and documentation that his vehicle junked by the place it was impounded by. He was told yesterday that the documentation or receipt of that he will probably be able to have by end of day today. That being said, I'm respectfully requesting a 2-ish week adjournment.
Matter will be adjourned to July 2nd, 2025, 9 a.m. All right, we'll get a chance to get that in and see what's up. All right, sir, thank you.
Thank you. Have a good day.
You too. Court calls case People versus Ronald Benson.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Benson, who should be present via Zoom.
Mr. Benson? Oh, I think that's him. Samsung might be him.
Yeah, it's me. Sir.
All right, what's your name?
Ronald Benson.
All right, very good.
Thank you, Your Honor. There is a resolution in this matter. Mr. Benson would be pleading to add a count 2 of allowing an ineligible person to drive. He did give me permission to sign the advice of rights form on his behalf after we reviewed it on the phone.
All right. And that's the offer.
Yeah, I just, Your Honor. So I moved to add count 2 of CL 257.326. Of course, if you accept that.
All right, very good. Mr. Benson, can you raise your right hand, please, sir?
Yes, sir.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record.
Ronald Benson.
Sir, this is court's understanding that you're going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days of jail, $100 fine plus court costs. You understand that?
Yes, sir.
Understanding that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed, or you had your attorney sign an advice of rights form on your behalf, correct?
Yes, sir.
You've gone through those rights?
Yes, I have.
Do you have any question regarding any of those rights?
No, sir.
You understand that you're waiving those rights, particularly your rights, your trial rights, which are contained in paragraph 5. You understand that?
Yes, I do.
All right. You understand also that you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of this offense?
Yes.
You understand, sir, that if I accept your plea and you create, there is some misconduct as defined by the Michigan court rules that occurs after the plea and before sentencing, that you would not be entitled to withdraw your plea and you would not, the court would not be bound by any sentence or evaluation of this case.
Yes, I understand.
All right. Sir, on May 13th, 2025, at the location of Ellsworth Road in Pittsfield Township, Washington County, State of Michigan, did you have custody or control of a motor vehicle?
Yes. No, I did not have no. No. Sorry about that. No, I didn't have no license to drive.
That's not what I asked you.
Did I
On
have
that
custody of
date
the
at
vehicle?
that location, did you have custody or control of a motor vehicle?
Yes.
Okay. And did you allow someone who was otherwise ineligible, maybe inclusive of yourself, to operate that motor vehicle?
Yes.
Counsel, first of all, have there been any pleas or have there been any promises, threats, or other inducements that have led to this plea that you're aware of?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2, count 1 is dismissed. Anything you want to say before I impose sentence, sir?
No, sir.
Fines and costs of $250, 90 days in jail, suspended. When can you pay the $250?
Can I get about a month to pay it?
July 31st. Okay,
No problem.
all right, thank you.
Thank you.
Court does call the case of the People versus Kia Berry.
Connor and Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate, on behalf of Ms. Berry, present via Zoom. Ma'am, can you please unmute and state your name for the record?
My name is Kia Berry.
Thank you.
Thank you, Your Honor. So unfortunately, well, Ms. Berry did take the test again. Unfortunately, she states to me that she missed it by 1 question, but she's getting very close and she states she is scheduled to retake it this afternoon. To that end, I request hopefully one last adjournment.
This was the written test?
Yes.
You missed it by 1?
Well, by 1. I'm getting so frustrated. By 1.
Why?
Well, the only time I can take it is on Wednesdays because that's their late days because I work and go to
Okay.
school. So, yeah. And it's hard to schedule and work, school, and everything. So I'm trying my best.
What question did you miss?
I can't remember. It's always different ones. And I try to remember, but I can't. I'm getting frustrated. I should know it by
Don't get
now.
frustrated. You're gonna get it done today?
I want to get it done today, yes.
All right, we're all rooting for you.
Thank you. I need all the rooting I can get.
Mr. Allen says you're gonna pass.
Well, then I know I'm gonna pass now. I know.
Okay. I'll adjourn this out to July 2nd, 2025, 9 a.m. Or as
All
you're
right, thank you
invited
so
to
much.
All right, thank you. Good luck to you.
Thank you.
Court calls the case. People versus Annalee Burgess.
Connor and Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate, on behalf of Ms. Burgess, who is present via Zoom.
Well,
She was earlier, she was texting me while on the Zoom call.
okay. You got her. Okay. All right, what are we doing?
Thank you, Your Honor. I'm requesting adjournment. So since we've last been here, Ms. Burgess did go to Rhode Island and those suspensions have been cleared. She does have a Secretary of State appointment here scheduled for next week. She does need to take the written and road test to her, in my understanding. She states, we're asking for a date sometime after July 4th. That is when she will have the funds available to pay for those tests.
Yeah, she better pass this. All right. July 16th, 2025, 9 a.m. Where's your invite indicates. Okay, ma'am?
Thank you so much.
Thank you. Court calls case. People versus Diamond Buyers.
Connor and Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lawrence County on behalf of Ms. Byers, excuse me. Ms. Byers, please state your name.
Yeah, she's not currently in Zoom, but she's been dropping in and out for a while.
Well. Given that she was here, Your Honor, I would request that the court consider just adjourning it out.
July 2nd, 2025.
Thank you, Your Honor.
9 a.m. Court calls case of the People versus Abdul Rahman Al Dahif.
Connor and Silver on behalf of Pittsfield Township.
This is a show cause without counsel.
This is already set for a show.
Yes.
Court failure to answer the citation. All right.
Issue a bench warrant for defendant's failure to appear. Bond 5,000. Give a 10% privilege. That warrant will issue immediately. Court calls case People versus Deontay Arnold.
Henry Solar, on behalf of Pittsfield Township.
That's a show. All right. He's not been arraigned on this. What's your name?
Deontay Arnold.
All right. So you are before the court.
I'll take his time.
Cool.
I'm gonna move to dismiss. Conduct does not violate the ordinance, so.
You have any objection to that?
Not at all, sir.
All right. Case is dismissed. Go home.
Thank you.
All right. Take care. He had a big old grin on his face when you said that.
He was a bit surprised.
Yes. Court calls the case People versus Jamari Bagwell.
Conrad Solar on behalf of Pittsfield Township.
Bagwell? No response. I'll issue an order to show cause. Court calls the cases of the People versus Mitchell Carr.
Conrad Solar on behalf of Pittsfield Township.
Fair ratings. Mitchell Carr, no response. I'll issue orders to show cause in both of them. Court does call the case of the People versus Melanie Olivero.
Conrad Solar on behalf of Pittsfield Township.
Well, when did the appearance come in?
Just yesterday.
And I don't have either one of them here. A notice was sent out for June 18th for today, but that was before the appearance.
Who filed an appearance, Your Honor? You don't?
Gregory Zalapowski? You know?
Yep, I'm familiar.
Okay. Since I have an appearance in there, I'll just adjourn this out. 7/2. 25:09 a.m. Court calls the cases of the People versus Derek Embry.
Conrad Solar on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Embry. I don't believe he's present in the courtroom. I don't know if he's on Zoom. I did attempt to contact him multiple times without a response. I don't have an explanation for it. For the record, I request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in each of these matters, 5,000. I'll give a 10% privilege. That warrant will issue immediately. There haven't been previous warrants. Court does call the cases of the People versus Christina Evans.
Conrad Solar on behalf of Pittsfield Township.
Good morning, good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Evans.
Christina Evans. No response.
Well, Your Honor, I did speak to Ms. Evans. She did state she appeared. She has tears in her eyes. I don't know why
She
she's not.
said what?
She said she would, I said,
That she would.
I misspoke. Yes, she said she would be here. I apologize. But I don't know why she's not here now. For the record, I'd request an adjournment.
Bench warrant, 5,000, 10%. Warrant will issue immediately in each of these matters. Court does call the case of the People versus Travis Gore.
Conrad Solar on behalf of Pittsfield Township.
Good
morning, Your
afternoon,
Honor.
Assistant
Good
Public
morning,
Defender
Your Honor.
Lauren
Good
Kearney on
morning.
behalf of Mr. Gore. Sorry, Mr. Gore, we're talking at the same time. State your name now, please.
My name's Travis Gore.
All right, thank you.
Your Honor, Mr. Schiller and I are in conversations regarding this matter.
How's it going? No, I'm kidding.
I'm very well.
It might end up going very well for Ms. Brady.
Yeah, it depends on how things proceed, but I request an adjournment. Mr. Schiller, I think is doing a little investigation on his end.
All right. How much time did you need to get that accomplished?
We have the 16th day.
Sure.
Thank you.
I'll adjourn this matter out to July 16th, 2025, 9 a.m. or as your invite indicates. All right. Thank you, Mr. Gore.
Thank you to all. God bless.
Court calls the case People versus Sequoia Jackson.
Conrad Silver on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren appearing on behalf of Miss Jackson. Miss Jackson, please
Oh, she is here.
state your name, Miss Jackson.
Sequoia Jackson.
Your Honor, Miss Jackson, we are requesting an adjournment of the pretrial ultimately. She has a Secretary of State appointment today at 4 p.m.
Really?
Yeah, I tried to go earlier this morning, but they didn't let me to my appointment time.
You're right, like they didn't let me. So I'm all right. All right. So she has an appointment this afternoon. So I'll adjourn this to July 2nd, 2025, 9 a.m. Or as your invite indicates. All right. Thank you, Ms. Jackson.
Thank you. Have a good day, sir.
You do the same. Court calls the case People versus Jaden Kendrick.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender, Mr. Kendrick, who may be present via Zoom.
Yes, I think he's about to appear.
Yep,
Okay, state your name.
Jaden Kendrick.
All right.
So I'm requesting an adjournment. The numbers I still have in the file from Mr. Kendrick are bad, but I was able to email him. So Mr. Kendrick, could you please either respond to that email if you got it or call up to the public defender's office to give the most up-to-date number for you?
I did not get the email or any of the things, but I do have my license now, and I wanted to pay whatever fines. I just want to get it over with.
Well, hold on a second. That may not be the way it works. You got to talk with your attorney first.
Okay, yeah. Could I receive a new email or another text?
You didn't get the email?
I got the email for this Zoom, but I've been looking for anything else, and there was nothing else.
Okay. Do this. There's another email that they sent you, but you said you didn't get that one.
No, I do not believe so, sir.
Okay, so you might want to check your spam folder just in case that happened. But do this because this can work out for you. You got the main number for the public defender's office?
Could I receive that?
Well, let me give it to you. You got something to write with or somebody to put it?
Ready right now.
You ready?
Yep.
Okay, 734-222-6970.
All right.
Okay, get in touch with them. Make sure that you do, young man, so that they can explain all your options. We can get this taken care of next time, okay?
All right. Thank you so much. Have a wonderful day.
Not a problem. July 2nd, 2025, 9 a.m. or as your invite indicates. All right, call them right away and get that number in.
Got it.
Okay, take care.
You as well.
Court calls the case People versus Kayla Keys.
Conrad Silver on behalf of Pittsfield Township.
The public defender has paid for Ms. Keys, who gave the authority to accept the offer on her behalf.
So, Your Honor, I move that in case 0422. 0422 at count 2 double parking. And if you accept the admission to double parking, I move to dismiss the original charge. As well, case 0423 will be dismissed.
Got it. And Ms. Pate, do you have authority to admit responsibility on behalf of your client?
Yes, Your Honor.
And you do so admitting responsibility on February 29th, 2023, Ellsworth Road in Pittsfield Township, that they double parked a motor vehicle.
Yes, Your Honor.
All right, court will accept that admission to count 2 in case 0422, count 1 in that case being dismissed, and case ending in 0423 is dismissed. Fines and cost of $180.
You're asking
That be
for-
paid.
Sorry, Your Honor, you're asking for 2 months on this case.
2 months?
Yes, Your Honor.
Kate's pushing it. I know, I see my new calendar. It's very colorful, but I don't know what it means. August 29th.
Thank you, Your Honor.
Court calls the case People versus Anthony Lafredo.
Conrad Siller on behalf of Fiscal Township.
Assistant Public Defender Natalie Pate for Mr. Lopero, made by the DSA.
Nope.
Your Honor, similar to another case, I was successfully able to send him an email, but I did not hear back. So I guess maybe he didn't get it. All the numbers I did have for him were not in service. So I do not have an explanation for his failure to appear and would respectfully request an adjournment for the record.
Bench warrant will issue bond 5,000, 10%. Warrant will issue immediately. Court calls the case People versus Hassan, Missouri.
Conrad Siller on behalf of Fiscal Township.
Assistant Public Defender Natalie Pate from Mr. Missouri, who gave me permission to accept the offer on his behalf.
So Your Honor, move that count 2 of double parking. If you accept the admission, move to dismiss the original charge.
Ms. Pate, you admit responsibility to the fact that on April 24th, 2025, at a location in Pittsfield Township, specifically Clover Lane Drive, that they double parked a motor vehicle.
Yes, Your Honor.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can that be paid?
Candidly, he wanted to pay it yesterday, but I told him he had to wait till after the hearing, so that I would ask for 1 week just to make sure. he had it.
All right, real good. I'll just pay it by June 30th.
Thank you, Your Honor.
Shouldn't let him pay it. We couldn't have taken it, but he could have paid it. Court calls case People versus Demarius Munoz.
Conrad Siller on behalf of Fiscal Township.
Assistant Public Defender Natalie Pate with on behalf of Ms. Munoz, who is present via Zoom.
It's me.
Can you please unmute and state your name for the record?
Damaris Monreal Munoz.
Thank you, Your Honor. I believe at the last pre-trial, I stated that that would probably be my last request for an adjournment. I am asking for one last one. Since the last pre-trial, I've also had communication again with my client's brother, and he has some documentation is going to be helping my client with what she needs to do to take advantage of this potential offer. So I would be respectfully requesting a couple weeks at this time.
All right. Without objection, July 2nd, 2025, 9 a.m. Where's your invite indicate? All right, thank you, ma'am.
Thank you.
Court calls the cases of the People versus Ruth Jones.
Conrad Siller on behalf of Fiscal Township.
Your Honor, the official copies without counsel.
There's show causes.
So Your Honor, these are duplicate cases.
They are.
So I would like to dismiss the earlier case. That would be 241-1667.
All right. And that case is dismissed. All right. And then on the other case, this, you said this was a show cause?
Yes.
So, not being here, I'll issue a bench warrant. The defendant's failure to appear found 5,000, 10%. Court calls the case People versus Tanisha Moore.
Conrad Siller on behalf of Fiscal Township.
This is also.
It's also a show cause?
Yes.
Yes, it is. I see that. Tanisha Moore, no response, bench warrant 5,000, 10%. That warrant will issue immediately. Court calls the case of the People versus Dion Chapman.
Conrad Siller on behalf of Fiscal Township.
This is an arraignment pretrial.
Yeah.
Dion Chapman, no response, issue an order to show cause. Court does call the case of the People versus Ryan Gouch.
Conrad Siller on behalf of Fiscal Township.
Hello, what's your name?
Ryan Ghosh.
Gouch.
Okay, sorry about the mispronouncing. In there. All right, sir. Oh, I see. All right. He's got some information here. All right, sir. I don't know what they did at the first one, but it's obvious you haven't been arraigned on this, so let me arraign you on this, okay? You are before the court on a misdemeanor citation that alleges that on or about May 11th, 2025, at the location of South State Street, South State Road, actually, in Pittsfield Township, Washtenaw County, State of Michigan, that you operated a motor vehicle with improper plate or registration. You understand that charge, sir?
Yes, sir.
All right. That's a misdemeanor. It is punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, sir.
All right. First question I have for you is you want to be represented by an attorney?
Well, I was just,
No, here's what I'm going to do. I'm going to try to do it my own way, and then everything's going to get messed up. No, I'm sorry. Go ahead. What were you going to say?
I was wondering if you saw the evidence that was presented, my father dropped off.
I did see some things in the file.
Okay.
All right.
I have a letter from the Secretary of State if you would like me to present it.
That wouldn't be what would happen at this point.
Okay.
I'm going to need a plea entered. Let me ask you this, sir. Do you want to be represented by an attorney to help you just get this straight? I see what's in there and I understand kind of where you're headed, but I can't help you do that.
Yes.
So you want to be represented by an attorney?
Yes.
Thank you. PD case. It may be able to be done in short order. You know, let me do this. So this is a public defender case, but I've seen some of the evidence that's in the file. I don't know what he has as a letter in there. But what I'm gonna do, he's down here. He doesn't want to drive from Saline again because that's a long way. So before you enter your appearance, you're waiving formal reading, your client standing mute.
Yes, Your Honor, Assistant Public
Defendant
Defender
has to
Natalie
waive formal reading, standing mute, court will enter a not guilty plea. Because of kind of what I've seen, but I can't help him. I don't know what letter he has. I'm gonna pass the matter and maybe you can take a look at what he has and this can maybe get resolved today.
Awesome.
Give
Thank
it a
you.
shot. I can't guarantee that's what happened, but give it a shot because he was trying to do it himself.
Absolutely.
And I'm looking at him, he would have blown it. No. So I'll pass it. I'm about to finish up this block and then let them talk to you. Okay, sir? Thank you.
Thank you.
Court calls the case People versus Giovanni Benitez Flores. I see here. I need a Spanish interpreter.
Yes. Good afternoon, Charlie. Are we set to proceed?
I'm ready to proceed. Good afternoon, Ms. Quelling.
Thank you. Can you please raise your right hand? Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and translate from English into Spanish and from Spanish into English in the manner not before the court to help you God?
I do.
Thank you.
And good afternoon, Charlie. How are you, sir?
Good afternoon. I'm doing great. Thanks for asking, Your Honor.
You may have up just a slight bit. All right. The court does call the case of the People versus Giovanni Benitez Flores.
Este Tribunal de Justicia hace el llamado del caso en contra del señor Giovanni Benítez Flores.
Conrad Siller for Pittsfield Township.
Representando el gobierno de Pittsfield Township, tenemos al señor Conrad Siller.
Lauren Perny on behalf of Mr. Benitez Flores.
Representando al señor Benítez Flores, tenemos a la señorita Lauren Perny.
Say your name, sir.
Diga su nombre.
Giovanni
señor.
Benítez.
Giovanni Benítez.
Your Honor, we're requesting an adjournment.
Su señoría, dice la señorita Perny, que estamos solicitando en este momento un aplazamiento del caso.
I had a bad number for my client, however, I got an updated number today.
Resulta que tenía un número telefónico equivocado para mi cliente, pero ya me lo pudieron dar correcto el día de hoy.
I will adjourn it to July 16th, 2025, 9 a.m.
Dice el señor juez que se dispone entonces a posponer este caso para el día 16 de julio de 2025 a las 9 a.m.
Thank you.
Gracias.
Thank you. All right. Charlie, always a pleasure. Do appreciate it, sir.
Absolutely, Your Honor. Thank you very much.
All right. You take care.
Okay, thank you.
That was what?
That was 1 o'clock. We just have 2 o'clock left, Your Honor.
Is there 2 o'clock left?
Yep.
We're back in stride.
I was about to take a break. Who are you?
You're on Tanya Hall, and I was supposed to be seen yesterday at 14, but I was in the hospital and I just got out today.
Well, I don't know.
So they told me to come down.
Hold on. Who's your attorney?
I don't even know.
You have her, Miss Fairney?
It looks like we withdrew due to a conflict, and I'm trying to see if trying to see if it says who's been appointed, but I don't see that in, nope, I don't see it in my, Robert Killwall.
Okay, was there a bench warrant issue? I don't recall.
There's a long note. It does say she sent yesterday. No, this note is from last week.
Okay.
All right, I'll let them pull it up. We'll try to figure something out for you, man. Court's gonna stand in recess.
All right. Maybe see it.
So your first meeting?
T-A-M-I-A.
T-A-M-I-A?
T-A-N-Y-A.
Yeah, that doesn't sound so
I have the case number.
What's the case number, Lauren?
21 FB 1472. Okay.
21 FB, you said?
Yeah, 21 FB 1472.
So I show she's actually on for July 3rd for a probable cause conference. Trying to see if your other cases.
Oh, you're right, this is July 3rd.
Do you have the middle name, ma'am?
No, ma'am.
Yeah, you're not scheduled until July 3rd.
Okay, I'm supposed to be here today?
You are not supposed to be here today, and you were not supposed to be here yesterday. I don't show that you missed a hearing.
Well, I think I'm supposed to be in.
Community corrections?
Yeah, and I went to community corrections and they told me to come here.
So you were arraigned on June 5th, and it was today the first day you went to see community corrections?
No, second day, the second time.
It looks like
I'm supposed to drop and I don't have the money to drop and they said it would be to come here and maybe the judge will wait.
Oh,
Yeah.
That's not accurate information.
It says on the 13th, she's going to do testing. They passed the matter, so she went to community corrections and it was recalled an hour later.
I remember you now. Okay.
Paying of the funds. She has to go back to.
14A District Court for County of Washington, State of Michigan, is now back in session. Judge J. Cedric Simpson presides.
May be seated. This is my recall. Court recalls the case People versus Ryan Couch.
Conrad Solar on behalf of.
Public Defender Natalie Pate for Mr. Gouch, who, Your Honor, Mr. Siller and I have discussed this matter, and Mr. Siller stated he would be dismissing this case.
That's right, Your Honor. I reviewed the documentation. I'm going to move this case.
It's certainly no objection to that, Your Honor.
And he left.
He did.
Okay.
But his dad did stay.
Yes.
Oh, his dad?
Stay, so, yes.
So the defendant left, dad stayed.
Dad stayed to make sure everything was
Just
good.
made sure everything, that's just like a kid. They just walk out, parents are left to clean it up. But anyway, thank you for staying, sir. This case is dismissed on prosecution.
Thank you, Your Honor.
Thank you. Take care. Court does call the case, People versus Daniel Nuggle.
Conrad Siller on behalf of Pittsburgh.
I'm here, sir. Good afternoon, Your Honor. For the record, Brendan Dabalski appearing on behalf of Daniel Nago, who's present via Zoom. Your Honor, today is the date and time set for a pretrial in this matter. That being said, I've spoken to Mr. Siller and he's indicated that he's willing to offer my client operating while visibly impaired, which he would like to accept. Is that correct, Mr. Nago?
Yes, sir. That is correct, Your Honor. So I moved at count 2 of operating while visibly impaired. If you accept that guilty plea, I move to dismiss the original charge.
Yes, sir.
All right. All right, sir, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name again for the record, please.
Daniel Nagel.
All right. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court cost. The court could order community service or any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, sir.
Understanding that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
All right. Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty?
Yes, sir.
January 2nd, 2025, at the location of Michigan Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
Do you recall what you had and how much?
Well, I don't know. I mean, a couple drinks. I had whiskey at
Okay.
home.
Were you stopped by the police or was there an accident?
I was stopped by the police, sir.
Why'd they stop you?
I was told that it was because they had a call placed.
Okay. A call placed that talked about some erratic driving on your part?
Yes, sir.
Are you disputing the right of the police in this instance to stop you?
No, sir.
All right. Were you arrested?
Yes, sir.
Were you taken to the hospital for a blood draw?
Yes, sir.
All right. Do you recall what the results of that blood draw were?
I'm not positive.
Results were
312, Your Honor.
121, Your Honor.
121?
Yes.
All right. Sir, do you have any reason to dispute those blood test results?
No, sir.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
All right.
Sir, you understand that if I accept your plea and you commit a misconduct as defined by the Michigan court rules prior to sentencing, that any agreement or evaluation of your case regarding sentencing would no longer bind the court to any particular sentence. You understand that, sir?
Yes, sir.
You also understand that if you commit misconduct, you would not be entitled to set aside your plea in this case.
Yes, sir.
All right. Counsel, are you aware of any promises, threats, or other inducements that have led to this plea other than anything that's been said on the record?
No,
Your
Your
Honor.
Honor.
All right. And counsel, have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
July 30th, 2025 at 12 noon.
July 30th, 2025. What time? 12? 12 noon. All right.
Thank you, Your Honor.
Bond will continue. Sir, I'll need you to hang
Yes, sir.
on the line. I'm going to put you into a breakout room with our probation intake so we can get this process started, okay?
Okay.
All right, thank you.
Thank you, Your Honor.
Thank you.
Oh, my goodness.
I just. Well, I was coming to promote, I'm the AGM of DWC, and I seen that I got an order from the dog back a month ago. I see that you guys might do some catering. And I'd love to cook for you.
Come here. No,
Make
no.
nice and right for you.
Come right up to the podium.
So, yeah.
State your name. No, right.
Oh.
He'll take you
Just
down.
be Murdoch.
How are you doing?
I'm wonderful.
Are you?
Yeah.
So you came up here, why?
Well, something put it on my heart. Well, my boss, he was like, I want you to promote, DWC. And I was like, okay. Some said, go to the jail. This was a part of my life for 20 years. And I changed my life. 4 years not to drink and 4 years no trouble. So
You kidding me?
yeah,
4 years?
4 years next month.
God,
Not a slip or dip.
God bless you.
Yeah, no. So God has truly been good.
I remember when we first met.
And what? My cocky self. And you got me together.
What?
I was cocky.
You think you were?
No, I know.
How'd that work out with you and me?
You nothing to play with.
What?
You know that. Well, everybody know that.
What did I do?
Nothing. You put me in my place.
I did that?
Well, you have to. You have a job to do, right? You have a job to do.
Well, I have a job to do, and you just thought you knew better than me, right?
No, you do your job better than anybody can do.
Well, thank you for saying that. But you thought you knew better than me.
But no, I was cocky because I just recently got sober at that time. And I don't even remember the incident that happened, So I was cocky.
But you're doing well.
Man, so good. My brother passed on Memorial Day. He was 50.
I'm sorry.
But I'm able to be here for his kids in a present mind where nobody else is sober like me. So, yeah.
That's fantastic.
Thanks.
Yeah,
Jeff.
let her come on. You better be
What's
careful
up?
because he.
Mr. Allen, know me real well. Thank you.
All right.
Allen. I used to flirt with him even though I was gay. Nice looking and something to look at.
Oh, wow. Man. All I know. That was a classic.
You never know what it's gonna happen.
I just hope Felicia was tuned in. You have to send her a tape of that. All right.
I do this for
You know, You know, I'll be honest with you. I didn't know what to expect. That I didn't. I just didn't expect that.
Or Mr. Allen.
I feel
He's
too bad
being
for him.
objectified all the time. And he'll get them.
Courthouse case, people versus James Raggett.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Senator Lauren Kearney on behalf of Mr. Raggett. Mr. Raggett, please state your name for the record and turn on your camera.
James Patrick. Thank you, sir.
Your Honor, today's pretrial. I'm requesting adjournment. Mr. Raggett is going to be doing an alcohol assessment, and that will give us a little bit insight into a possible reduction.
Oh, okay.
Were you able to contact them, Mr. Raggett?
I just know. I did get the link that you sent, but I haven't had a chance. Oh, did you hear him?
No.
Or no? You're breaking up there a little bit, sir. What were you saying?
Oh, it seems like he took out his headphones.
Can you hear me now? Yeah, we can hear you a little bit better. Go ahead. The question was, were you able to get, I think, the assessment set up? Is that what you were talking?
Correct, yes, Your Honor, thank you.
Oh, can you hear us, Mr. Raggett? I don't think he can hear us. Well, here's what I'll do. I'll adjourn it out to July 16th, 2025 at 9 a.m. and then I'll let you, that should give you enough time.
Yeah, whether he did it or not, it's still gonna take a while to get back, so, thank you, Your Honor.
All right. Thank you, Mr. Raggett.
Thank
Bond
you.
continued. Court calls the case People versus Kent Robinson.
Conrad Siller on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Robinson, who is present via Zoom.
Yes, he is.
Sir, can you please state your name for the court?
Kent Robinson.
Thank you, sir.
Thank you, Your Honor. I have discussed this matter with my client, and we're asking for an adjournment so that he can make and keep an appointment with the Secretary of State. He thinks he has an idea generally of what he needs to do, but he still needs to make that appointment.
July 17th, or 16th, I'm sorry, July 16th, 2025, 9 a.m. Where's your invite indicated?
Thank you, Your Honor.
Thank you.
Thank you, Mr. Robinson.
Okay.
Make sure to update me with how the appointment goes. You're all set for today.
Thank you. Have a good one.
You too.
You do the same. Court calls the case of the People versus Posey Smith.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Smith. Mr. Smith, please state your name for the record.
Boise Smith.
So, Your Honor, today, Mr. Smith has been trying very hard to get his license. However, it has not come to fruition. Secretary of State just dragged his feet. So he is going to resolve it today, however, with 257.326. So he'll have to keep having to follow every couple of weeks.
So, Your Honor, that is correct. So I move to add count 2 of MCL 257.326. If you accept that guilty plea, I will dismiss the charge.
All right, very good. Sir, please raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
All right. State your name again for the record, please.
Boise Smith.
All right. You can put your hand down. Sir, it is this court's understanding that you're going to be pleading guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail and a $100 fine plus court costs. You understand that?
I do.
And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind?
I do.
All right. because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand all of that, sir?
Yes, sir. According to the court rules, I do.
All right. And you went through an advice of rights form with your attorney?
I have.
All right. Did you have any question regarding any of those rights?
No, Your Honor.
And you understand that you're waiving those rights you went through?
Yes, Your Honor.
All right. You understand you're giving up your right to appeal of right?
Yes, Your Honor.
All right. Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Voluntarily of my own free will.
Okay, that was my next question. And also, that's how you know you've been here too much.
You gonna put me on blast like
that? And also because you believe that you're guilty of this offense?
Yes, Your Honor.
All right. On the date, February 24th, 2023, location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan. Did you have custody or control of a motor vehicle?
Yes, Your Honor.
All right. Did you allow someone who was otherwise ineligible to operate that motor vehicle?
I did, Your Honor.
All right. And sir, I do have to advise you that if you do, I'll be sentencing you today, so it really doesn't matter, but that if you commit a misconduct between the time of this plea and the time of sentencing, that you would not be entitled to rely upon any recommendation or evaluation regarding your case. You understand, for purposes of sentencing, you understand that, sir?
Yes, Your Honor.
And you also understand that if you commit that misconduct, you could not withdraw your plea. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements that led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Satisfied, Your Honor.
All right, court will accept the defendant's plea to count two. Count one is dismissed. Sir, anything you or your attorney want to say before I impose sentence?
No, Your Honor.
All right. Fines and costs of $250, and I'll suspend 90 days in jail. When can you pay the $250?
I can start making payments by next month. I don't want to so much obligate myself to a particular fee starting next month, but I will be able to make at least a $30 down payment on that ticket, and whatever extra money I get.
How long do you think it's going to take you to pay this, Mr. Smith?
I'll say about 2-3 months.
2 or 3 months?
Yes.
All right, here's what I'm going to do. Get it paid by September 30th. Okay?
Yes, Your Honor.
All right. Thank you, folks. You
All
take
right,
care of
thank you, Your
yourself,
Honor.
so have a good weekend.
You too. Happy Father's Day.
Thank you, sir.
You're welcome.
Court calls the case, Huber versus Kevin Stevens.
Conrad Siller on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Stevenson. Mr. Stevenson, please state your name for the record.
That was, she didn't know if he was there or not. That was a hopeful, please state your name.
No, I talked to Mr. Stevenson yesterday. We
Did you?
have a resolution. Yeah, you sound like you didn't believe me.
Whoa. I didn't say I didn't believe you.
Okay.
I just was reiterating what you said. I don't know how you talk to these people like yesterday and then they don't show up. I'm not sure what's going on in that conversation, but go ahead.
frankly, I don't know either, Judge. I don't know why he's here. I did provide the Zoom information, and again, we did have, well, actually, he tried to log on yesterday. He texted me that he was waiting in the Zoom hearing at like
24 hours.
2 p.m. And then I told him it was for 6, so
So you think that saves the bench warrant?
maybe, well, it depends on.
Nope. Go ahead. I understand, but we'll figure out, I don't know where he would be. Bench warrant will issue bond 5,000, 10% privilege. Those warrants will issue immediately. Go along. The other ones he had. Court does call the case of the people versus Nicholas Stocker.
Conrad Sullivan on behalf of Pittsfield Township.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mr. Stalker. Mr. Stalker, please state your name for the record.
You have to unmute, sir.
Oh, sorry about that. Nicholas Anthony Stocker.
All right.
So Your Honor, Mr. Stalker was in bench warrant status for a while. I think because of that, we may have old contact information for you, Mr. Stalker. I attempted to call and email a few numbers, but we obviously did not make contact. So what I ask you to do is call the public defender's office and update your number.
Okay, definitely. I can do that.
All right. I'll adjourn. I'll adjourn this to July 2nd, 2025, 9 a.m. All right. Thank you,
Okay,
sir.
thank you.
Court does call the case, people versus Elizabeth Raggett.
Conrad Sullivan on behalf of Pittsfield Township.
Is that you? Come on up. It's your case. No. This is an arraignment. All right. Hello.
Hi, thank you for letting me go to my son's graduation last week. Or you let me, thank you.
You're welcome. How was it?
It was good.
Uh-oh. You all right?
Not ideal.
All right. State your name again, please.
Elizabeth Raggett.
All right. All right, I have to give you I have to arraign you on these charges. You're before the court on a misdemeanor complaint that alleges that on or about March 27th, 2025, at the location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan, that you operated a motor vehicle with a high VAC. You understand that charge?
I understand.
All right. That is a misdemeanor. It's punishable by up to 180 days incarceration, a $200 to $700 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services.
I
Understand all of that?
I understand.
All right. My first question to you is, do you wish to be represented by an attorney?
I do. Yes, please.
All right. This is a public defender case.
Good afternoon, Assistant Public Defender Lauren Penny on behalf of Mrs. Raggett. We waive any further reading, stand mute to the charges, and ask for a new pretrial date, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial on this matter will be adjourned to July 2nd, 2025, 9 a.m. or as your invite indicates. Alleged BAC in this matter.
Your Honor, it's a search warrant, .191. There was a crash. Excuse me. Vehicle.
Ms. Parody, is there anything you want to say on behalf of your client?
Your Honor, I'd request a personal bond standard conditions and drug and alcohol testing. If I may, Your Honor.
I'm not driving at all. I'm not. That's fine. Do you have a preference? To anything but.
No, it's gotta be this one.
On your ankle.
No, we'll do it.
I can blow into something.
So my client did indicate that she's not driving at all at this time. She would prefer a SoberLink device if that's amenable to the court.
But then I could still, like, if I wanted to swim or something. Okay, sorry.
I'd set the defendant's bond at a $20,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possessions of any weapons or anything fashioned to be a weapon. You understand that?
I understand.
I'm also going to order that there's to be no possession or consumption of any alcohol, recreational marijuana, or any illegal drug. I will order that you report over to Community Corrections for placement on a SoberLink testing device. All right, and I've signed that order. All right.
Thank you.
Thank you.
Thank you.
Take care.
Okay, I'm gonna ask you for your phone number. Okay.
Court does call the case People versus Xavier Ruffin.
Conrad Soler on behalf of Pittsfield Township.
Which one's?
They're both on, they're both.
Sorry. I'm so.
Well, I have four. When you say,
I'm so sorry.
Sorry.
Got it.
When should I look?
Xavier Ruffin, no response. Bench warrants will issue for defendant's failure to appear. Bond will be $5,000, 10% in each of these cases. Those warrants will issue immediately. Court does call the case of People versus Sidney Wack.
Conrad Soler on behalf of Pittsfield Township.
This is an arrangement.
Sidney Wack, no response. I'll issue an order to show cause. The court calls the case of the People versus Brandon Wingate.
I'm a regular over at the Try Watch Clips channel where you go for clips of your favorite judges
I'll issue an order to show cause for defendant's failure.
and your favorite trials
That's all we have.
and your favorite cases.